morning, everybody. If I can just commence by the usual wholly under the health and safety legislation that the doors through which you entered are the evacuation doors if we have an emergency, fire or earthquake, and if we do, we gather outside the straight sail house. Those doors are the same doors for where toilet facilities are available. And otherwise, I'd ask everybody to just ensure their phones turned off, if you would. And the other preliminary matter that I just wanted to raise was Ms. Sefton, overnight I had a chance of just looking at that Canyon Vineyard High Court case, which you referred to in paragraph 13 of your submissions, as authority for the proposition that to maintain means to protect, which in turn means to keep safe from harm or injury. Now, there are two aspects to that paragraph. One meaning to maintain means to protect, and then the second in turn means to keep safe from harm or injury. When you look at that decision and the paragraphs that the paragraph 125 that you drew our attention to, I'm struggling to reach an accord with you in terms of the conclusion you've reached about that. I invite you to reconsider that because it is important, and if you could do so and address that in your reply,
yes.
And because it's unhappily worded, if one's got to be very careful about why one talks about High Court judges, but in essence, the paragraph that you drew our attention to refers to counsel's submissions, which is an unusual way of leaving a rather important issue of law, and just says, I conclude that the weight of recent authority supports Bendigo's submissions as summarised in paragraphs 121 to 122. It's confusing because the next two paragraphs, 123 to 124, address a different case, the Port Otago case, where the actual issue involved was actually around the word protect. So it wasn't really a discussion of maintain, but that gets confused because in paragraph 123, the judge says, I note despite Bendigo's submission to the contrary, Port Otago does appear to provide a definition of maintain at paragraph 42, although it is correct that what was indeed an issue there was indeed the meaning of protect.
Yes.
So it is, I appreciate there's not an easy sequence of thought processes in the way in which that's dealt with in that case, but I'd like you to reconsider your position, because Absolutely. At the moment, on first blush look at it, I'm not persuaded that your paragraph 13 is accurate in really either of those two respects. So you could address that in your reply.
Yes, and I was concerned yesterday when Commissioner Cubitt said that Council appeared to be submitting that the Section 31 GA matter was elevated to a matter of national importance per our submission. And so I had intended on addressing that. Obviously, it is quite different, 30, the obligation in 31 GA and Section 6. And I can understand, well, from the recent case law, and obviously the case I've cited wasn't the best authority, but the obligation in 31 GA in the case law of, and I will articulate better in the closing submissions, does usually conflate maintenance and protect as being on the same footing, but that in my submission didn't elevate the maintenance of biodiversity in general to a Section 6 matter of national importance, but I can see how that logic appears to flow through.
Well, it's understandable that Mr. Cubitt expressed that concern, because it certainly is a concern I share that if one looks at Section 6C, it's talking about protect. One looks at the function under Section 30, it's maintain. So one's apparently in the statute at a higher level than the other, which is what you would expect for significant natural areas as contrasted with other biodiversity.
Yes.
And that was the concern Mr. Cubitt was expressing, certainly one I shared. It appeared to be responded to in the paragraph 13, but when you drill down and have a look at those cases, I don't think the that they support the proposition you make. So we look forward to you responding to that in detail. But in the meantime, can I trouble you to send a link to Kate, if you could, please, in relation to the case that's referred to by the judge, the Port Otago case, which
is that Otago Regional Council in Port Otago?
it's well, I just need to go to where she discussed that, which I think was Port Otago versus Dunedin City Council, and Environment Court decision. So it's at paragraph at your footnote 30, 35. But hold on. Well, that's strange. You've got in your footnote 35 above note 38. So quite rare. If you can track it down amongst your footnotes and make sure you get the reference to Kate, but also if you could send her a copy of it so we can get it printed out. I'd like to have a printed copy today to take home if I can.
Yes.
All right. Not sure where you'll find the reference to that in your footnotes. But if you start at your footnotes 32 and 35, possibly that reference to 38 is supposed to be 28, is it possibly? No, it's not helpful.
That's okay. I will find it.
You'll find
it?
Good. Right. Thank you very much. Right. So that legalese out of the way, and we turn to Ernst Law 1. Anybody
Online.
Online. Right.
Morena, can you hear me?
We can hear you, but we can't see you at the moment, I suppose.
I'm not too sure why you haven't got video of me. I've certainly enabled that here. Are you okay for me to proceed without a picture of me?
Well, you're dealing with somebody who's IT challenged, and so I can't help it, and we just simply will have to proceed on that basis.
Okay, I beg your pardon. Right, well, Morena koutou, my name is Lynette Beisch, and I'm appearing for Ernst Law 1. Ernst Law 1 is a production forestry company operating in Otago and throughout New Zealand. The scope of my submission is to provide planning evidence, and I confirm that I'm familiar with the Code of Conduct for Expert Witnesses and that my evidence is within my scope of expertise. I refer the panel to para 40 of my evidence if you have it before you. This is where I begin to comment on the ecosystems and biodiversity chapter. And I have addressed matters concerning the mapping of SNAs, methods of protection of Indigenous vegetation and SNAs, and the management of wilding conifers within that chapter. So turning first to the mapping, I have to agree where other submitters have raised concerns with the potential for the spatial extent of SNA mapping to be somewhat vast. However, I understand from reading the joint witness statement for the AP2 criteria that experts have agreed some guidance would be appropriate for interpretation of that criteria. So that is good to know. And the panel may wish to consider whether that guidance could extend to include some standards applying to mapping of SNAs. For instance, indicating what level of ground truthing would be appropriate with mapped evidence for proposed SNAs, appropriate resolution, whether aerial photography would be appropriate, perhaps triangulated with land use mapping tools. And I understand that you've traversed with other submitters the pros and cons of relying on LCDB and mapping layers such as that. But my submission sets out that processes around identification and mapping of SNAs must necessarily include verification of such areas through robust engagement. Such engagement is squarely within the domain of plan rather than policy making. But the RPS provides direction for how those processes may play out and what the net result would look like. So I consider that method ECO M1 is a critical provision in this regard. So now focusing on methods, method ECO M1 is essentially a statement of responsibilities, and it provides direction to regional and territorial authorities with respect to ecosystems and biodiversity and their particular scope of jurisdiction with that topic area. And I consider it as relevant to this method to note that land use activities associated with plantation forestry are already regulated. The National Environmental Standard for Plantation Forestry contains provisions to ensure that clearance of Indigenous vegetation is minimised and that thresholds are not exceeded for damage to Indigenous vegetation or to SNAs unless a resource consent expressly authorises it. So it is a regime that includes scope for consents to be obtained should a permitted baseline be exceeded. Turning to paragraph 48 of my evidence, I propose that a note be included in this method ECO M1, advising that unless a more stringent rule in a plan is made, the NESPF regulations will apply. For forestry as a sector, the NESPF provides a clear regulatory framework. It provides certainty and consistency, and it was a long time in the making. Alternative plan provisions may be made by a regional plan or district, by a regional council or district council, but that's subject to evidence to show that NESPF is not achieving anticipated environmental outcomes. Finally, if I may, just on the subject of the wilding conifers, I would like to reserve my commentary for the land and freshwater hearing taking place in May in a few weeks. I have proposed a new policy for that chapter in addition to a number of land use considerations. Because I consider that wildings are an issue for wider landscapes as much as ecology. But I would like to stress that again, the NESPF provides for the regulation of wilding conifers. It includes the wilding risk calculator tool, which must be used for the planning of afforestation and replanting and could be applied to land uses more widely. So at para 58 of my evidence, I propose adjustments to ECO P9 accordingly. So that's my commentary for this morning, and I hope there's time to take questions.
Thank you. There is time for questions, and we'll commence with Commissioner Sullivan.
Thank you very much for that. We did hear yesterday what was pointed out to us that the NPS PF is only for plantation forestry, so it doesn't apply for sort of permanent, more carbon forests. Is that something that you've considered when you've in your evidence and what you've proposed, or you're being solely focused on, assume, on plantation forestry?
My comments on the ecosystems and biodiversity chapter are solely focused on plantation forestry, but the land and freshwater chapter is an opportunity for the regional council to extend the scope of its plan to other types of afforestation. So that would be carbon forestry and the like. And no, you're correct to say the NESPF applies to plantation forestry only, and that is forestry that's intended to be harvested. And it's really the harvesting activities and all other activities associated with a commercial forest that's to be harvested.
Thank you. I think that's yeah, no, I didn't have any questions on your evidence. That was all clear. So thank you very much.
Thank you.
Yeah, thank you. Just heading backwards in your evidence, actually, and we deal with the significant resource management issues, paragraph 17, and it's kind of relevant to how the eco chapter works. And your supported fish and game submission there around the definition of ecosystems, that they're not necessarily all native, which is reasonably obvious, but in the context of the eco chapter, I'm just wondering the implications of that for plantation forestry operators, because it may have been you guys, but I think it might have been Sea Forest raised the issue around plantation forests being significant habitat for various at-risk birds, etc. And what the implications are for that. How does the NES deal with that issue?
The NESPF certainly provides for the protection of habitat. As Indigenous vegetation, there is constraints on how much can be cleared. There are buffers required between forestry activities and riparian zones. And certainly there are provisions, for instance, Regulation 102 in the NESPF for Indigenous bird nesting requires that forestry operators have procedures in place for identifying the presence of nesting birds. Not all birds nest in trees, some nest on the ground, for instance, kiwi. So many forestry operators need to be quite proactive at identifying what species are within the forest. So in many cases, forestry operators undertake ecological assessments and map the presence of species. And then those maps are carried through to forestry operators through prescriptions, identifying a particular species may be present, and if sighted, they are to put in place procedures, for instance, buffer zones around the nesting site. So there are management plans that are applied in those circumstances, and that's all regulated under NESPF Regulation 102 for Indigenous.
Yeah, okay. So that sort of answers my question around that, because the concern was if these areas get identified as an SNA, and I'm not talking about the Indigenous vegetation within the forest, it's the planted conifers, but there is a process in the NES to deal with that already, so there's no concern.
That's correct, yeah. It's likely that cutover does provide a habitat for some types of bird, for instance, falcon, and we are aware of that. So again, a management plan would dictate what other operations can happen in the cutover if presence of those birds are identified.
Okay, thank you. Your paragraph 50, where I think you're supporting Forest and Birds amendments to Eco P5 to make the addition that existing activities have to be lawfully established. I'm just wondering why that section is needed at all when you're probably already protected by section 10. And I think the exposure draft of the NPS actually recognises that already and actually specifically excludes activities protected by section 10, recognising that that's obviously not in play yet. So how does that Eco P5 help?
Haven't really considered how it would play out, other than noting that it could only assist activities that have been working on land for some time and then are suddenly dealing with the status of SNA coming across their land. So I would still consider that for the lawfully established activity to continue in the mix with an SNA, that a particular management plan would need to be in place to ensure that the values of the SNA are protected. But it's good that it is recognised in the policy framework that notwithstanding the SNA value, there was also a lawfully established activity there first.
Yeah, I was just wondering how that section 10 sort of already applies in that context. But in your paragraph 51, when you refer to EcoP 6, the effects management hierarchy, I think what you're saying there is that your preference is for a separate hierarchy for Indigenous biodiversity as opposed to the one that's in the freshwater management MPS. When I look, but when I look at the two effects management hierarchies, the one in the FM and the one in the exposure draft, at least, again recognising it's not gazetted, they actually look pretty much the same, but very similar.
They're quite similar, but when applied in different contexts, there would be differences. So just those slight nuances are probably quite tangible.
Well, have you got an example of how they would be different? Because we have heard evidence from other parties that the MPS FM effects management hierarchy is the preferable one. It's the only one we have sort of enshrined in any national document.
That's true. No, I don't have any examples that I can give you because my evidence isn't really detailed with regard to this provision. But I could see the planning sense around applying the two different hierarchies in appropriate context. So that's why I made a comment on it. But no, I don't have an example that I could provide.
Okay, well, thank you for that. And I guess we'll talk about conifers and other wilding trees in a couple of weeks' time.
Thank you. I would appreciate the opportunity to go into that topic in a bit more detail at that time. Yes, thank you.
Thank you.
Ron Crosby, the chair, just to finish. The NSPF, you say, provides certainty. It provides a pretty lax certainty, doesn't it, in terms of protection of Indigenous biodiversity? And if I give you an example of why I say that, if you look at the vegetation clearance provisions that you've drawn attention to, the cumulative clearance can be up to 1.5%. So it's either must not exceed or 1.5%. The wording is whichever is the greater.
Yes.
So that if you've got 1,000 hectare plantation, you can clear up to 15 hectares of native Indigenous vegetation. Am I reading that right? You
are reading that correctly, yes.
And then subclause 4 of regulation 93 says incidental damage is also a permitted activity and may occur in an area which is within or adjacent to any plantation forest, including a riparian zone. What's incidental damage mean?
Incidental damage I consider is brush damage of a protected zone or a zone with higher identified natural values. I think that prior to 2017, when the NSPF took effect, there were no buffer zones or setbacks required for forestry. So riparian margins were planted right down to the stream. So it's very difficult when harvesting now to sometimes avoid adverse effects on a riparian margin or an Indigenous vegetation area or an SNA when trees were planted right up to. But everything planted from 2017 forward will be planted with setbacks, and it will be easier to avoid incidental damage on sensitive natural areas within the forest. So I think the incidental damage is something that provides a little bit of elbow room for forestry operators, but with the caveat that you avoid damage. But if damage is unable to be avoided, there is a little bit of elbow room. If damage can't be avoided to within those thresholds, a consent must be applied for. And harvest planning activities factor that in for every operational year, which is why under the NESPF we have to prepare a management plan for the year's operations, and everything is mapped and considered with regard to the scope for operating within a setting and the potential for any damage to an SNA or an Indigenous zone.
If you look at, I know you wanting to deal with conifers and the wilding issue next as the land hearing, and I'm reasonably comfortable with that, but I do just want to raise with you that I'd be interested in you addressing clause 11, regulation 11.5, and how effective that really is in a practical sense when you do come to that, because it provides for control measures that seem to be limited to areas quite obviously within the same ownership or management of the property on which the forestation occurs. I mean, I'd be very interested in hearing your views when we come to that as to how effective that really is in the setting. For example, if you look at, and I'm not sure whether you would have driven through the Mackenzie country recently, but it's something that I did last month, and it's just appalling the amount of wilding pine spread in there. If it's not controlled in the next few years, there's not going to be a Mackenzie country of Sussex, there'll be a Mackenzie country of wilding pines.
Yeah, I've also seen that down in Otago. So yes, I will make a comment on that for the next session. Absolutely, I'll address it.
Thank you. All right, well, look, thank you very much for your evidence, and hopefully we'll get to see you next time.
Yes, I'll try to figure out what happened there, because I certainly pressed the right button, but I'm not too sure. So thank you very much for hearing me.
Thank you. Pushing go.
Thank you. Just check that Mr. Farrell's online. So these are my legal submissions. And we'll get the email. Areas.
Good morning, Mr. Farrell.
Good morning.
Start.
Thank you. So I'll take you through, I have to push a button, don't I? Take you through my legal submissions, but first I'll introduce the gentleman beside me who you wouldn't have met yet. You've met Mr. Farrell, our independent planner, but to my right is Nigel Peregrine, the environmental officer for Fish and Game, and beside him is Jade Cooper, Fish and Game officer and ecologist for Fish and Game. So Fish and Game are going to appear twice before the panel. This first appearance is going to address the relevant topics heard to date by the panel, which I've listed in my paragraph 1 there, including the ecosystems and biodiversity chapter. But also we spend quite a bit of time on the integrated management chapter as it links to these ecological health points and the significant resource management issues, particularly as they relate to the people's health and well-being derived from accessing natural places. And we will return to address yourselves on the land and freshwater chapter and related provisions, including APP1 in May. So the touchstone of Fish and Game's case generally, so this does sort of cover the whole thing, but it's particularly relevant today in respect of the pORPS, is that firstly, the pORPS needs to put the health of the natural environment first, and that's in a holistic, integrated way. Secondly, the National Policy Statement for Freshwater Management and Te Mana o Te Wai require that there be no degradation of water quality. Then relevant to putting the environment first includes the importance to people's health and well-being derived from recreational use and enjoyment in the natural environment and outdoors, and that also includes obviously harvesting different species of food. Included in the above is the importance of protecting the habitat of trout and salmon. And as part of all the above, at the pORPS level, there needs to be a clear direction that environmental limits should be set that will protect or restore ecosystem health, and that all resource use is subject to these limits. In Fish and Game's view, priority placed on the health and well-being of a water body in accordance with Te Mana o Te Wai creates an additional check that helps combat otherwise unaddressed cumulative effects. And Fish and Game submits that the pORPS should adopt the concepts of Te Mana o Te Wai for the whole environment because of its integrated management framework. As Te Mana o Te Wai is or will be embedded in the freshwater framework due to the NPSFM, the integrated management chapter must therefore bring this through into the entire RPS framework given ORC's approach. And this can be done by creating a clear and directive hierarchy with the natural environment as the priority. It is done by imbuing the anthropogenic concepts of health, well-being and resilience upon the natural environment as a whole. And I've inserted there a paragraph from Fish and Game's original submission that expands on this point about taking this anthropogenic approach to looking at not just water bodies, but the environment and ecosystems. I'll let you read that section out to yourselves. So the point I'm trying to emphasise there is that looking after water bodies and looking after the natural environment in this way is more consistent with Te Mana o Te Wai than a more compartmentalised approach to effects on the ecosystem. It's a positive obligation to look after the environment's health, not a reactive or what are the adverse effects. It's sort of quite a different philosophical shift, if you like, in terms of attitude towards the natural environment for our planning documents. It's not a shift for everybody. A lot of people approach the environment in that way already, but our planning documents generally haven't to date. And the third point there is really similar to what I just ad-libbed, ensuring all actions support in a positive way the health, well-being and resilience of the natural environment. So I've tried to gather these legal submissions into 4 general themes that I'll then take you through and direct you to which provisions generally fit under each of these umbrellas. So these 4 themes are to protect and restore water bodies and freshwater ecosystems, that freshwater ecosystems often include trout and salmon and other introduced species interacting as part of a functional unit. And I just draw your attention there to my footnote 2, where I've just noted the definition of ecosystem from the Southland Land and Water Plan that's been considered by Her Honour Judge Borthwick's division. And it's not a contested definition, it's in the plan. is a dynamic complex of plant, animal, and microorganism communities and their non-living environment interacting as a functional unit from the UN Convention on Biological Diversity. Now, we don't have a similar definition in this document, so that was just why I thought that was a useful reference. The habitat of trout and salmon is to be protected insofar as this is consistent with protecting the habitat of Indigenous freshwater species. So that's directly taken from policies 9 and 10 of the NPS freshwater management. And the protection and restoration of the health of water bodies and freshwater ecosystems is the first priority in accordance with Te Mana o Te Wai, requires a range of actions and a holistic approach to all causes of degradation or bad health. The fifth, sorry, I said there are only 4 things, there's actually 6 main things, included within the range of actions required to protect and restore the health and well-being of freshwater ecosystems is that all activities are to be managed within limits. And I just want to, in my footnote, emphasise, by focusing on limits, we're not trying to take away from the importance of the holistic approach and integrated management by, again, compartmentalising things into what are the limits, what are the adverse effects. It's just that as part of that integrated approach, the limits is obviously a really important thing that you are grappling with. So I have called it out as sort of a separate sub-theme. And if the positive health and well-being effects of outdoor recreation, including in and around water bodies, should be recognised and valued. Other couple of themes are the precautionary approach and cumulative effects, which are sort of weaved throughout in definitions of some key terms. In terms of Te Mana o Te Wai, it's submitted that the finding and explanation below from Judge Borthwick's division is of assistance. And I will actually read out paragraph 31. So the NPS-FM 2014, amended 2017, was closely considered by the Environment Court in Aotearoa Livestock, that's the Southland Land and Water case, on appeal from decisions. The court's observations in Aotearoa Livestock remain relevant and bear repeating here. Te Mana o Te Wai is not a Māori-centric, but a water-centric approach. While expressed in Te Reo Māori, Te Mana o Te Wai benefits all New Zealanders. Te Mana o Te Wai is a concept that requires natural and physical resources be managed in a way that recognises that by protecting the health of freshwater, the health and well-being of the wider environment is also protected. This concept entails a fundamental shift in societal perspectives on sustainable management of freshwater. There are specific issues in respect to trout and salmon habitats and water bodies generally that are principally addressed in the Land and Freshwater chapter, being addressed by this panel. I say not the Freshwater Commission, it's as well as the Freshwater Commission, obviously, but you have provisions in front of you that come under this heading as well. So Fish and Game will address this panel on the Land and Freshwater chapter, along with the following linked provisions in the rest of the PRPS at the May hearing. And at the May appearance, Fish and Game will also address Ms. Boyd's recommendation to include a new method to implement LFFWP7 in respect of species interaction. However, LFFWP7 is not a provision being considered by this panel, and Ms. Boyd's recommendation in her supplementary evidence was not included in this version of the 42A report. So what we've got is a little bit of confusion about exactly the scope of what ORC consider is and is not for this panel to consider in terms of this trout and salmon and species interaction theme. For safety, if you like, we're addressing it to yourselves because it was part of our primary submission, and the relief was originally sought in the eco chapter, but we've agreed that it probably better fits in the freshwater chapter, but also for safety, Fish and Game submission on the freshwater commission process covered these points again. So when we do come back in May, that integration, just to, we'll have another discussion with you about how we can best address that integration in a way that's sort of fair for everybody. I don't think we need to grapple with it today, but I'm sort of giving forward notice on that point. So on our first key theme, protect and restore health of water bodies and freshwater ecosystems as a priority and as a positive obligation. An overarching theme and objective of Fish and Game is that the pORPS should provide clear and unambiguous direction that the health of freshwater ecosystems and water bodies should be protected, and if degraded or if it's unhealthy, restored to good health. And there are specific sub-issues under this heading that will be addressed separately in the land and freshwater chapter. However, the overarching direction is set in the SRMR, IM and ECO chapters, and consistent references to this objective are also required in the EIT chapter. So Fish and Game's relief under this heading is in respect of the provisions I've set out below. And so what I've appended to my legal submissions is hopefully all of our provisions, whether they're from Mr. Farrell's evidence or the Fish and Game submission in one place, just a bit of a reference. So what I might take you to, just so you can see what I'm talking about, if you turn to page 18 of my legal submission document, you'll see the relief for IM01. And IM03, where we support the amendments in the 42A report. This is primarily to orientate you a little bit and get you to find your way around our package, if you like. Turn the page and you'll see IMP4, not IMP2, sorry, I apologise. So we support the concept of amalgamating IMP1 and IMP2, but Mr. Farrell has suggested a different drafting of that amalgamated policy that addresses both our priority of the health and wellbeing point as well as the limits point when there are conflicts. So that might be something you have some questions for Mr. Farrell for. IMP5 is on page 20 of that.
Sorry, just taking you back to page 19. What's the highlighting in the word health?
Yes, I think there's some shading and my marking up code might not be quite right, so I'll have to just do a proper checks. Some of the markups, particularly where they're from Mr. Farrell's evidence, will actually be the section 42A markups that then he's done his markups on top of. Whereas if I've said it's a Fish and Game submission relief, that is a markup just compared to the notified version of the pORPS in 2021.
If you just take page 19,
yeah,
you've got some lines underlined,
yeah,
some double underlined,
yes,
and then you've got a highlighted.
Yes.
So what's what?
Yes, good question. Like I say, I think there might still be some fixing up to do with the actual coding, because some of the double underlines, for example, in IMP1 are Mr. Farrell's drafting, but in other places the double underline, for example, in P5 from the 42A report.
Look, I think.
So I could give you a tidier version of this.
Absolutely.
Yeah, yeah,
and
yeah.
with a key, if you would.
Yeah, with a better key.
So,
Yeah.
so that we know exactly what we're.
Yeah. Yeah, no, I'll definitely keep working on that.
I mean, at the moment, your key at page 16 says black text with grey shading, provisions to be addressed at the hearing in the May.
May, yes.
Right.
Yeah. Yeah.
All right, well, look, let's just leave that for you to make sure you get a proper one to us with the key as you want it, and so that we can understand it when we look at it.
Yeah, yeah. So no, we'll definitely provide that. That's no problem.
So back to your paragraph 12.
12, yeah. So paragraph 13, I draw your attention to some of Fish and Game's evidence on the theme of restoring health, if you like. Mr. Cooper's evidence provides an overview of the general state of Otago's aquatic ecosystems, and he looks at 4 components: water quality, water quantity, species present and their interactions, and the physical alteration of water bodies. And Mr. Cooper states that these components can be thought of as the foundations of stream health, and the state of them can indicate anthropogenic degradation of waterways. In terms of water quality, Mr. Cooper found strong evidence of degradation in multiple waterways, And the Environment Court in the Plan Change 7 decision also described the state and trends of water quality in its annexure 4 water quality to the decision. I'll let you read
I've
out
probably
that.
got to interrupt you there
Mm.
because we're clearly required to look at habitat, and so clearly anything in relation to ecosystems we can look at, and habitat we can look at, but we've got the barrier that the High Court said to us: we can't look at quality, we can't look at quantity. So I think there's a fine line to be trodden somewhere by you, in that we're happy to and will receive evidence relating to ecosystems.
Yeah.
And that takes you very close to quality, I
Yeah.
would have thought, right?
Yeah.
But when you start getting into the detail of quality that you're about to quote, I just think we've got to steer away from that.
Yeah, well, and maybe I'll address you further on this in May, but to give you the teaser of what's, what we're all grappling with this strange process that we're in. I know that there are paragraphs in the High Court decision that say exactly what you just said, but there are also the High Court's declarations. So I didn't expect to have to front foot this with you today, but I will in writing in May. So paragraph 231, the declaration of the High Court to the Regional Council was it must satisfy itself as to which parts of the proposed regional statement relate to freshwater and so constitute a freshwater planning instrument through giving effect to the National Policy Statement for Freshwater Management. So that's a broader declaration than the other narrower statements that the High Court also made about freshwater quality and quantity.
Yeah, and I think really what that paragraph 231 is saying is what I've just said to you, that we must look at ecosystems, we must look at habitat, but the issues of quality and quantity is where we can't transgress. And that's got to be left for the Freshwater Hearings Commission.
That's right.
To decide. So you were doing well up till the passage that you've tried to read to us, which I don't think we can accept. And then immediately in paragraph 15, you're going on to water quantity.
Yes.
And again, we can't venture there.
Yeah, I agree. Well, you can't venture there specifically, but going back to how I opened with if Te Mana o Te Wai is imbued through the whole planning framework, and the integrated management chapter is actually about integrated management, and there's an approach to ecosystem health as a whole.
Happy with all of that?
Yeah, happy with all of that. Compartmentalising out completely, or not even completely, because we've still got a bunch of freshwater provisions that we're coming back in May to talk to you about, which is what we're all struggling with. Compartmentalising out part of the freshwater health component of that, natural environment, holistic, integrated health approach. It's very difficult. And so even if
agree with you more.
I know, I don't even be a task at all.
We're all struggling with
Yeah,
how it is
yeah.
to have an integration when
Yeah.
you're told that you can't look at the quality and quantity.
Yeah, yeah.
But we're stuck with that.
Yeah. Well, you might. Yes, it is very sticky. Yes, and so I'll do my best to be helpful. I'm not trying to be difficult by setting the scene, which is all I'm doing with these provisions. I'm setting the scene about the state of health of part of the ecosystem.
Good.
Happens to be the wet part.
We can hear that. And,
Yeah.
And
Good,
carry on that
good.
basis.
So that's part of what Mr. Cooper's evidence does, is it sets the scene of where the state of health of the freshwater ecosystems in Otago are. And so there's that quote from Plan Change 7, and there's the other quote about the scale of abstraction. And then on 17, some more quotes about level of allocation being high in comparison. Water demand and water availability were impacted by climate change, and there are a range of issues affecting current coverage and continuity of flow recording. So that's about monitoring. So then in respect of the anthropogenic physical alterations of water bodies, Mr. Cooper describes the scale of these. And in my submission, the degree of degradation generally of many of Otago's water bodies is not disputed. That's agreed. There's degradation. There's poor health. Therefore, for Fish and Game's perspective, it's important that there are not only to be a consistent reference to protection, but that there also be a consistent reference to the requirement to restore. Given the state of the health of Otago's water bodies, there needs to be a very clear positive obligation to provide for their health. And to this end, Fish and Game have promoted a new definition of the term restore so that it can be applied with certainty and consistency. And that's that italics there. The next paragraph should actually not be indented. A consistent directive to protect as well as restore is also consistent with the approach outlined by the Environment Court in the Southland Land and Water Plan in respect of Te Mana o Te Wai. So I'll let you read that quote. So why I wanted you to focus on that is, even though this is in respect of a water plan in Te Mana o Te Wai as it relates to water, this PRPS is taking Te Mana o Te Wai further. Otago's interpretation of Te Mana o Te Wai will be probably different to Southland's, but what's of assistance from Judge Borthwick's statements there, again, is like in the middle of 62, it's about a positive obligation of all people exercising functions to ensure that they are providing for the health of the water body and the health of people. And so if you elevate that to ecosystems and the natural environment generally, it's that positive obligation to provide for health is the first priority that I really wanted to emphasise and draw your attention to there. And it like I opened with, it's a juxtaposition of how many planning documents have previously approached managing effects on the environment. It's been, previously you've looked at what change am I going to make? How much of an adverse effect is this going to be, rather than am I providing for the health and well-being of this entity first? At paragraph 21, I submit the appropriate use of the directive to restore will also help give better effect to policy 13 of the NPSFM. And 22, relevant also to this first theme, is Fish and Games Relief, which seeks that the term minimise be defined so that it is applied consistently throughout the document.
You don't source that particular definition.
I don't source it. It's in Fish and Games submission and Mr. Farrell's evidence, and I can't remember if it's a definition from an actual dictionary or not.
Mr. Farrell will probably provide that. I think it comes from another plan.
Yeah, well, yeah, hopefully Mr. Farrell will be looking at the source right now.
Right, okay.
So the second theme, and taking on board your point, Mr. Chair, but I do have to address you on it because Fish and Games Relief sought certain provisions be inserted into the eco chapter that relate to the habitat of trout and salmon.
If it helps you, I'm only going to stop you if I think you go a little bit too far. Okay. I'm going to try and err on being inclusive and letting you say whatever you can about ecosystems and the health of ecosystems. Now, that must take you a long way.
Yeah.
Right? Okay.
Thank you, sir. So there are overarching provisions in the Eco and the IM chapters in respect of which Fish and Game submitted it is necessary to add reference to the term ecosystem generally and habitat of trout and salmon specifically. And Fish and Game is still pursuing these changes. So if we look at IMM2, for example, which is on page 22, that's the relationships method. That's one of the changes sought. Yeah, so both of the word ecological is the new word in that phrase, not environmental. So I'll just check that. Sorry. And then Eco 01. This is where we're sort of really making our point. At page 27, you'll see Eco 01. And Fish and Game and Mr. Farrell seek that primary objective of the chapter refer to ecosystems and Indigenous biodiversity, not just Otago's Indigenous biodiversity. So it's not detracting from the Indigenous biodiversity objective, it's just having the objective consistent also with the title of the chapter even. Eco P10 is inserting specific references to the habitat of trout and salmon. As is Eco M4, which is on page 29 of the legal submissions. Eco M5 is more generic, about promotion, restoration or enhancement. Eco M8 is a similar wording change to how we approached the objective 1. So it's about gathering information on ecosystems, Indigenous biodiversity and habitats, so that it's got that subtle but really important broader focus on ecosystems generally. So that's the gist of these changes under this theme. Now, these changes are on the basis that pursuing ecosystem health overall, at least in the freshwater context, need not be inconsistent with Indigenous biodiversity objectives. This gives effect to policies 9 and 10 of the National Policy Statement, Freshwater Management, and the definition of ecosystem health does not exclude an ecosystem that provides healthy habitat for trout and salmon. So I've set out the 2 key policies from NPS Freshwater Management, along with some words from Sir Geoffrey Palmer. The specific recognition of trout and salmon habitats in the RMA reflects both their historical recreational importance and their role as an important indicator species for the health of our rivers, lakes and streams as a means of assessing ecosystem health. The reason for this is that trout and salmon have a higher ecological requirement for freshwater quality and quantity than most Indigenous freshwater species. As set out in the evidence of Mr. Cooper, a river that provides good habitat for trout would also ensure good habitat quality for other species. Mr. Peregrine's evidence discusses the need for clarity about what exactly ecosystem health means, a concept that comes through particularly in the integrated management chapter. Now, on this question generally, I also submit that the High Court's decision, which was on the Lindis appeal, the plan change, is of assistance when it looked at the highest level Section 5 requirement that life supporting capacity in ecosystems be safeguarded. The question 4 that the High Court considered was, does safeguarding the life supporting capacity of water and ecosystems in Section 5 of the RMA rightly include the sustainable management of trout and their habitat? The finding of this question is of assistance in that the High Court confirmed the sustainable management of trout comes within the safeguarding of life supporting capacity purposes of section 5. And I've bolded the finding on that point. And then a disciplined step through the NPSFM also supports the directive that including trout and salmon habitat protection and the concept of ecosystem health is appropriate and consistent with implementing both Part 2 of the Act and the NPSFM. As noted above, up front, there is Policy 10, Qualified Directive to Protect the Habitat of Trout and Salmon, as part of achieving the one objective of the NPSFM and its 3 priorities. Clause 3.5 requires an integrated management approach, including at B, recognising interactions between ecosystems, and it would be inconsistent with this approach to attempt to silo or separate out management of indigenous ecosystems from the broader ecosystems that include introduced species with which there is interaction and integration. Clause 3.9 requires that for each FMU, both the compulsory values and the other values be identified, and the description of the compulsory value of ecosystem health in Appendix 1A takes the same approach as policies 9 and 10, in that a healthy freshwater ecosystem should have the 5 biophysical components providing for trout and salmon habitat, as long as that is consistent with protecting the habitat of indigenous species. Value 5, fishing in the NPS explicitly requires that when setting attributes, the attributes will need to be specific to fish species such as salmon, trout, tuna, lamprey, or whitebait. So the manner in which all of these provisions interact means there's no exclusion of trout and salmon from the NPSFM concept of ecosystem health. And I just want to emphasise, we're not trying to take away from the importance of Indigenous biodiversity and protecting Indigenous species habitat. It's just protecting trout and salmon habitat as part of this integrated approach to the health and well-being of water bodies and ecosystems. And as I understand it, in a terrestrial sense, you're kind of grappling with similar but different concepts, whether it be exotic species provide important habitat for Indigenous species. Again, it's just another example of the complete integration we've got in Otago between introduced and Indigenous species in our ecosystems. I've set out another quote from the Southern Land and Water Plan in terms of the Environment Court's assessment of how to approach ecosystem health again, and I submit it's of assistance in how to look at ecosystem health and how it can't be compartmentalised. It is experts' view that water quality and ecology must be considered using both a whole of catchment and site-specific approach. This involves consideration of historic and current land use, the quality and quantity of groundwater and all freshwater bodies in the sea on an integrated basis, and all water bodies are interconnected, not adopting a holistic whole of catchment approach risks drawing incorrect conclusions. And as set out in the evidence of Mr. Cooper, pure Indigenous ecosystems in Otago are incredibly rare and geographically limited, if not non-existent. In that regard, it makes no sense for the focus of the eco chapter to be solely on Indigenous ecosystems, but a strict reading of the provisions presents a direct focus only on a few rare ecosystems that are fully Indigenous, with no recognition for the bulk that include introduced species. Many valued introduced species are fully embedded into the ecosystems of the Otago region. I want to expand a bit on this concept. So the eco chapter, the eco and Indigenous biodiversity chapter, the title comes from the National Planning Standard template. The National Planning Standard does not direct what must be included in these chapters and RPSs. The only direction it gives, on my understanding, is that if a council goes to address their Section 6C and Section 30 duties in terms of biodiversity and Indigenous species, this chapter is the place to do it. It doesn't say that's all you can address in this chapter. there is no national direction that this chapter is solely confined to Indigenous matters and biodiversity. So in my submission, the heading of the chapter is self-evident. It's about ecosystems and Indigenous biodiversity. It's not just about Indigenous species and Indigenous biodiversity, because if it was, that would be the heading. And so this is why, on this subtle but really important point, Fish and Game's changes seek to broaden the focus of the chapter to what is the reality in Otago. Is that most of our ecosystems, even the healthy ones, aren't just full of Indigenous species. They are also have introduced species as an integrated part of the healthy ecosystem. So that's sort of the gist of what I'm trying to labour on this point. So at paragraph 36, it's these high-level changes that we submit are required to some provisions to acknowledge that introduced species do form part of the ecosystems and ecosystem health in Otago, whether it be terrestrial or aquatic. And I've listed again just the provisions that I took you to before. There's a submission point in respect of issue 2, where we sought changes to remove the word native from that issue, which was done by the 42A report, so that's supported. And then in Mr. Peregrine's evidence in chief for Fish and Game, he confirms that rather than amending some of the provisions in the eco chapter to address trout and salmon habitat, fish passage and species interaction, instead Fish and Game have agreed that those provisions can be addressed in the land and freshwater chapter. So the provisions on which Fish and Game originally submitted and sought new provisions, which I've listed at the end of that chapter there, to the extent we can, we'll be addressing you in the May hearing in the context of the freshwater chapter. And we'll continue to figure out how to dance that fine line of integration with the other process.
Yeah, happy for you to do that, but can I just have a clear picture in our mind at the moment as to whether you're going to be suggesting in that hearing week in May that these amendments go into the eco chapter or go into...
No, I think that we do agree that if they are to go anywhere, it's into the freshwater chapter. The next theme is protection and restoration of ecosystems requires all activities to be managed within limits. One of the essential mechanisms in respect of which there needs to be clear direction in the PRPS is the requirement to set limits in a manner that does not detract from the positive obligation to act in a holistic manner to protect and restore ecosystem health. In Fish and Game's view is in order to protect and restore natural ecosystems at and to a healthy state, it is fundamental that any use of natural resources is constrained by limits. Reference to using resources subject to biophysical limits is an important paradigm shift that should be brought through consistently in the PRPS. Fish and Game's focus is biophysical limits. And Fish and Game agrees that there are other natural features such as natural character and landscape that are important to the quality of experiences in the outdoors and that also need to be appropriately managed. But management of these natural activities features, while important, doesn't fit neatly into the sort of quantifiable and objective manner in which you can set biophysical limits, such as water quality and quantity or providing for habitat. Hence the distinction, in my mind at least, between biophysical limits and other environmental constraints or controls. So on this point, Fish and Game's submission originally sought a definition and use of the term environmental limits. And then in addition to that, Mr. Farrell suggested instead of that, you could use a term, biophysical limit might alternatively be used throughout the PRPS in the provisions intended to prevent degradation of ecological health and to protect human health. And just note at paragraph, footnote 18, if you are looking at that definition of biophysical limits, given that the NPS FM uses the term ecological health, not ecological integrity, would supplant the word ecological integrity with ecological health, would be more consistent. So if you were looking at biophysical limits, they would be appropriate for air, Indigenous biodiversity, coastal water, estuaries, freshwater and soil. We note Ms. Boyd reviewed her position as this process has moved on and has come back to just recommending the definition of limits in the pORPS only use a defined term in a freshwater context. While this is obviously acceptable in terms of Fish and Game statutory role to be of assistance, we still query whether the concept should be applied more broadly and consistently across the eco chapter and the use and development chapters, where the concept of using natural resources within limits should sensibly be applied across the board if the panel is minded to apply this consistently to both terrestrial and aquatic ecosystems. Regardless of whether or not the term is the NPSFM definition of limit or environmental limit or biophysical limit, Fish and Game consider there should be clear and unambiguous direction throughout the document that consistently require that such limits be set as part of the suite of mechanisms to effect Te Mana o Te Wai, the protection and restoration of the health of water bodies and their freshwater ecosystems, including the habitat of both Indigenous species and trout and salmon. And in this regard, a suite of changes is sought to provisions in the IM, EIT and ECO chapters and the Land and Freshwater chapter. And Fish and Game consider there should not be an exemption from complying with limits, even for renewable energy generation, subject to the exceptional circumstances provided for in IMP12. So we've already looked at IMP1 and P2. So perhaps I'll just take you straight to the EIT provisions, because we haven't looked at those in the appendix yet, just so you know where they are. So they start from page 31. They submitted that it would be preferable for the pORPS to make this clear and consistent direction that the use of resources is subject to environmental or biophysical limits in a manner consistent with Ki Uta Ki Tai, i.e. not just in respect of freshwater, but across the natural environment and ecosystems generally. It will then be up to the relevant district plans and regional plans to implement that direction and to set and enforce those limits. Ultimately, however, Fish and Game statutory interest is primarily in relation to freshwater habitats and implementation of the NPSFM. And then, as I flagged earlier in the piece, in respect of IMP1 specifically, or the amalgamated version, Mr. Farrell has recommended drafting that is also intended to assist with the question of addressing internal policy conflicts, including as between national policy statements, because it is considered that the Section 42A version weakens what was previously clearer in the separate IMP1, MP2. Then the final main theme is the positive health and wellbeing effects of outdoor recreation, including in and around water bodies, should be recognised and valued. In order for the pORPS properly to provide for people's health and wellbeing, Fish and Game consider there should be a more explicit positive acknowledgement of the importance and protection of people's ability to access the outdoors for recreation, that's both active and passive, and of course for harvesting food. Specific to Fish and Game's interest is that water bodies that support recreation and amenity values are highly valued natural features. And for this reason, as well as the intrinsic or non-anthropocentric reasons, they should be recognised as important, protected, and where degraded, should be restored. The evidence of both Mr. Cooper and Mr. Peregrine provides support for this explicit positive acknowledgement of the importance of accessing natural places for people's health and well-being. Mr. Cooper illustrates just how popular and widespread angling and game bird hunting in particular is, both nationally and in Otago. And Mr. Peregrine's evidence also addresses this point. He explains it is not just ensuring that contact with water does not cause adverse health outcomes, it's the positive fact that access to and recreation in the outdoors is good for people's health and well-being. And he cites research that shows there is a strong relationship between outdoor recreation and human health. At the outset, Fish and Game submit that the positive health and well-being benefits people get from accessing the outdoors should be recognised in the SRMR chapter as it is a positive matter of significance that should always be factored into decision making. So following on from Fish and Game's submission that sought this new issue in general terms to make this positive recognition, Mr. Farrell's evidence in chief suggested drafting that would give effect to this relief entitled SRMR I-12. And so an issue to this effect that explicitly acknowledges the significant positive human health and wellbeing benefits is still being pursued by Fish and Game. And just for clarity, the two joint witness statements in March, the 22 March one was specifically directed to address infrastructure, and the 29 March one was specifically addressed to direct users or commercial users, if you like, of natural resources, primary production, mining, tourism and industrial activities. So neither of these JWSs traversed into the standalone issue that Fish and Game are seeking and that Mr. Farrell has proposed a standalone issue to address. The other provision in the UFD chapter that is relevant to this relief is right near the end of the appendix. So if you turn to page 32, the new subparagraph 8 in particular for UFD P7, adding enables outdoor recreation, including commercial recreation, is relevant to this theme. And even though I acknowledge, well, I know you're grappling with the fact that the urban chapter has all these rural provisions in it, the urban provisions in that chapter do acknowledge the importance of recreation in an urban setting. So I see no logical bad architecture reason, let alone on the merits, why this effectively rural policy 7 should also not acknowledge what recreation values are important in the rural areas of Otago. So still on the point of where throughout the plan, this particular theme is relevant for APP 9, which is the schedule that defines outstanding natural features and landscapes and highly valued features and landscapes. We support the section 42A's adoption of part of our point, which is that recreational values be explicitly acknowledged in that appendix. So that's that outcome is supported by Fish and Game, and then we will address you again in May where this relevant theme comes up in the land and freshwater chapter as well. And then the final point, which is also supported by a number of submitters, is that it's desirable to define what is meant by a precautionary approach. So one definition is proposed by Fish and Game. We also supported the definition of, I think it's the Waitaki irrigators definition was similarly useful, we thought, and particularly if IMP 15 deletion is going to occur, which we don't support, definitely need to be a definition that provides something that ensures a consistent application of that term throughout the instrument. So happy to take questions.
Thank you.
And this may be more a matter for Mr. Farrell, but I suppose I've just sort of been looking through the various definitions in the plan, and I see we've got definitions for biological diversity, indigenous vegetation, indigenous species. We then you've been raising, and I think you're suggesting the definition of ecosystem.
Well, I referenced it
You
because we don't
referenced-
have one.
No, no, because there's not one. I mean, there is and often in the eco chapter, we're talking about indigenous species and ecosystems, presumably indigenous ecosystems, and I certainly take the point in the evidence around, possibly it's useful to define that because, and I mean, are you aware of definitions in other places? Is that something that you looked at?
Well,
through
that
this
one
as well?
definition that I cited.
That's ecosystem rather than indigenous ecosystem.
That's right. Yeah.
And I'm assuming that, whether there's definitions of indigenous ecosystems around which have, a certain proportion of indigenous species or, something, given that there's always going to be exotics in there as well.
I can't answer that question because I'm not aware of any. Mr. Cooper might have some insight into that in addition to what's already in his evidence. And I don't know what Mr. Farrell knows on that point either.
I suppose on this issue, and I'm not sure who this question's for really either, but when you've looked through the provisions in the eco chapter to look at whether it's referring to indigenous ecosystems versus ecosystems and how that's referred to, and certainly take your point that the national planning standards are, that's the defined title of the chapter, and there is a lot of case law that's and the RMA referring to trout and salmon. Is that something that you've looked closely at in terms of the way the wording is to make sure that where relevant, it's referring to ecosystems and not indigenous ecosystems?
Those are the changes we've sought to make sure that the general concept of ecosystem is included in appropriate places because it wasn't.
Yeah. Also, in terms of your EIT provisions, and again, this might be more matter from Mr. Farrell, but in terms of references to environmental thresholds and biophysical limits, have those additions, has there been analysis of those against the relevant national policy statements? And I'm thinking more sort of electricity transmission and generation, those sorts of things.
I'm sure Mr. Farrell has thought about that.
Yeah,
because we know it's a very live issue.
Heads up, I'd be interested in comment there. Yeah.
And we also grappled with that in Plan Change 7. Yeah.
I think that's that's all from me. Thanks.
Thank you.
Yeah, thank you, Marie. I think you did very well to skirt around the freshwater thing.
Waiting to be told off.
You did highlight the situation we're in quite nicely.
Yeah.
Just going back to the definition of ecosystems, there is a definition in the RMA, isn't there?
Oh, yes.
Yes.
Yeah.
In the exposure draft has a definition, which is quite similar, I think, to what you've referenced.
Right.
The interesting thing I find about the definition of ecosystem, that includes us.
Yep.
And what we do.
Yeah, well, that's
So-
right. I could have gone further in terms of this, introduced species being part of ecosystems. Maybe there isn't. But yeah, I thought let's keep focused.
Yeah, and thinking about that, and I haven't got my head around it because, without predetermining things, that's a valid. And when I look at Sir Jeffrey's quote there, one of the things we're dealing with here is in terms of the assessment process for other ecosystems or significance. And you guys haven't focused, I think, on Appendix 2 too much, but there is a freshwater component in there.
Yeah.
I think, especially when you're talking about rare collapses and stuff. That's going, we've been told, well, the assessment point's got to be pre-human. We went trout in that here, so there's a little No, I haven't thought through the implications of that. Have you guys
Well,
thought through that? It is the introduced versus native species that you touch on, but is there wider implications of that?
There will be, yeah, and I'll think about it more and address you in May about that as well, because the, sorry, I'm just looking at the NPS freshwater.
Well, I think May is where most of our questions probably going to come from your witness, because when I read it, it was more, and if you've seen what we've been faced with reading wise, we go, we don't have to read that, we're not going to.
Yeah, I mean, pre-human
But I have read it all, but it haven't quite got my head around it.
Yeah, pre-human isn't a concept that comes through in the NPS FM.
No.
It's absence of human disturbance is the term in ecosystem health, and then that's qualified. You provide for that before you provide for the other values. So you still provide for the other values as long as that is not putting at risk what policy 9 effectively requires in the NPS FM.
Yeah. In what
There's a lot of human values in the NPS FM.
Yeah. What your legal submission has also done is taken us right back to the start of this hearing. We had quite a debate around bringing the freshwater principle to light and broadening it across the whole environment. And we had quite a lot of submissions on that, saying it was inappropriate to extend it across the wider environment for various reasons. And I think there is a bit of authority referred to, I think it's King Salmon, around really you have to have a specific issue before you can focus in on solid protection of one component of the environment, something like that. I don't know whether you've turned your mind to that. You would have seen probably those submissions.
I won't try and do that on the fly.
It might be useful in the land and freshwater thing. It's probably where it's more relevant from your perspective. I assume all that stuff will be up on the website.
Oh yeah, no, it definitely is. I've been diving in and out of that, so I'll give it a proper look.
Yeah, so I didn't really have too many questions, more that those things are probably going to be quite relevant in that May hearing. And I think you'll add some value to that. Yeah. Okay, thank you.
Thank you.
Morena. In exercises like this, I usually try to find 2 or 3 key things, key points. If you go more than 3 or 4, just tie yourself up in knots. So the 2 key things that I took out of your presentation this morning, and maybe there was a couple, there may be more that I need to highlight, and if there are, just let me know. One of them is very much tied up in Te Manawa Way, water quality. But that's subsumed under the more generic, holistic approach to life that you highlighted. And so I have the other, reading the evidence of the other witnesses here. So there's this common understanding and acceptance that the whole of life doesn't stop at the water. It doesn't start on land or vice versa, all that sort of stuff. So I think I understand that bit. The other bit was a bit more perplexing for me, and that is there's almost seems to me to be a fear that trout and salmon will miss out on all this, sort of the whole review RPS, if it hasn't already. I'm not sure that it has or it hasn't, but maybe I need to be enlightened a bit more about what is Fish and Game's sort of concerns about whether or not fish and salmon habitat is part. I mean, your demarcation between ecosystems and indigenous biodiversity, for example, that highlights it for me. And I'm reflecting quite a bit on Mr. Peregrine's evidence, about the fact, I mean, trout and salmon and being introduced into the country, the way in which, I guess, society as a whole has kind of defined the trout and salmon industry as a sport. And I mean, you keep making references to harvesting.
Mhm.
Now, I'm not quite sure what the difference is between harvesting and sport. I think I do, but again, maybe fishing game have a different way of defining all that. Would you like to comment more on that?
That's a great question. Well, one point I suppose is the Conservation Act calls them sports fish. So that's where that term comes from in a legal sense. But the fact is, you know, these guys will know more than I do. But the fact is that, you know, there's some anglers who do fish to get food for their family. Well, most of them. No, I don't know if it's most or not. Sorry, a lot of them. So it is about harvest. It is about gathering food. There are the other type of anglers who, as you're familiar with on the Nevis, they go to for the sport of catching the fish, but then they release it. So it's not about a food source, it's about an activity, interacting with nature in that way. So yeah, so there's those two different types in really general terms of anglers that the trout and salmon provide a resource in respect of for them. Yeah. Yeah.
Is there anything else I missed out? I mean, as I say, those are the two key points that I took from what you've given us this morning.
Well, the only thing we tried to labour the point that, and it will come up in the freshwater chapter as well, is that there is effectively a hierarchy between protecting Indigenous species and their habitat and trout and salmon, if protecting the habitat of trout and salmon puts at risk that Indigenous protection. But if it doesn't put at risk that Indigenous protection directive, there's an equally strong directive to protect trout and salmon habitat in both the Act and the National Policy Statement.
Whatever other questions I have, I want to direct it to these guys.
Right.
Thank you.
I just really wanted to raise, and I made it's a point that Mr. Cubitt's already had some discussion with you about, and I'd like you to think about, because you're obviously going to address this in May in more detail on. But reflecting over time since we had those discussions Mr. Cubitt's talked about, and it's repeated now in these submissions from yourself about this application or the proposed application of the NPSFM principles across the board runs, I would have thought, into a difficulty in that Section 6A is advocating the protection of all rivers and all wetlands, whereas Section 6C, when it looks at the terrestrial environment, makes a significant difference of that very word. It uses the term significant, the protection of significant areas. And so in base principle, it would seem to me that there's a very clear distinction, which has then been picked up by the NPSFM, where there's a very strong emphasis, rivers first, and the maybe of the freshwater first, and then the descending hierarchy before humans are allowed to touch it as the last in the hierarchy. So it's very difficult to see how you can apply that in a terrestrial sense to all Indigenous biodiversity. And what we're hearing from the generators or the users, if you like, of the terrestrial resource, whether it be the mines, the generators, the electricity generators, whether it be the infrastructure providers, whether it be the telecommunications people, they're all saying, look, you can't go doing that in a land setting, in an Indigenous biodiversity setting, because we have these linear structures, or we have these structures which are locationally constrained, and And further, they say, where is it in the Act that you've got authority to do that?
Mm.
And it comes back to the very point that I was raising with Sefton this morning, as to why it's so important to understand or get a proper appreciation in a legal sense of the difference between maintain and protect. So I'm not really asking you to respond right now.
No.
I just want to put out a challenge to you there. How do you say we address that difference between the Section 6A approach and the Section 6C approach?
Yep.
And when you look at too, if you would, Section 30, because again, the functions there that are imposed on the regional council in terms of indigenous biodiversity are to maintain. And when you look at those functions in respect of water, they're not as broadly worded. They're much more specifically worded, and I don't think they necessarily, and they can't really add anything to Section 6A because it's very much taking a preservation and ultimate protection approach. It's because of the very point you make that the state of the rivers and state of waters has been so degraded. So look, I really just wanted to emphasise that with you.
Thank you.
I don't think there were other questions that I had. I did, just on a light-hearted note, I did, when you were reading your paragraph 30, when you were talking about it would be inconsistent with the approach to attempt to silo out or separate out management of indigenous ecosystems from the broader ecosystems that include introduced species. When I just read this morning in the ODT about the finding of the new flathead, or the magnitude of the finding of the new flathead galaxid, and the necessity to ensure that it was protected in that particular catchment from these terrible predators who would wipe it out overnight.
Yeah, no, I'm sure Mr. Peregrine's got some comments to make.
So probably you
Positive comments.
You chose a bad day.
Positive comments. No, I don't believe everything.
I don't think there's anything else I needed to. I think the other things. I think questions in relation to the changes that Mr. Farrell suggested, I'll leave to Mr. Farrell. So, all right, we'll break for morning tea and come back to quarter.
Thank you. just prepared a written document just to draw your attention to the key points of their evidence that they want to freshen you up on. So hopefully you've got those in front of you now.
No,
Summary.
Summary.
Nigel's first. Thank you, Mr. Peregrine.
Yes.
Thank you.
Push the button. Morning. We have a start.
Yes.
So fishing game councils are required to produce sports fishing game management plans, and there is one each from the Otago Fishing Game Council and the Central South Island Fishing Game Council. As plans are developed under the Conservation Act, these are to be had regard to in this process. If I might stop there immediately, and I'll just talk quickly about the comment on harvest or sport. It is an interesting question, isn't it? It did become, what it really was viewed as sporting in the early days, wasn't it? I think as we've matured, is that the right word? People have come around to the idea of harvest, and certainly now in a modern fishing game, we are inclusive of both the sporting aspects and the harvest aspects, and people have different ideas about why they go out. I mean, Mr. Cooper and I are of different camps. I am a casual angler. I wouldn't go out unless I can bonk something on the head. And so I go out a couple of times a year and get myself a feed, whereas Jade is someone who's more likely to go out for a day and enjoy the fishing and enjoy the activity itself. So yeah, we really do try to be inclusive of both, which has its own challenges. I'll keep reading from that. A key direction from the relevant sports fishing game management plans is for fishing game to act as an advocate or monitoring body to identify habitat condition or threats and protect or restore habitat and ecosystem health. As a result of this direction and others like it, the councils have been heavily involved in planning and legislative processes to protect and restore habitat and to direct investment in habitat rehabilitation projects. This is most often for the benefit of multiple species, introduced and Indigenous alike. I've provided a list of prominent examples of these in my evidence at paragraphs 54 to 57. Fishing game takes an ecosystem-based approach to environmental management with a focus on protecting and restoring water bodies and aquatic ecosystems holistically to achieve a healthy state. Within this, there is a focus on the habitat as a life-supporting element of ecosystems. Sports fish and game birds benefit from such protection alongside other species within those ecosystems. For example, when we seek to protect or restore a lowland river because of a sports fishery, we're also thinking about benefits to other values such as tuna, pulleys, lamprey, and the intrinsic value of the river itself. All of this can be encapsulated in the one river system. There are instances where a focus on habitat is not sufficient, such as serious negative species interactions between sports fish and some Indigenous species. Interventions to manage such interactions require input from multiple statutory parties. Fishing Game is proposing a framework be embedded within the RPS, which enables those parties to plan proactively for interventions where necessary and take a more holistic approach to freshwater management when they're not. If you'll allow me to pause there again to talk about Ty Creek on the paper this morning, what the ODT neglected to mention, but I understand the staff reporting on the same project did mention, is that Fishing Game is a partner. And we are involved in these projects. We don't want to see extinctions of fish. That doesn't fit with the modern approach of fishing game and that holistic environmental ecosystem health. So we are looking to intervene proactively. And as I detail my evidence, we are increasingly doing that through time. Probably two important points to note on this. One, the research shows that in terms of the proportion of total river reaches across New Zealand or Otago and the places where we need to, or we feel we need to provide intervention, the intervention places are quite small. So I would probably assert that this needs to be considered along with the other statutory parties, that policy 9 and 10 would be a consistent thing to do in a lot of cases. The second thing that I would point out is that there is also good research to suggest that when you have a better quality in your water bodies and in your aquatic ecosystems, there's less need for an intervention. That is certainly not downplaying the need for intervention. As we see, it is very important in places. Certainly, some of the research shows that we can help the case by improving the quality of water bodies. So I'll pick up from paragraph 5. There are differing perspectives on the meaning of ecosystem health. These can be broadly categorized as having a focus on pre-human ecosystems, valued species and processes, and human-environment relationships. Taking a strictly pre-human approach to ecosystem health in the RPS makes it difficult to achieve healthy ecosystems in the presence of water body alteration from human activities, structures, or introduced species. However, the other perspectives may be more forgiving of anthropogenic alteration. I note that the ecosystem health compulsory value set in the NPSFM is inclusive of anthropogenic alteration, including introduced species, provided Indigenous species are not unduly affected. There is a clear link between recreation in the natural environment and the health needs of people. For angling and hunting, this includes direct contact with water, drinking and eating food harvested from water, and health and well-being aspects of being out in nature. For the latter, the health and natural environment relationship is articulated in New Zealand public health strategies and government reporting. This includes recommendations for physical activity, Kia Mana Wanui Aotearoa, the long-term pathway for mental well-being, and the living standards framework, which informs the government's well-being budget. Within the documents, access to healthy natural environments underpins the public's well-being. The term well-being is broadly used in these contexts as part of the public's healthcare in a preventative sense, helping people to stay healthy rather than relying on curing illness after the fact. Okay. That summary.
Thank you very much.
Yeah, thank you. For that. I was interested in your evidence, you know, really wide range of projects that you're involved in, which is really neat to see. Are you also involved in any projects around sort of fish passage and including or fish barriers to prevent trout and salmon passage?
Yes, I couldn't rattle a list off the top of my head, but it is a focus of the organisation as I put in my evidence. The Tai Creek example is probably a good one where we are looking to work with other organisations. As I stated in my evidence, there's 5 statutory parties really that have responsibility in this space. When it comes to these species interactions, it's quite a fractured legislative environment. A couple of years ago, Fish and Game adopted a policy on species interaction that directed its staff, Fishing and Tiger, I should say, that directed its staff to work with those other statutory organisations and other stakeholders, specifically to try and find these places where we need to intervene. There's a lot of work to be done, and essentially what the Otago Council is saying is they're keen to do it.
That's good. And I see this policy in the land and freshwater chapter, I think P14, which provides for, so you know, is about fish passage and appropriate fish barriers and that sort of thing. One of the things I noticed, you know, particularly given we're looking at the eco chapter this week, is that the evidence focused quite a lot more on the fish side of Fish and Game rather than the game side of Fish and Game. And I just wondered, I suppose, given we're talking about ecosystem values and all that sort of thing this week, we hear quite a lot about grazing impacts of ungulates on native vegetation. I mean, and I suppose I'm sort of thinking back to the bit of an outcry about deer culls. Was that last year, I think. I mean, I'm just wondering if you've got sort of any comment on that, or or is there sort of any work going on to ensure that game populations aren't having too much of an adverse effect on Indigenous,
Yeah,
particularly Indigenous vegetation species, but it goes wider than that. I mean, you see pigs can be pretty destructive,
yeah, absolutely.
not just to vegetation, but also to, birds and other Indigenous species as well.
Yeah, particularly wetlands, wallowing and
Yes.
wetlands can be quite
Yeah.
destructive for pigs. The game and fishing game refers to game birds. It's
Right,
older
okay.
language,
Yeah.
which is a little bit deceptive in the way we use our language in the modern sense. We have a few species of upland game, but fishing games on the game side, fishing games focus is mostly on waterfowl.
Yeah.
And really it's habitat extent that is a really important factor for waterfowl. We've all seen those figures of wetland loss across the country and across the region, and they're quite staggering. So there are specific provisions that Fish and Game is seeking within the pORPS provisions, which look to protect wetlands that are remaining and restore wetlands. Mr. Farrell, I'm sure, can run through some of those in more detail. And I think Mr. Cooper also does provide some of those statistics for the loss of wetlands. Conscious of the discussion before about to what degree we can delve into that. There is species interaction. Species interaction is between human uses and game birds that is of interest that fishing game councils do manage. It's usually around the agricultural industry. A number of game birds, for example, paradise shelduck, are herbivores. They're known to eat pasture. And so we every year we issue licenses to disturb or licenses to kill, so that farmers can protect their crops from game birds. There was also a number of years ago, before I joined the Otago Fish and Game Council, quite a debate over whether Canada geese should still be on the game bird list, and it was decided they should be taken off. So that's no longer a game bird species that Fish and Game manages, but we did do quite a number of culls prior to that them being taken off the list for that exact reason.
Yeah, I know in Christchurch populations since the earthquake have exploded. They quite
Yes.
like the red zones.
Yeah.
Lots of grass and
Yeah, they do.
yeah, okay. One other question, and you might be able to point me to where this is. I see you talk about the ecosystem health compulsory value and the NPSFM being inclusive of an anthropogenic alteration. And I was just having a look at that, and possibly because I skimmed it, I can't quite see that. I suppose refer to the Appendix 1B, the other values that need to be considered, so not the compulsory values, and that's where fishing comes into it, which was mentioned in the legal submissions as well. Is that somewhere else in the NPSFM rather than in the Appendix 1A?
I can provide you.
Might not be something you can answer.
I can provide you with my high-level thoughts. Bearing in mind that I'm not an expert witness on this, might be would also direct the question to Mr. Farrell. What I would say is that I think of the ecosystem health compulsory values broken down into three parts. The first part in the first paragraph refers to the extent. So the ecosystem health value refers to parts of anything which support an ecosystem appropriate for that type. So it's just an ecosystem as a whole.
Yeah, not specifically Indigenous.
Not specifically Indigenous, not specifically not Indigenous, it's just ecosystems. There's the second part of the biophysical components. And if we go down to, so water quality, water quantity, probably don't have Indigenous or non-Indigenous elements to it. Habitat certainly can have an Indigenous or non-Indigenous element to it. And certainly aquatic life has an Indigenous and non-Indigenous element. And under the aquatic life entrance, there is no qualification of that we're only looking at Indigenous or not. And then if we go to the third part is, I don't know what you want to call it, a benchmark, a direction at the bottom, which directs that in a healthy ecosystem, all 5 biophysical components are suitable to sustain indigenous aquatic life, expected in the absence of human disturbance before providing for the other values. So Ms. Baker Galloway talked about in her legal submissions how she views that that does provide for non-indigenous species to be part of a healthy ecosystem. If we were to put it in a different context, like say a water abstraction context, or the science, as I understand it, certainly does support the ability for abstraction from a healthy healthy aquatic ecosystem. It's all about proportion. You take too much, you dry it up, and you make it really bare. You don't take much, and you can still leave quite a lot of water in the system to sustain indigenous aquatic life or other aquatic life.
Yeah, okay. No, thanks for that clarification. That's helpful. Thanks.
Thank you.
Yes, thank you, Mr. Peregrine. I found your evidence very enlightening and helpful. And I guess, given your accent, the introduced versus native species thing is quite important to you. Oh, yeah, no, we've had a lot of Australian plans here in front of the section. Originally Australian.
Yeah.
Just sort of following on from that discussion around ecosystem health, and you talk about the reference states in 83 and then going on 87, and this is probably more relevant to that May hearing, I guess. It's around, and you've noted that it's highly unlikely that you could ever achieve sustaining pre-human ecosystem elements. And I haven't gone back into your submissions on particularly policy 14 and land and freshwater thing. Is there any inconsistency with that position with what Fish and Game are promoting? It may not be appropriate for this hearing, I'm not sure.
Let me
Because I know that policy talks about restoring natural character and various natural states and rivers, which is virtually impossible in Otago's river systems now.
Yeah.
Is that sort of what you're referring to?
Yeah, I think there's a couple of points within that. So, firstly, Fish and Game has sought that we add and in-stream values. So we read the title, we're restoring natural character and in-stream values. And of course, there is a wide array of in-stream values. And we've, as you might imagine, not being specific as to what those in-stream values might be. That's the thing that future plans might decide. So I think that's really important for the holistic and integrated approach to managing water bodies. The second part is around restoring, and I think it's a really important point. What is our baseline that we're assessing our adverse effects against, and what are we trying to achieve? Fish and Game has tried to address that point by providing a definition for restore. The criticisms, as I understand it, and that's relatively intentional, which is to restore to a state of good health. But that is aimed at trying to assist in this question. What position are we getting back to? And certainly the mindset for Fish and Game is not one where what we're getting back to is pre-human. That seems like it's in most cases probably not achievable.
It wouldn't work for Fish and Game anyway, because what you manage isn't pre-human.
Yeah. In some cases, so paradise shell duck, for example, would benefit from that. But in most cases, it's probably not helpful. What we will get to in the next appearance is what those baselines might look like, and we'll be providing some additional information, which hopefully will be of assistance around that and around our relief on that one.
Thank you. The only other thing I just wanted to talk to you briefly about, as Bianca said, you involved in quite a few interesting projects, but in your paragraph 40, you, as an example, you used the lower Pomahaka in terms of water quality issues, and you quoted a report, I think that was from 2010. And I'm just wondering, because I don't know, you'll know more about this than me. I have a feeling that it may have been that report that's prompted quite a bit of work in that catchment from catchment groups have formed. And I just wonder if since that report's done, has any follow-up been done in terms of what the work they've done? Has it improved water quality and all those sorts of, whether that there's been follow-up? So I know it takes a while for that to translate into improved water quality, but
Yeah,
we've heard it, we're going to hear a lot of evidence, and probably started reading quite a bit of the ORAD stuff that the actual users of the water talk about this approach to it.
yeah.
I just want to know if, from your perspective, has this actually had any measurable gains?
The Pomahaka Watercare Group is an excellent group. It's one that Fishing Game has been supporting both by turning up to the meetings and being involved in the discussions and the work, and also we've supported them financially. It's a model that I think is very helpful.
So I'm supporting them. By paying the license.
Yes. Yeah, it all gets a bit incestuous, doesn't it? So the in terms of has there been any effect, I know that the Pomahaka Watercare Catchment Group has been monitoring as they go along. I wouldn't want to speak off the cuff in case I get it wrong for them. What I would point us to is the state of environment monitoring for the regional council. I know Mr. Cooper provides some information on that. I can't recall whether the Pomahaka is part of the Lower Clutha FMU or Rohi, or whether it has its own.
I think it's part of the lower.
The Lower Clutha.
Yeah,
The Lower Clutha.
I think so.
In a 2020 State of Environment Monitoring report stands out because 100% of the sites that were monitored did not meet one or more national bottom lines as set out in the NPSFM. So that's not great news, I think. That's not to say that the efforts of these groups is in vain. That's just simply the results that have been reported in that year by the regional council.
I recall reading that evidence, and I looked at the Lower Clutha in relation to another issue a while ago. In my memory, it did actually meet all those quite high quality bands, but obviously something's changed.
Yeah.
Because I noted that, and it was just phrased as a way that I couldn't quite understand, but it's probably for that next hearing.
Yeah. There is a 2020 report that's cited.
Yeah.
There's a 2021 report, but also by the ORC, that has much better results. And it was put to me one day, oh, look at the improvement we made in 1 year. It turns out that the two reports look at have different standards. So one from the 2020 report is looking at the NPSFM water quality standards, and then the one from 2021 was looking at the current water quality standards. I think it's Schedule 15 of the regional plan of water for Otago. I mentioned that wondering aloud if that's the work that you have viewed.
Yeah, I'm not sure. I'll go back and look at that before next hearing, because I think it might have been Mr. Cooper's evidence or someone's that I did read that. I don't know if that doesn't align with what I understood to be the case. But, yeah. No, thank you for that, and we'll see you in May.
Thank you. Don't mind me addressing you as Nigel.
No, I love that.
Cool. I'm going to cut straight to the quick and paraphrase your paragraph 33, which starts crucially, the failure to take a partnership approach with mana whenua was a significant omission in the early introduction of and management for trout, right? And then you say, and then you go on further on down, and I'll go down to paragraph 84, I think it is, where you then come back to the question. But your comment was quite enlightening in that it remains a vexed question, isn't it? I mean, no matter how you approach it, everyone will come up with a different view on how to manage it. And I don't think the issue of introduced species like trout and salmon will go away, because it's now an accepted part of our life. including mine, which is kind of what I'm sort of getting to. And I quite like your comment where you say, provided the benefits of their presences are accessible, distributed fairly, and able to sustain cultural practices. I wonder if you wouldn't mind just elaborating a wee bit on just that last bit.
Yeah, so I should say I also like that.
Yeah.
Like that quote. It's not my words. They come from a report that's out of the Fish Futures. I don't know what they call it. Project is what they call it, which is a trance of research work looking into the future, the way fisheries will be managed in future. That does have heavy involvement from Mana Whenua, as well as a wide range of disciplines, scientific disciplines. And I think you really do see that when you read through their reports. In terms of this piece of evidence, I put that scene setting piece in around partnership very intentionally, I think, to recognise, to call a spade where acclimatisation societies might have done wrong in the past. How we go forward is really a question for Mana Whenua and Fish and Game, how Fish and Game gives effect to its Section 4 of the Conservation Act requirements. So I wouldn't want, I'm not aware of those discussions of being had in Otago. There's certainly something which I personally would promote being had, and I wouldn't want to predispose what those outcomes might be, if you know what I mean.
I think it's an important one, because I was going to follow up with a question you partly answered around how might this process help that question, help address that question?
Yeah, I think this pORPS process can be really powerful in resolving one key issue, which is around species interaction.
Yeah.
So we, as I mentioned, my evidence I mentioned before, we have this fractured legislative arrangement around the management of fisheries. And when something goes wrong, there's no one party that we can look to resolve it. We have to look to a wide range of parties, including treaty partners. By embedding within the pORPS a mechanism that aligns the RMA processes and the Conservation Act processes, we can actually start to get some of that integrated management working more, hopefully. And my hope is that would lead to a more proactive approach to the issue. And also, I'm a big believer personally in relationship building through osmosis. As we start to work together, maybe we can start to heal those fractures from the past and find that way forward.
Yeah. If you look at it another way, I mean, I'm referring here in particular to Mana Whenua, which is Kaitahi, right?
Mm.
Now, they cover the vast majority of the whole of the South Island. It's not just an Otago thing, but it is quite prominent in the Otago context, in the Canterbury context, the whole thing around trout and salmon fishing. Maybe not so much in the North Island, but it's there. But in my experience in hearings like this, it's more prominent in this part of the world. And I can't help thinking that maybe there's an opportunity here for a process like this. And given that you're only dealing with one iwi, just Kaitahi, you don't have to argue with any other iwi. So when you go to other parts of the country, you've got to argue with about 3 or 4 different iwi in one location. So whether there is scope there, a greater scope for this kind of conversation to better address this issue around trout, salmon, tuna, you know what I'm talking about. But even more than that, the opportunity to do so now, being able, someone could just grab it by the neck and throttle it right now would be quite it would be an achievement that a process like this might you look back on it and say, yeah, we did it in 2023 because we had the boldness. I was going to use a different word to just grapple with it in a way that maybe we haven't had the opportunity to do it in quite the way that we might now through this RPS process. Do you have a view on that? Do you have any comments on that?
Certainly the fishing game attempt around species interaction is trying to be bold. We're well out on a limb compared to what other fishing game councils around the country are doing.
Yeah.
We're trying to demonstrate that giving effect to the MPSFM, bringing these fractional legislative arms together can be done in a way that that achieves integrated management and is holistic, and brings all the voices together. There are certainly other, that's not the totality of the Conservation Act Section 4 issues that might need to be discussed between Mana Whenua and fishing game councils. There will be a limit to what we can do in this RPS process. For example, we can't talk about licensing structures or cultural harvests in this document. I assume maybe I need to take legal advice on that, because the Conservation Act issues. But certainly we can do our best to bring those two documents together in a way which provides some sort of longevity.
And I just to finish off, if you go to your para 87, I don't want to read the whole lot of it, but I'll read the last bit of it, where you say, I find it unlikely that could ever be achieved fully.
Yes.
Yeah. What makes you say that? Yeah? What do you mean by that?
If we take a pre-human perspective to ecosystem health, in order to fully achieve ecosystem health, to be 100% top of the carpet level, you would need to, I think, remove some parts of the environment which the public probably would not agree to, like removing the people or the cities or the farmland. So I think in that sense, it's probably not practical. In another sense, there have been extinctions, not many in the aquatic sense, but in the terrestrial sense, there have been extinctions, and there is no way to put those species back. So that in and of itself is really problematic for a pre-human perspective on ecosystem health. It means you can never get to the top. You can never achieve ecosystem health fully. That said, you could think of ecosystem health as an envelope. And I will imagine the criticism of what I've just said is that you may be able to achieve ecosystem health that is good enough, within that envelope. I spoke before about how in the freshwater sense, you may be able to have some sustainable level of extraction of water. And I truly believe that we can have, in many cases, extraction of water in a sustainable, healthy ecosystem. It's about scale.
I don't know if you heard our hearing yesterday, but I made a comment yesterday about having the guts to actually face issues head on. Yeah. And which is why I think the way you've couched your submission is in this particular issue I'm talking about. I admire the way in which you've taken you face the issue head on. Don't necessarily have the answers. I mean, that's for everybody else to work with, but I thank you for that, because it was good reading for me. So thanks a lot.
Thank you. I really appreciate that.
Only a few matters. I must admit, and Commissioner Solomon's already addressed with you the statement you made in paragraph 6 of the summary statement you gave this morning, because I was aware that in that ecosystem health compulsory value is in the absence of human disturbance or alteration were there specifically, and which seemed to conflict. So I was interested in the response you gave to her. But just looking at that value, that compulsory value, I've always found it difficult to understand that that phrase being included when you've got, and Otago's the classic, when you've got major dams that have been in for decades, and how on earth you sort of ignore those and talk about the absence of human alteration. It's a reality of what the ecosystem is at the present time.
Yeah, I guess where some of those activities have consents, they're not permanent activities, is probably one of the things that I would say. Not completely forgotten this, the
And
second
the whole
one.
of them, I mean, the whole of the morphology though, in river systems has been changed by the dams.
Yes, it has.
Sedimentation on massive scale it's occurred.
Hmm.
Now I'm probably talking rather than answering a question. So getting to some questions, just not the things that probably have arisen through the course of the day. Ty Creek, what does it flow into? What catchment?
It's in the Katrina.
In the
In the Katrina.
oh right. Okay.
I actually do recall what I was going to say in response to your previous question, if you're happy for me to double back. One of the key points of the fishing game submission is the phrase, all activities support the health and well-being and resilience of water bodies. That one is particularly close to my heart, and it has come from the RTT decisions from the Southland Water and Land Plan interim decisions. The positive obligation of parties and people acting in the environment to support the health and well-being of water bodies, and if the panel were inclined to make that a wider consideration to the environment, is a paradigm shift compared to the way that we have been viewing natural resource management in New Zealand today. And I think one that will be very helpful, because it is a different question if we ask ourselves, what is the adverse effect of these dams and how do we remedy, mitigate, or avoid them, compared to how do these dams support the health and well-being of the water bodies? And again, we might view the health and well-being of those bodies as having an envelope of good health, which those dams may or may not help us to stay within. I'm reluctant to make a clear, distinction on where those particular dams might sit, just because we don't have all the information in front of me right now. But as conceptually, I think it's a good example to demonstrate the difference in those two approaches and why why paradigm shift is so significant in my mind.
Well, that's a relevant observation to the bigger issue that we're being challenged with, where the generators are saying, look, as a nation, we've got a target of carbon net zero by 2050. That's a bigger issue in terms of effects in the longer term on Indigenous biodiversity than anything else, because how on earth do you respond to that? To respond to it by alternative renewable generation, you're going to have an effect, you're going to have lesser effects, but you've got to allow them to enable the greater effect to be achieved, and or the greater protection of effect to be achieved. Yeah. Now, final question really was just the Canada geese response that you gave to Anchor Sullivan. So who's charged with the statutory control then of those? Does it fall back on the regional council?
I'm not aware that any one authority has taken on the responsibility. It's just been taken out of the hands of fishing game councils.
So who runs the Molesworth hunt, for example, each year?
My experience has been that individual landholders and groups of landholders have got together to do it as sort of a grassroots approach.
Right.
There would be the option for a regional council to do it if they wanted to include it in their pest plan. I don't know if that's something that they're interested in doing. There have been recent culls. I'm aware of one recently in the Maniatoto But again, they're disparate. They're not necessarily organised across the region or country, as they may have been when they were under Fish and Game management.
Right. Okay. Well, and the final thing is just to comment that you've had a pat on the back from Ray Kirikiri for being brave enough to front up to the fraught relationship in the past with the Māori, but I'd like to pat you on the back too for having the courage to come along and say that it's okay to catch a trout and knock it on the head.
Thank you, appreciate it.
Mr. Cook.
So,
So long as you're still speaking to us when I acknowledge that I'm not the odd traveller.
no, I do too. Yeah, less than I used to, but yeah, pretty regularly.
Right.
Yeah, so I'm Jade. I work for Otago Fish and Game, and I've just got some notes to talk through. So within the Otago region, Fish and Game manage the recreational fishing for 6 species of valued introduced fish and hunting of 2 upland game species and 6 species of waterfowl, 4 of which are native. Popularity of fishing for these species is even at Otago, where the sale of fishing licenses has surpassed 24,000 licenses in all categories, out of which more than 12,500 are whole season licenses. License holders devote a considerable amount of time to fishing, with surveys indicating up to 218,000 angler days in the Otago region alone. Though less popular than freshwater fishing, game bird hunting is still a significant recreational activity, with up to 82,000 hours spent hunting waterfowl and 8,800 hours spent hunting upland game in the Otago region. These pastimes don't just provide recreation, they also contribute an important food source for the community. Several factors can influence the enjoyment of the recreational resource, but the most crucial one is the preservation of aquatic ecosystems across the region. The state of Otago's aquatic ecosystems can be broken down to 4 key components that make up the foundation of waterway health and can provide an indication of anthropogenic deterioration. These are water quality, water quantity, the species present and their interactions, and the physical alterations of the water bodies. These components cannot be looked at individually, and their effects can compound together. Diminished water quality can make waterways less appealing for recreational activities, hazardous for consumption, and can lead to a decline or exclusion of fish and invertebrate populations. In general, there is a robust evidence of degradation in multiple waterways around the region. Water quality in the region falls below at least 1 MPS FM bottom line at 63% of sites. The pattern of water quality degradations, however, not uniform across the region. Typically, high or mountainous waterways under native forest cover tend to have higher water quality, while low elevation waterways that drain pastoral or urban areas tend to have lower quality. Concerningly, across the region, the 20-year trends were predominantly degrading for all water quality variables, apart from ammoniacal nitrogen. Issues with water quality is not limited to surface water, and there is also strong evidence of declines in the groundwater. Water abstraction, particularly during low flows, can have adverse impacts on the health of waterways. It can result in reduced invertebrate production, increased water temperature, the disruption of migration pathways, and the concentration of fish species, leading to higher predation. There is evidence that relative to the amount of water available, there is a large amount considered to be abstracted. Physical manipulation of water bodies is common in the Otago region. Of particular concern is the proliferation of fish migration barriers and the ongoing drainage of wetlands, leading to a loss of ecological values and downstream negative effects on water quality and quantity. Fish and Game's efforts to safeguard and improve aquatic ecosystems and access to them are not only advantageous for sports fish, game birds, and license holders, but they also contribute to the overall health of ecosystems that support various other types of recreation and promote healthy populations of native species. The ecological values sought by Fish and Game are also essential for the needs of indigenous species. In particular, salmonids require high water quality and flow, and meeting these values can also provide healthy native fish populations in most cases. Fish and Game protection and enhancement of wetlands not only benefits downstream water quality, but also ensures the preservation of many native bird species. Just a brief summary of my evidence.
Thank you, Mr. Cook.
Yeah, thanks. Thank you, Mr. Cooper. I do have several questions on your evidence, but from looking through them, I think most of them are probably relevant to wait until and there's probably one or two I have in there that I might get in trouble if I asked to, because I suspect to be more in relation to some of the water quality and quantity matters. But I did just want to raise a matter that I raised with Ms. Baker Galloway as well around the definition of Indigenous ecosystems. And I take the points that you made at your paragraph 129 of your evidence as well there. I mean, have you seen a definition somewhere? And I'm not sure that it's within the scope of submissions that we've got here. Are you aware of any definitions of Indigenous ecosystems where it does sort of refer to a proportion of Indigenous species? I do recall seeing something somewhere, but I can't off the top of my head recall where.
Yeah, I'm not aware of any. I did search. I wouldn't say I pulled through local plans or anything, but certainly looked online for anyone else that had defined that term.
Check. No, thank you. I think I'll leave my questions till May. Thanks.
Cheers.
Yeah, thank you. I'm probably pretty similar, but I've got just a couple of questions that, because they do sort of relate on this, but and I'm always very weary about statistics without context, and we get a lot of statistics thrown at us. And just in your summary at 10 and 11, we talk about the bottom lines in the region falling below 63% of all sites. I'm assuming that's tested sites, because you go into 11, and I'm assuming most of those monitored sites would be in the lower elevation waterways, because you're not really going to bottle up the heads in the conservation estate. Would that be the estimation?
So those statistics are relying on the Ozan papers at 2021, 2020. And I know, I think it was in a presentation around that report, she noted, and I think I say it somewhere in my evidence, that those sites are representative of the region and of the waterways.
Okay. Representative, right? So they are, it's just from certain, is it based on ecological districts, or how is it being done? I can't recall your evidence on it.
I'm not exactly sure how they would have set up their testing protocols.
That's
I imagine at the end of roads.
Freshwater, land and freshwater question anyway. Sort of in the same vein, you talk about Otago being a hot spot for freshwater fishes in paragraph 87, and you follow on from that around the rarity and importance of the native fish there. What does that mean in the context? What is a biodiversity hotspot, I guess? And is it because Otago is relatively unique, because it seems to have a range of different habitats because of the nature of our climate compared to the rest of the country? And I guess that translates possibly to the water bodies as well. And you could also argue that maybe, well, we have those rare fish, etc., because we haven't been fully developed like perhaps places further north. So we actually, even though we have a high rate of rare things, it's because they're hanging on here, whereas in other places they're not, they're gone.
Yeah, I'd say the geology of Otago probably has a lot to do with it. Steeper catchments, you get little geological units where things evolve in different directions. I know some rivers have changed directions and created little pockets of now quite rare glaciers. So I think that's got a lot to do with it. But yeah, it's quite impressive the number of species that are in Otago.
So it is geology driven, really, rather than maybe not as much development.
I would say, yeah, a lot of it's geology. And possibly a lot of that land isn't able to be developed because of the steepness.
We've always thought about special undertaking.
I think we are.
Just sort of following on to that, in your, it's on page 24, sort of related to that issue, and you do touch on the pre-human sort of issue as well, or how you measure the start point, but you talk about the conversion of tussock land to pasture, reducing catchment water yield. I think that's a 2006 report. Then below that, talking about agricultural intensification, which comes out of a 2010 report. In your experience, what's happening in that space now? Because we've heard a range of ecological evidence around, some people saying, well, it's still going on. Some people saying, well, no, not much of that's happened in the last 10 to 20 years. What's your experience around that particular issue?
So in terms of conversion of,
yeah, because that seems to be the major habitat issue in Otago, from what I can gather from reading the evidence of the ecologists. This conversion of tussock land for agriculture is probably the big concern now.
yeah, and that intensification that goes along with it.
Yeah, is that still going on at a rate?
I would struggle to give any sort of long-term perspective on the stats of that.
Yeah.
I'm sure they'd be available. I believe it is still happening, but probably the rate is slowing down.
Yeah, and that might be related to, it's a little bit more difficult to get water rights nowadays.
Yeah, could be.
Yeah. No, thank you for your evidence. But we'll talk more about it in May.
Great.
Fiona, I'm curious about your definition of Indigenous ecosystems. I mean, in fact, you had to go to a dictionary first to find where the right definition was. But more than that, I suppose, as where you ended up, you know, at the bottom you said habitat or ecosystem is preferable to the term Indigenous ecosystem. Would you like to just expand a bit on that? I mean, you say, according to the definition, there will not be any Indigenous ecosystems in the Otago region, for example.
Yeah. So I got asked to comment on this, and I thought it was quite an interesting sort of thought exercise, thinking about where an Indigenous ecosystem would be. And yeah, I did come to the conclusion that I couldn't think of any. Just ecosystem is such a wide term, and humans have sort of got their fingerprints on everything, really. As I say, climate, things like that. You can remove all the water abstraction from a waterway, but you've still got drained wetlands and introduced species on the banks, and yeah, even at high altitudes, maybe introduced invertebrates. Couldn't say that they're not there.
So is this just playing around with words, or does this actually mean something?
I think it does. Well, I'm not a planner, so I don't know where the term comes into things. I try to stay out of that. Yeah, I guess it's where do you draw the line of what an Indigenous ecosystem is. And ecosystems can and do contain introduced species and still are healthy.
So drawing the line, I mean, what line are you trying to draw here?
Essentially that I was uncomfortable with the term, because I think, as most people would define it, it doesn't exist.
Yeah, as I said, I was just curious as to why there was a whole section around just defining a word like Indigenous ecosystems, although part of this exercise is around defining any number of words or you know, sort of used words. But grabbed me, particularly when you can make quite emphatic statements like, you know, Indigenous ecosystems just been non-existent in the whole region. And for a non-expert like me, I said, what does that mean? You know, is there something wrong with the overall system or what?
Yeah, I don't think we can get away from human's effect on every single environment, especially with climate change, rainfall.
Okay, thanks very much. That's all I have. Thank you.
On that issue, and Mr. Peregrine had drawn attention to the use of the word extent in the compulsory values of ecosystem health in the NPSFM. And just reading that opening paragraph in there and following on from the discussion with Commissioner Kirikiri, it says this refers to the extent to which an FMU or part of an FMU supports an ecosystem appropriate to the type of water body, for example, river, lake, wetland, or aquifer. It's almost pointing at a localized type of ecosystem, whereas what I rather gather from the paragraph reading your paragraphs 127 to 130 and your discussion with Mr. Kirikiri, you're struggling to separate out a small area. You're saying really you've got to look at everything's interrelated, and humans either introduce things or hadn't put their imprint on the way it all intermeshes.
Yeah.
Am I understanding you correctly?
Yep.
Yeah. So your proposition really is you can't divorce or separate out all these small areas and say, oh, that's an ecosystem on its own.
Yeah, I think that's incredibly difficult. Yeah, everything's related. Yeah.
Right. I found both your evidence, Mr. Peregrine, very informative. Thank you. And I don't think I've got particular concerns that I need to clarify. Oh, there was only one thing, a couple of things right at the end on page 32 that I had queries by. The list A in Index 1. I know we're not supposed to go there because it's coloured blue.
Oh no, well, it's not even that simple. That is a May point,
Is it?
but it was coloured blue. So
Yeah.
I'll address you about that in May if that's okay.
Okay, that's right. I'll leave those. What else? Oh, yes, I did have a question at paragraph 27. Just the effects of, well, it's more in paragraph 27, really, it's the whole of your passages about sedimentation. So when we've read other evidence in relation to the effects on morphology of these rivers, particularly behind the Clyde and the Roxburgh dams and the colossal deposition of sediment, has that had an effect on trout species in those locations upstream of the rivers, of the dams?
As in sedimentation depositing behind the dams,
Yeah.
is it affected?
Has it been measurable from Fish and Game's viewpoint in terms of effects on trout spawning or?
So a lot of trout spawning is inside tributaries, so it'll be less affected by that. And a lot of that sedimentation is going to be in the lakes, so it's going to be less noticeable. But say like Lake Dunstan's a good example where it's got the two arms, and essentially one is clearer, has more cobbles, gravel sort of stuff, and is a lot more productive for trout. And the other one, the Kawerau arm, is essentially fished a lot less because it's just not as productive. And that's likely due to the sedimentation in that bridge.
Yeah, okay. Thank you very much, Mr. Cooper and Mr. Peregrine. Thank you.
Yeah.
So then we've got Mr. Farrell. It's got a brief summary as well to draw to your attention.
Thank you, Mr. Farrell.
Good morning, or good afternoon, perhaps. So just to clarify, this summary is a summary of the key themes of my evidence. I'm not going into the specific recommendations or the specific provisions which are set out in my evidence. Just the first note there, I do support the amendments that Fish and Game is put in their submission, where if I haven't commented specifically on my evidence. So just clarifying that point. So in terms of providing for the development for the health and well-being of people, the significant resource management issues for the region section currently provides a one-sided approach to sustainable management and should be amended to acknowledge the regional significance of the use and development of resources. I support inclusion of one new section as recommended in my evidence. And this is with or without the addition of the two new issues indicated in the two planning JWSs that I've been involved in. Recreation has significant direct benefits to human health and well-being, and I consider this relevant under Section 5 of the RMA. The RPS should be framed to ensure that the benefits of recreation to human health and well-being are recognised and provided for. In terms of integrated management and prioritisation of using resources within limits, I remain of the opinion that it's appropriate for the RPS to require activities to be undertaken subject to limits. In short, reference to using resources subject to environmental limits is an important paradigm shift that needs to occur to avoid or reduce the risk of our natural systems reaching tipping points. Prioritising the health and well-being of the natural environment is appropriate, particularly if it is reflective of the resource management approaches promoted by Otago's Reno. Consequently, all activities and development should be subordinate to natural environmental limits. And there should be no carve-outs, for example, from policy IMP 12, including in respect of renewable electricity generation and the national grid. However, I do acknowledge that in some cases it will be appropriate to allow limits to be breached or exceeded, and this is namely in response to climate change mitigation. Policy IMP 12 is appropriate in this regard, although I recommend an amendment to that policy. Just in light of Commissioner Sullivan's question earlier, or potential question around national directions, I'm not aware of any national direction that says renewable electricity generation or infrastructure should not be subject to environmental limits. The closest we come, I think, is in the National Policy Statement for Fresh Water, where there is direction around providing for large-scale hydro when setting FMU limits. But there is no carve-out of complying with limits. There's direction to consider the large hydro schemes when developing the limits. In terms of reconciling policy tensions, it's my opinion the RPS should attempt to reconcile internal policy tensions as far as possible to improve the effectiveness and efficiency of decision-making processes made under the RPS. If the RPS does not reconcile internal policy tensions, including those created by national policy directives, then I question the efficacy of the RPS in decision-making processes. In respect of Te Mana Wai, I agree with ORC and Runanga that giving effect to Te Mana Wai is fundamental to the RPS framework. It's become apparent to me that implementing Te Mana Wai will require education, upskilling of practitioners and people involved who use or affect water to better understand what this concept means. It is therefore helpful, but not necessary for the RPS to include provisions clarifying what is and what is not Tier 1 and 2 priorities. And I'll just point out, I don't recommend specific relief in respect of this education aspect, but my commentary here comes from paras 23 to 29 of my rebuttal, where I'm responding to other planners' evidence who are recommending methods around the implementation of Te Manawa and what this means. And so I don't have specific wording or relief, but I support the idea in principle. And that's my summary.
Thank you, Commissioner Sullivan.
Yeah, thank you. Just having a look through, I think you're in luck. The questions that I did have for you have already have been covered off pretty well. So you're off the hook from me.
Yeah, thanks, Ben. I had some, and this is no fault of you or your team, but when I was reading your evidence, I was probably confusing some of the Wayfair stuff as well. And just for clarification of they tuning up at the land of freshwater.
No, they've just appearing once. And sorry, just to remind the panel might not be aware, but Mr. Farrell's not coming back in May either because he'll be down TT.
Oh, can we put an order in? Farrell this year, then put an order in.
Just a dozen will do.
Yeah. She's going to tell us off later. From the Fish and Game perspective, I think the evidence is very clear, and I understand it. Well, I guess I can I ask questions around the other?
Yes,
Yeah.
yes.
Because it's sort of that wider benefit thing, and I think you supported in your rebuttal Claire Hunter's recommendation for an objective that kind of reflects the wider social and economic benefit needs of communities when managing ecosystems, which I think does kind of relate to fish and game as well. And I'm not sure if you've seen, she has recommended a redraft of the section which includes that. I don't know if you've seen that at all, Ben?
No, did you say no? I don't know.
Probably reflective of what was in her original evidence, and that I guess that dovetails into that Eco P8 recommendation we are providing for subdivision use and development in support of 1, 2, and 3. But from looking at that, it seems to reflect the exposure draft of the IB MPS. The other question around that was in your Eco P5, this is in your evidence in chief on page 22, you recommended some additions to that, and it's probably not fish and game relevant, probably more Wayfair, but it's the expansion. So it's that provision that's purporting to provide for existing uses within significant natural areas. I think you've promoted them using expansion and also or an anticipated land use. And I understand that's in the context of ski fields, but it has a wider implication, I would have thought. I'm just wondering how you thought that might work in a lower water planning document. Would it be a structure plan approach? I mean, that would be easy in the ski field sense, but if we were thinking about how a farming operation might work, I guess, yeah, then we're getting into freshwater plans for farms, but what were you envisaging would happen there, I guess?
It really is or is intended to reflect zoning.
Yeah, oh, okay, yeah. It's quite specific to significant natural areas, this policy though. So you're saying the ski field will have a specific zone, and I guess this applies potentially to Macrae's as well, because of the same sort of argument there.
Correct. And it's not just ski fields. It's anywhere where there's existing lawfully established development or lawfully established development rights through zoning, for example. That's what I was intending to capture.
Yeah, and I think in that context, because I've been trying to exercise my mind how what does this offer over and above section 10. I think what you're promoting is a recognition of these things are here. They're actually here because they need to use this particular environment. So we need a mechanism in those lower order documents that allows you to address those in a spatial sort of context through a zone or some sort of management approach, adaptive management approach. Is that where you're heading or where your thinking's heading?
Yes.
Yeah, thank you. I think apart from that, I think we had discussions on a lot of these other issues earlier in the hearings process. So, no, thank you for that. That's all I had. Thanks, Jen. Apart from the audit.
I don't have any questions.
Yeah, just a few questions of clarification if I can. Just page 23 of your evidence, under the heading reason, right at the top of the page, you're talking about the ski areas, etc., may contain SNA, especially in the future if significant ecological restoration initiatives are established, such as at Walter Peak. Can you just explain that to me?
I can, and also feel free to ask Ms. Baker Galloway. The land at Walter Peak, if you are familiar with it,
Only in general terms.
If not, it's a pastoral farm landscape, and if you might recall evidence of Paul Norris, I think he talked about conservation initiatives that Real Group undertake, and they have undertaken considerable revegetation on the peninsula, and to the extent that I would anticipate, in short time or medium time frames, the ecological restoration that occurs there will be such that an ecologist will come along and say that's a significant natural area.
Right. So is that native plantings?
Correct.
Right. Thank you. Just at page 25, so this is in relation to the IT IMF P13, and you've recommended deleting B, which related to all other infrastructure that wasn't nationally or regionally significant. But when I read your reasoning, it seemed to support or seemed to be addressed to a more localized sort of infrastructure. The examples that you gave are a wharf or a jetty. And when you read the reasoning, it looked like it was actually supportive of having some provision for lesser standards of infrastructure that weren't necessarily regionally or nationally significant. Am I being unfair to you in that? You say that those adverse effects may not be extensive, it may not be inappropriate when factoring in other circumstances. For example, the benefits of the proposal, compatibility with surrounding land uses. I would have thought that sort of reasoning supported having in a provision for lower level district of significance in a district-wide sense to be provided for.
Yes, that's correct. I had understood the consequence of the deletion of B was that type of infrastructure that's not nationally or regionally significant does not need to then avoid adverse effects on the values, etc. Maybe I've misinterpreted what I've written, but I was intending to delete the requirement to avoid adverse effects on the values that contribute to the area's outstanding natural nature or significance.
All right, well, look, I'll have a look at that in due course. Yeah, thank you. Paragraph, sorry, page 29, and under EIT transport P19, policy 19, you've used the phraseology key visitor destinations. How do you assess what is a key visitor destination?
That would be up for discussion in a lower order process. I know what I'm thinking of when I think of those, that term, and it's, for example,
what do you think of?
For example, in Queenstown, it's resorts like the ski fields, and like at Walter Peak, where the Earnslaw goes. It's an existing key visitor destination, which hosts thousands of people, visitors.
Yeah. So you're contemplating large scale.
Yes.
Yeah.
Yeah.
Okay. All right.
Sorry, just to round that out, that was large scale where it's an important transport or a relevant transport issue.
Right. No, thank you very much, Mr. Farrell. And as I observed before, thank you for the thought you put into it. Thank you.
Thank you.
So that's our case for today. The three of us will be back in May.
Yeah.
Mr. Farrell, if there were written questions from Mr. Farrell, I think he's back on the 20. He's back on the 15th of May. So there would be time for a written response from Mr. Farrell to any questions before LRC's closing.
Right. Thank you. Thank you very much. Presently present. Yep.
Good afternoon. Thank you very much for the opportunity to present in person today. So I'm Harriet Jopp, and with me is Eleanor Linscott, and we are from.
I'm sorry, I missed your name.
Harriet Jopp, J-O-P-P, and Eleanor Linscott.
Eleanor
Linscott, Linscott. And we are appearing on behalf of Federated Farmers of Otago. The right hand button. Oh. Sorry about that. We are presenting on behalf of Federated Farmers Otago and Federated Farmers New Zealand today. So we're a membership organisation, and we're here on behalf of our members in Otago. We would like to set the scene for you by sharing the diversity and complexity of farming systems, and then how the eco chapter may impact farming activities in Otago. We'll then move to outlining the specific changes we're seeking. So to set the scene, a study by Norton and Parnell in 2018 found that in Otago, in terms of native vegetation, there is more native vegetation on farmland than conservation land. It was found there would be 40.5% of the region's native vegetation on public conservation land and 56.1% of native vegetation on sheep and beef farms. So from these figures, it is clear that there is a large amount of Indigenous biodiversity on farm in Otago. Otago's farming systems are diverse and complex. One particular feature relevant to the eco chapter are the high country stations, of which more than Otago has the largest number in New Zealand. There are also large numbers of hill country farming systems. Our witness evidence estimates that there's 913,000 hectares of tussock grassland that's grazed in Otago. And I think some of the other figures indicate that 300,000 hectares of that is the tall monte tussocks.
Can I just inquire, are you reading from a document?
Oh, I'm just
It's not a copy.
summarising, yeah,
Oh, I see.
setting the scene.
Look, if you're summarising this document you've just put before us,
Yeah.
possibly it might help, particularly when you're giving us figures like that, if you could draw our attention to particular paragraphs as you go.
Yeah, that sounds good. So I might actually, instead of reading that out, I was going to focus on yes, more setting the scene, but we can move to the written submissions. So I'll just jump to paragraph 6 there. So this is what are we seeking? Otago needs a policy setting that will protect areas of significant Indigenous vegetation and significant habitats of Indigenous flora and addresses the threat of pests to Indigenous biodiversity. Decline in terms of spatial area of habitats has slowed in the last 3 decades, and we've cited there the Department of Conservation's Biodiversity Strategy Report of 2019. That also found that the decline in our Indigenous biodiversity is more seriously due to predators and the lack of pest and weed control. It is our submission that this is a critical factual point as it goes to the heart of the rationale of the eco chapters, where continuing serious decline creates an imperative for all effects to be avoided, but misses the real issue of pest and weed management deficiency as the cause for that decline. So to implement an effective policy on Indigenous biodiversity, it will require active management by many farmers through plant and animal pest control initiatives, planting programs, and soil conservation initiatives. Now, if I may, I'll just slightly expand on that with reference to the high country in Otago. With high country farms, you're not talking about 50 hectares of wetland or 100 hectares of totara. You're talking about thousands of hectares of Indigenous biodiversity that are managed for the purpose with biodiversity values in mind. Many in the high country have been measuring this for decades. And for those who maybe haven't, there are now industry standards, which, so like New Zealand Merino recommends taking transit lines to inform the biodiversity stock management. So stock management and biodiversity in the high country are directly related. And I guess the other major point to note in relation to the effective policy is the pest management that's already been undertaken on farms. So I'm happy that you've already referred to newspaper reports, but I think it was last week that ORC released a report that identified that pests are under control in the high country and that it's peri-urban areas which where pests are more of an issue. The cost of pest management on farm met solely by farmers, with the exception of the wilding pines, which was partly funded by the council and the government. So paragraph 8, what we're seeking is that farmers are recognised as stewards of the land, have greater recognition of stewards of the land in Otago. What that phrase means to us are that farmers make decisions for the best interests of their grandchildren. From our discussions with iwi, it's similar to the principle of kaitiakitanga. In addition, we would like to emphasise the importance of integrative and adaptive management in relation to managing biodiversity on farm, the importance of including non-regulatory methods to protect Indigenous biodiversity, and also a discussion around the existing use rights and how the RPS can provide for those. So now that I've set the scene out from paragraph 10, we go into the specific issues that we have identified that we would like amendments on. And the first one is that the significant resource management issues, I think it's 2 and 3, sorry, 3 and 7, both relate to pests and Indigenous biodiversity. So that's in the proposed Otago Regional Policy Statement. However, we consider that these issues are inadequately reflected in the objectives, policies, and methods because they inadequately identify landowners as stewards of the land and a part of the can't manage pests without the landowners' involvement, and therefore there should be a flow-on change in policy. The tall montane tussocks have come up and also in the evidence. And in particular, it's slightly confusing to differentiate between tall montane tussocks and other tussock grassland because I don't think it's actually been clearly set out in the evidence. We cite a Statistics New Zealand report from 2012 that identifies that tussock grasslands, this is a national percentage, but it's down 1.3%, and it would be our submission that that would be within the margin of error. At 10.9, I explain that why consideration needs to be given to what is equitable based on the status quo, but also what's happened in the past. Many farmers have taken steps to protect the significant Indigenous biodiversity, including tall montane tussocks, and it's important that there is an equitable policy framework to recognise the work that's already done. So I give 2 examples there. The second is quite important. So those are the farmers who've been through tenure review, which have given up a portion of the land for the benefit of to conservation, with the consequence that the remaining land is then freeheld. So they've already been through assessment that differentiates between high value conservation land and land that can be used for productive purposes. Likewise, the QE2, I haven't written this down, but the QE2 covenants are also well used in Otago, and they provide conservation benefits. I won't read it all. I think that another important point that we're seeking to make is that the criteria for significant natural area needs to be set at the right level, given the impact that it will have on farm land. So that's at paragraph 12. So we are seeking that the reference to indigenous species that are taonga is removed from the objectives, policies and methods in the Act. And the reason for that is the differentiation between section it's section 6C and section 6B. So section 6C is the provision that requires.
Just to help you, that 12.4 A is section 6E and C rather, and B is section 6E.
Thank you.
Okay.
So there is a positive obligation to protect significant Indigenous vegetation and significant habitats of Indigenous fauna. There is no obligation to protect, and that's obviously an important word, species that are taonga, but the proposed drafting of the RPS infers that taonga species are significant as of right. With the high country, a lot of the, Mr. Cubitt's identified that it's been managed by LINZ, and those that have been through consents have obtained cultural assessments. So there has been dialogue with iwi around on farm about what is significant and what needs to be protected. But in terms of the policy settings, we are seeking that the reference to taonga is removed. And the reasons for that is that the species that are taonga are prevalent on farmland, including bracken, ring fern, tauhinu, mingi, manuka, and kanuka. And that these species often need to be cleared to maintain productive pastures. Another point that we would like to emphasise is that the differentiation between what is significant in terms of 6C and what may be included by reference to species that in taonga has not been through a Section 32 report. So that is what additional land may be captured and what is the cost of that to our region. So the final point that I'll speak to is the existing use rights. So at the moment, clearance of Indigenous vegetation is dealt with by each territorial authority. There's a proposal that the regional policy statement will shift responsibility to the regional council in part or in whole, which would differ from the existing regime and have consequences for practices on farm. In addition, we have identified that this may conflict with the NPS on highly productive land, which obliges territorial authorities to provide for existing use rights. And in addition, it would conflict with the Environment Court decision in Southland District Council and Peter Donna Chartreuse, which is a recent decision on existing use rights. The farm was Te Anau Down Station, and it's an extensive land holding, and they cleared Indigenous vegetation regrowth. So we're not talking about significant Indigenous vegetation, we're just talking about regrowth. The judge expressly said that there is no obligation on the landowner to allow Indigenous regrowth to grow into Indigenous forests, and upheld the right to clear Indigenous vegetation. And I guess it's important to understand how that works from a practical perspective on farm, in that you don't clear it every year. It's like as any plant species, it's as and when it grows to a sufficient scale that needs to be cleared. So for instance, in that case, I think they cleared it less frequently than every 20 years. So we've set out the changes we want in the relief table. I won't go through them unless they're helpful. So maybe, yeah, we're happy to answer any questions you may have.
Thank you, Ms. Chop. There will be questions, I'm sure. So, let's those of Commissioner Sullivan. Thanks.
Yeah, thank you. Thank you for that. I'm just a question to start. What proportion of farmers do you represent in the Otago region? Do you have any idea?
Not off the top of my head, sorry, no, I don't.
I think it's over 700, but we don't know what the proportion that would be.
Yeah, and I take your points around farmers being kaitiaki of their land. In my experience of dealing with farmers, I do find that the majority of them are certainly really good stewards of their land. They're very interested in the Indigenous values that they have on the land and trying to minimise their impacts. There are also, I suppose, I've found a portion who don't take that view, and it is kind of production at all costs to some extent. How, I mean, I suppose, and not having, we'll look at, what you're proposing here in more detail, but I mean, do you think that the amendments that you're proposing, just from a look, it seems that you're more sort of focusing on provisions that would, possibly on the assumption that all farmers are good farmers and are good stewards of their land. How do you think it's going to actually capture those who aren't?
Yeah, that's a really good question. I think that our approach is to really promote that integrated and adaptive management. So like there will be some, like without a doubt, there's the national policy statements that are there, not so enforced yet, but that's going to help set direction alongside with the regional policy statement. I guess that there are existing frameworks in terms of what can be cleared. So yeah, the issues will be mainly around clearance of significant Indigenous vegetation. Is that what you're thinking?
I mean, I suppose I'm seeing, you've got the effects management hierarchy P6 to be deleted.
Yeah.
And I think, if you look at the RMA, it is requiring us to consider more than just SNAs in terms of obligations under Section 30.
Yeah. So we would, in terms of P6, our proposal would be to use the same wording as in the NPSFM in terms of that effects management hierarchy, because the wording, I think, in the NPSFM includes where practicable, and that allows more integrated or adaptive decision making to occur. I think that there are, obviously with biodiversity, it is on mainly the larger farms, which have the option to kind of focus on one area as long as production on other areas of their farm can be maintained. But in other farming systems, you wouldn't have that ability to balance, I guess. But in terms of how this would make sure that it's protecting those who may not value biodiversity as much as other farmers, then there will still be remaining policies in force. So that, for instance, and also like the objective for the region is quite clear, that the policy framework will protect Indigenous biodiversity.
Yeah, I think we're going to be hearing something quite different from the Director General this afternoon, Director General of Conservation. But Okay, no, thank you for that.
Yeah, thank you for that. I'm assuming when we get to land and fresh water, I think you guys have teamed up with the ORUG group. Yeah, because I've started reading that evidence because otherwise I'm not going to get there in time if I don't start now. But there was quite a drive in that, what you're talking about around the stewardship and non-regulatory management approach coming through that evidence as to what's happening now, I guess. I guess as Bianca's raised, is how do you deal with the renegades? And in relation to that is the pest management issue, which is a big issue that's been raised. But how does an RPS sort of direct active management of something like that? You can't really go that far, can it? So unless it's identified in a pest management strategy in this bylaw, I'm not sure how that works. That forces people to manage that stuff.
Yeah, absolutely. So there are tools that have already been included in the RPS. I think it's method 8, and it talks about financial incentives. So like the conversation is now talking around like if you're actively managing pests on your property, you might get a rates remission. And then of course, there's movement in the carbon space as well. And there may be some kind of biodiversity credit into the ETS, and that's another way to incentivize managing pests on the property. So I think there are, like, you can't mandate it, but you can encourage it. Yeah.
Yeah, I read that, or how far I've got in that even so far with some interest around. We keep being told not to compartmentalise things, and in the ORAC evidence it's coming out, well, there's a bit of an issue. We're required to spend a lot of money planting riparian strips, but we know get no credit for that in the emissions trading schemes, nor the other things. So I see that drive coming through.
Yeah.
My question around that, though, so it's not something we can deal with at this sort of level, but I understand the issue. As I do with the 10-year review concern, which is raised quite regularly, but the reference to the Charterist case, which I'm familiar with, we talked about earlier in the hearing, that actually brings the issue sort of front and centre around section 6C, protection, and the other function, the maintenance. Do you have a view on that, how they relate? Because we've been told, and it appears given the structure, that all Indigenous biodiversity is almost being elevated to a section 6 sort of level. I'm not sure that's how the Act operates, but do you have a view around what protective maintenance means?
I actually have listened to my friend, and she explained that they have similar meanings. I think the real issue is what level is significant set at, and like in terms of farming systems, like, and to achieve the best outcomes, you are going to have values where that differentiate between significant Indigenous vegetation and Indigenous vegetation regrowth. I don't know if I'm answering your question, sorry.
Yeah, no, it's fine, because the question is going to be kind of relevant in that EcoP5 space around the existing use sort of issue when you turn up in the May hearing. I'll be interested to see how they see that working in a practical sense and what the implications of that might be. Thank you for that.
I was going to talk about an issue that you repeat often in your submission around stewardship, and quite carefully done that. In some ways, I'm kind of struggling to understand what you really mean. In terms of farmers being stewards, I think some layperson would look at that quite differently. I'm not sure. So can you enlighten me or explain to me a bit more about what it is you're really saying?
Yeah, so in short, it's that they make decisions for the benefit of future generations. They're stewards of the land. They look after the land.
In what way?
So, for instance, they manage the land in a way that would promote Indigenous biodiversity. They can rattle off quite a few. They will protect areas. So like, for instance, on farms, the protected natural areas came in, I think, in the 80s, which started to identify values. So totara will be protected on farm. Another example may be making decisions that are, I guess the opposite would be like using resources in a way that's not sustainable, whereas particularly for the high country, that they're making decisions that are sustainable.
Okay, I guess my problem then is really defining what you mean by biodiversity or ecosystems. As we heard from the previous presenters, often it depends on what viewpoint you come at. You know, you'll get a different answer. And I suspect I'm getting a different answer because I come at it from a different perspective.
Yeah. So I can give you a more specific example in the hope that it will be helpful. So I guess in terms of, because Indigenous biodiversity to us wouldn't just be trees, it would be pastures and grasses as well.
Yeah.
And so you're making decisions to ensure that the exotic species don't proliferate and that it's the native species that remain prevalent. So like, for instance, with grass, you have to set a stock regime to ensure that that objective is achieved. Does that make sense?
Sort of. I mean, I'm looking right now at the statement you make here, which is, and I'll just quote the first bit of it, making specific objectives, policies and methods to address the issues in Otago by recognising landowners as stewards of Indigenous biodiversity. That's the bit that's gnawing at me at the moment.
I guess what I was really trying to explain there is that decisions are already being made to promote Indigenous biodiversity, and to ensure that biodiversity outcomes are achieved, you need to engage with the landowners, because they're the ones that are going to know this is the this is the most significant, this is the work that we've been done to protecting it.
Yeah, because I was reading it a different way.
I'm sorry about that.
Yeah, no, in a sense, I'm a bit like my colleague to my left here, because I started reading the other stuff as well. So I'm kind of in a different sort of mindset, I guess. And I wasn't quite expecting this approach, but thanks very much.
That decision that you referred to at 15.5, send the link to that to Kate so that it can be printed off. Thank you. Just where you're referring to the tall montane tussocks, and then over the page you referred to 1 million hectares of tussock grassland in Otago. So are you combining snow tussocks and grass tussocks for different types of tussock, lower level type of tussocks or what?
I had a look into all the evidence that's been filed, and it wasn't that clear. But this was what I found. We would submit that tall mane tussocks have different attributes than the grass tussocks, but I think there's been some discussion about clearing other types of tussocks as well, not just that tall mane montane tussock.
So at the top, I'm just a bit confused. Sorry, I haven't got page numbers, but at paragraph 10.5, you've got there's an estimated 913,000 hectares of tussock grassland that's grazed and no tillage. So that's that figure that you're referring to when you talk about a million hectares. So, yeah. Paragraph 13.2, you make a statement that you often see, but I just wonder whether you can explain it a bit more to me. You say about 2/3 of the way down, we know of farms on the West Coast where 100% of the farm is designated SNA. The economic cost for some landowners may be dire. What do you mean by that?
So Federated Farmers did a survey around the draft or exposure draft of the NPSIB around the proportion of their land that would be captured as a significant natural area. How that flows through into the impact on production is around what existing uses can continue. So if there is a change in production, then yeah, that would be dire. Yeah.
So what you're really saying is that the concern is that if you're designated as an SNA, you're not able to remove significant vegetation.
That's not what we're saying. I guess what we're saying is that, yeah, the significance criteria needs to be set at the right level to ensure that Section 5 of the Act is met. If it's set too wide and more farmland is captured as an SNA than need be, there will be flow-on economic impacts. So that's really what we're getting at, the level of significance.
I don't think I've got any other questions. Set out as pretty clear. So thank you.
Thank you very much.
Thanks for your presentation today. Thank you. We'll take the lunch break now and up to Department of Conservation. So right waste time because we've got flights later in the day, so we'll probably reconvene at close to 1:45. Right. Thank you. We're going to pass one. And I think that's good. I didn't want to put pressure on the local. So
Kerry Warnock, good afternoon, my name is Kerry Warnock and I am representing the Director General of Conservation today. And thank you for affording us time to present our case. We're very grateful to you for that. One question that has come up is timing. How are we going to do this afternoon? Do you think we'll have time to present our case? We have got all of our doc witnesses here today.
We've got.
I'm very grateful.
The reality is that, turn that off. The reality is that in our minds, the issues have been thrashed around a lot, so that there won't be a lot of detailed questions. It'll be much at a higher level, I suspect, as far as your witnesses are concerned. And we're very interested to hear, and it's timely that you're at the end, because we're quite obviously hearing, I suspect, another side. And so that's valuable to us, but we definitely intend to get you concluded by the time we have to head off to the airport. All right? We won't be sitting late because we do have to get away to the airport.
Thank you. My submissions, legal submissions, follow a three-part structure. The first part sets out the general interest that the Director General has in this particular chapter. The second part considers the legal submissions and the legal framework that you're operating within. And the third part looks in detail at the submissions. And I've adopted quite a methodical approach to part three because the Director General has made so many submissions on this chapter. So to begin by way of introduction, the Director General has a particular interest in ensuring that the proposed Otago Regional Policy Statement promotes sustainable management by protecting ecosystems and Indigenous biodiversity in the Otago region. Within the current legal framework, regional policy statements are the most important legal instrument for protecting ecosystems and Indigenous biodiversity from adverse effects. In particular, they are a critical tool for protecting threatened Indigenous species. The pORPS must set clear and specific outcomes in Otago for the protection and improvement of ecosystems and Indigenous biodiversity, particularly threatened species, and those outcomes must be integrated throughout the pORPS. Without such clarity, endangered ecosystems and threatened Indigenous species in Otago will receive inadequate regulatory protection and risk depletion or extinction. And the second part of my submissions, I go on to address the legal framework. And I should add that I agree in general with the relevant legal framework ably explained by my friend Ms. Sefton for OLC, but there are a couple of additional matters that have come up during the course of the hearing that the panel might be interested in. And the first one concerns section 6C of the RMA and the question of significance. And you'll see in my submissions that I refer to the High Court case, West Coast Regional Council and Friends of Shearer Swamp Incorporated. And in that case, the High Court said, significant is a relevant term that imports the notion of informed judgment as to those natural resources in the region that need to be protected. The court also said, while the national state of biodiversity or species must be a relevant consideration for a regional council preparing a policy statement or plan, nevertheless, national importance is not a prerequisite for significance, and something can be regionally significant without having to be nationally significant. A further additional matter is that the protection of Indigenous species from adverse effects is a section 5, subsection 2 RMA matter, and you'll see that I've referenced the various case law that supports that contention. Points 3 and 4 were ably addressed by Ms. Sefton. Point 5 is that the exposure draft of the National Policy Statement for Indigenous Biodiversity is a document to which the panel may have regard. It has legal weight for 4 reasons in my submission. Firstly, it has been prepared under the RMA. Secondly, it represents best practice and the considered consensus of technical experts. Thirdly, it involved treaty partners' input. And fourthly, it provides the best indication we have of current government thinking. Accordingly, the Director General submits that the draft NPSIB is both relevant and highly persuasive. And I repeat paragraphs 21 to 25 of the opening legal submissions for Council for the Director General. 6, the panel may also have regard to Te Mana o Te Taio, Aotearoa New Zealand Biodiversity Strategy 2020. This is a national strategy that has ministerial approval. It has been created to fulfil New Zealand's international law obligations under Article 6 of the Convention of Biological Diversity. And the Director General submits this strategy is both relevant and persuasive. And then finally, the legal framework protects ecosystems and Indigenous biodiversity for their intrinsic value. That is, not solely for any practical utility to humans. In the context of this afternoon, I will be calling on all of the Department of Conservation expert witnesses who have submitted in this matter. For ease of reference, you'll see in my written submissions that I refer to evidence using initials and paragraph numbers. Moving on now to the detailed submissions. And the first issue concerns integrated management. Throughout this hearing, a consistent theme of the Director General's submissions and evidence has been the need for greater integrated management in the pORPS pursuant to section 59 of the RMA. But that message is particularly acute in this chapter. Biodiversity exists both within and across coastal, freshwater and land domains, and biodiversity in any one domain can be affected by activities in other domains. And of course, biodiversity is also impacted directly by energy, infrastructure, transport, urban development, and so on. Now, while the structure of the pORPS is constrained somewhat by the national planning standards, that does not, for example, prevent greater cross-referencing between chapters. And you'll see I've also added there, nor indeed between regional council instruments. For example, there should be an integrated management approach taken between the pORPS and the Otago Regional Pest Management Plan. But substantively, the eco chapter should be directly referenced in all other chapters. The second issue concerns objectives. Oppose the addition of net in Eco 01. The Section 42A report recommends amending Eco 01 to include the word net, so that Eco 01 would read, and net decline in condition, quantity and diversity is halted. The Director General strongly opposes the inclusion of the word net in Eco 01 and submits that that should not be adopted. The inclusion of the word net, and you'll see I give 4 points there, firstly, prevents Eco 01 from being aspirational. As the Environment Court has stated, an objective in a planning document sets out an end state of affairs to which the drafters of the document aspire. Point 2. It would allow a capped approach to biodiversity across Otago, as Mr. Brass explains in his evidence. Point 3. It enables perverse outcomes whereby a consent applicant could justify loss of biodiversity arising directly from their actions on the basis that there have been unrelated improvements elsewhere. And so it cuts across the carefully crafted policies of the pORPS that include an effects management hierarchy and criteria for when offsetting will or will not be appropriate. And finally, as Dr. Richardson will say, it does not work from an ecological perspective, as ecosystems and species are not fully fungible. Accordingly, the current proposed working for Eco 01 is contrary to Section 6C of the RMA, Objective 1 and Policy 11 of the New Zealand Coastal Policy Statement, Policy 6, 8 and 9 of the NPS-FM, and the planned outcomes and objectives of Te Mana o Te Taio. Each of these national statutory directives require protection of Indigenous biological diversity. Now, the Director General accepts that Objective Act must be examined. However, considering Eco 01 in combination with Eco 02 does not remedy the problem with including net in Eco 01, because Eco 01 would, for example, tolerate the loss of a threatened species, while the inclusion of Eco 02 or indeed any other objective could not restore or remedy this loss. Nor does Eco 02, as Mr. Brass opines, set any quantum or scale for net enhancement, and it only applies to extent and occupancy, not condition or diversity. The next point is that additional objectives are required in this chapter. And subject to the direct submissions that I've just expressed, The Director General supports the substantive direction of the current objectives. However, ecologists and resource management professionals know well from experience that without clear and specific regulatory outcomes, ecosystems and Indigenous biodiversity will not be adequately protected from adverse effects, nor will their population, occupancy, diversity and condition improve. And I've made this point that the entire reform of the resource management system is predicated upon this lesson. On their own, ECO01 and ECO02 do not provide sufficiently clear and specific outcomes for the protection of ecosystems and Indigenous biodiversity. In particular, a generic approach is being taken to Indigenous biodiversity, and the objectives do not seek to place any emphasis at all on threatened species or habitats. Now, the Section 42A report suggests that threatened species and habitats are automatically encompassed within the term Indigenous biodiversity, and there is no need to set specific outcomes for them. And I apologise for the analogy, but that's rather like Fagin instructing his gang to get all the metal from the Tower of London and then returning without the crown jewels. How are they to know? The most valuable items were forgotten in the melee. Without targeting threatened species and setting clear, specific outcomes for them, there is a risk that they too will get lost in the melee of planning and decision making. Further, there is a need to protect the components of biodiversity, because without them you lose the whole. When species or habitats are so depleted they are listed as threatened, this is a clear sign that targeted intervention is required. Mana Otatayo sets out specific goals that require implementation by regional councils. You'll see I've set them out there. And the pORPS should set clear objectives that reflect these goals. Fundamentally, setting specific objectives for threatened species will focus attention in decision making. It may help to prevent gaps in protection where, for example, threatened species inhabit non-protected areas. And I briefly refer to Commissioner Cubitt's questions to Kelvin Lloyd there that touch upon this issue. Accordingly, the Director General recommends that 6 additional objectives should be added to the Eco chapter to provide the necessary clarity and specificity. And I've included all 6 of those proposed objectives in the written submissions here for you. I'll only read out the first 2. That activities within Otago do not contribute to any worsening of the threat classification of Indigenous threatened species found in Otago. And the sister provision, in terms of the RPS, that activities within Otago contribute to improvements in the threat classification of threatened Indigenous species found in Otago. Now you'll see that in relation to those proposed objectives and also to other proposed objectives, the New Zealand threat classification system is explicitly referenced. As Mr. McKinley and Dr. Richardson will explain, the New Zealand threat classification system is the best tool we have for identifying threatened species. Explicit reference to the NZTCS in the eco objectives is essential because it will ensure that critical focus is placed on our most vulnerable species, those that we cannot afford to deplete any further. I have just added a note there that in response to concerns, very valid concerns expressed in the Section 42A report, I think by Dr. Jarvie, the wording in the first 2 proposed objectives has been amended slightly from that originally proposed, but the substantive intent and important reference to the NZTCES remains. Issue 3, policies. Amend the wording of Eco P3. The proposal in the Section 42A report that Eco P3 1A be limited to areas which have been identified and mapped under Eco P21 should be rejected. In his evidence, Mr. Brass explains that these words could lead to unintended adverse consequences. Amend the wording and the order of the effects management hierarchy in Eco P6. Firstly, in relation to the wording. The word mitigate in Eco P6 should be replaced with the word minimise. Mitigate is less distinct than minimise, as it attempts to do 2 things. and the High Court has discussed this. To mitigate is to alleviate. It may lessen the impact, or it may reduce the severity of an impact. And it may, as a consequence, result in protection or even removal of an unwanted effect, depending on its degree. The NPS FM and the draft NPS IB do not use the word mitigate in the effects management hierarchy, preferring to use minimize instead. It's a word that's not attempting to straddle a number of management approaches. Now, in terms of structure, the aim of the effects management hierarchy is to set out a scale that starts with the most protective action, moving through to the least protective. As Ms. Mealy will explain, to minimise adverse effects is more protective than attempting to repair adverse effects ex post facto. Accordingly, the effects management hierarchy should be reordered so that minimising adverse effects is a second preferred action, and then remedying adverse effects comes after that. Once again, this order reflects the NPS FM and the draft NPS IB. Further, it is incorrect that the cascading structure in the effects management hierarchy would prevent any given project from utilising a number of management techniques. Mr. Brass can talk to that in greater detail. Rather, the cascading structure focuses attention on the most protective aspects, to require serious thought and attention to be given first to avoiding adverse effects, and so on. To adopt the pick and mix approach suggested by some submitters would remove this emphasis, and it would inevitably lead to the focus switching to that approach that the applicant deemed most expedient. Issue 4, methods. Amend Eco M1. There's quite a hopefully non-controversial proposal in relation to Eco M1. So I'll move on to offsetting and compensation. And perhaps just standing back from my submissions, before I look at the detail of the written submissions, there has been a huge amount of attention paid to offsetting and compensation, and the discussion has become incredibly complex. And what I want to do in these submissions is to stand back from that complexity to some extent and think about first principles. Firstly, the pORPS must carefully differentiate between provisions that require a regional response and variation, and those provisions concerned with scientific methodology. Where provisions are concerned with scientific methodology, best practice can be largely replicated. APP3 and APP4 both have 3 parts. Each part has a separate foci that impacts the legal approach to be taken. Part 1 provides the gateway limits to when offsetting compensation is not available. Parts 2 provide the criteria for when offsetting compensation may be available. Parts 3, which are entitled additional considerations, are really concerned with ensuring a scientifically robust methodology of assessment and an inclusive and transparent process. So firstly, dealing with parts 1 and 2, they need to be reflective of the values relevant in the regional context. The examples provided in the draft NPS IB shouldn't be repeated verbatim. They need to be translated into criteria that make sense in the regional context. Critically, the gateway for accessing offsetting in APP3 and compensation in APP4 constitutes a form of risk management. In essence, it reflects where the regional council has utilised a precautionary approach and set the risk standard accordingly, i.e., what will be an acceptable risk to take and what is unacceptable. We know that offsetting is not guaranteed. We know that offsetting measures may fail. The oral evidence of Dr. Keesing made this clear. Sometimes we lose things, he said. In APP3.1 and APP4.1, the Otago Regional Council has set the boundary between acceptable and unacceptable risk. Now, we can argue about where that boundary falls, and indeed the Director General does just that. But we cannot argue that setting a boundary is an invalid legal approach. Further, parts 1 and 2 must, and indeed do in large part, establish criteria that give decision makers some degree of flexibility to allow offsetting and compensation in specific contexts. if that management approach will create the best outcomes for biodiversity. This requirement means that in some instances, the drafting in parts 1 and 2 will appear looser and more flexible, as opposed to highly prescriptive and rules-based. For example, the inclusion of the words the loss of, irreplaceable or vulnerable Indigenous biodiversity allows a value judgment to be taken by the decision maker based on the relevant context and best evidence at the time. However, having said all that, as presently drafted, the gateway to offsetting in the proposed pORPS is too restrictive and may create a fast track to compensation. Compensation can lead to poor outcomes for biodiversity. Accordingly, the pORPS should facilitate offsetting that is reasonably demonstrated to achieve no net loss or a net gain of biodiversity in preference to compensation. And the Director General recommends that APP 31A and APP 41B are removed and replaced with 5 additional limits that provide the requisite safeguards for biodiversity while preventing a fast track to compensation, as explained in Ms. Mealy's evidence. Now, Oceana Gold has submitted that, as a matter of law, Section 1041AB of the RMA provides a veto, or as a corollary, a mandatory rule, that an RPS cannot contain a threshold at all for when offsetting will or won't be considered. That submission is legally incorrect. The wording in Section 1041 RMA requires consent authorities to have regard to the listed matters in Section 41A to C. Have regard to means give genuine attention and thought to. It does not mean that it must be actioned or achieved, and Mr. Brass, again, can address that from a planning context. Now, moving away from parts 1 and 2, in contrast to the above submissions, parts 3 of APP 3 and 4, termed the additional matters, are concerned with scientific methodology. They do not need to be regionally specific or necessarily bespoke. And the Director General would say that rather than trying to reinvent the wheel, the provisions in Part 3 should be more aligned to international and national best practice, as reflected in the draft NPS IB. To ensure a robust assessment methodology, the wording in Part 3 must be tightened up, and the Director General recommends inserting new provisions into Parts 3 to provide increased clarity, and the wording is set out in Ms. Neely's evidence. The penultimate issue, issue 6, APP2, significant national areas. APP2 agreed in the expert caucusing meeting is adequate, but greater work is needed to ensure compatibility across domains. I'm going to start by repeating the point about where you need regional variation and where provisions are concerned with scientific methodology. In respect of the assessment of significant natural areas, best practice scientific methodology from Appendix A in the draft NPS IB can be drawn upon in the pORPS, thus providing robust and widely accepted assessment criteria that apply across domains and may be replicated across regions in the future. Now, all of DOC's expert evidence will agree with that premise. However, the Director General accepts that the draft APP2 arrived at in the expert caucusing meeting is largely representative of the draft NPS IB, and it also has some advantages over the draft NPS IB. For example, it establishes a baseline, the pre-human baseline, against which to assess representativeness and rarity. And including some form of baseline is critical to being able to make an assessment of decline. Further, the Director General rejects any arguments that the current APP2 would lock away too much land. It's important to remember that SNAs are not locked away from all uses at all. Rather, they are protected from adverse effects deemed unacceptable, and that will be a value judgment, and thereafter subjected to the effects management hierarchy in ECOP 6. Accordingly, a focus on how much land would fall into SNAs and the correlative idea that too much land is being taken out of all productive use may not be particularly helpful. Fundamentally, however, experts from the Department of Conservation would have appreciated a greater opportunity to work alongside ORC ecologists in order to consider, test and revise APP2 to improve compatibility between the management regimes applicable in and outside the coastal environment. And just my final point on definitions, and I won't read all of this out, given the time. Add a number of definitions. Commenting on the RMA in 2013, Dame Sian Elias wrote, "The Resource Management Act is an act that affects people and their aspirations in the real world. It is a framework of values for practical living and for the management of disagreements about the physical environment. It is meant to engage communities, not alienate them. The policies and plans that construct the detailed framework for resource management must also engage rather than alienate communities. The pORPS inevitably treads a delicate line between verbosity and certainty in an attempt to ease accessibility but prevent contestation. However, certain terms do require greater explanation in order to avoid potentially futile debates that would detract attention from substantive issues. And the Director General recommends adding definitions for Indigenous fauna, Indigenous vegetation, naturally rare, biodiversity offsetting and compensation, no net loss and net gain, and the explanations are given in my written submissions. Those are the submissions for the Director General, and I'm, of course, ready to answer any questions that you may have on them.
Thank you, Ms. White.
Thank you. That was very helpful. I suppose, a little bit surprised at your paragraph 2, where you state within the current legal framework, the regional policy statements, that regional policy statements are the most important legal instrument for protecting ecosystems and Indigenous biodiversity. And I know that you're saying there from adverse effects. So based on that, I presume you're talking about outside the conservation estate?
Yes.
Given that that's managed under a different framework than the Conservation Act?
Yes, within the resource management framework, yes.
Okay.
And I suppose if one thinks about it in a geographical sense and a cumulative sense, RPS aren't the most important, because we're talking about 70%. We will be talking about 70% of the Motu by RPS.
Yeah. No, I think my other question I suppose the only other thing was if you've got any inside word on when if the NPSIB may be gazetted.
No, that one, no advance on what has already been said, unfortunately.
Yeah.
We know that it's been through the sense check, if we can term it that. So it is ready to go, but it has not been before Cabinet yet.
Okay. No, thank you.
Thank you.
Thank you. I think all submissions highlighted or not highlighted, but the issue I've sort of been struggling with in terms of talk about in paragraph 15 that the emphasis, the objectives don't place the emphasis on threatened species, and it's sort of arisen through this process that, and it's section 6C matters and the maintenance of Indigenous biodiversity function, that and how that's addressed in this document. And the objective you refer to, the concern here, is about maintaining Indigenous vegetation, so which has been put to us, and that it actually elevates all Indigenous vegetation to a 6C sort of level. And I was interested in your view around that, particularly in terms of the definition of maintenance in the context of Indigenous biodiversity under, I think it's section 31A. And then I read the definition of, which I think is somewhere around, definition of biological diversity in the RMA. It talks about the variability amongst those things. And when I read that, it doesn't suggest to me that that means everything needs to be kept. It's about actually ensuring we have that variability, diversity there, but doesn't necessarily translate into keeping everything. So in that sense, maintenance is different than protection.
Yes, it's a difficult issue.
You come sit over here.
Well, we've obviously been watching the hearing and the discussions around the various words used in the RMA: protection, preservation, maintenance, relationship with, and it makes me think of Justice Cook when he was actually president of the Court of Appeal, and I think it was the Auckland Regional Case. Commissioner Crosby may be well familiar with this, and why he said that, you know, the RMA is verging on turgidity, the way it's written, without any. These words are almost put in, you know, randomly without any definition or clear thought. So in relation to your specific question, Commissioner Cubitt, we have this sort of hierarchy, don't we? We have section 31 GA, which is the general responsibilities on the regional council, which is a wide responsibility to maintain all Indigenous biodiversity. So that has a broad effect. And then, of course, we have the section 6C matter, which is about significant Indigenous biodiversity. It's protecting significant Indigenous biodiversity. I think it's always useful in a legal sense not to think of protection as an isolated word, not to sort of partition it off and think about it in isolation, but always to think about protection from what? Protection from adverse effects. What are those adverse effects? Well, that will be a value judgment that's taken by the community. In relation to Indigenous species, as I said in my submissions, that's a section 5.2 matter, 5.2c matter, and you'll see that that's subject to the legal framework that we know well: avoiding, remedying or mitigating any adverse effects on activities on the environment, and that's where the Indigenous species more generally comes. The Supreme Court in King Salmon talks about or addresses the question of protection. I think it's paragraphs 28 and 24D. I can certainly provide copies of that to the panel if we haven't already got it, but I'm not sure it answers your specific question. It's quite generic.
Okay, thank you. I think I'll just leave it there. That I found your position very clear and enlightening and useful in that regard. So thank you.
I don't have any questions. Thanks.
The King Salmon decision was dealing with a situation where you had section 6B issues at stake, and section 6B is protection of outstanding natural features and landscapes from an appropriate subdivision use and development. So again, the word was protection. I know that you said that you've made that submission about turgidity, but the reality is that section 6 and section 30 do use different terminology, and one has to assume that Parliament's done that intentionally. And so section 6A starts off by talking about preservation in relation particularly to the character of the coastal environment and wetlands, lakes and rivers and their margins, and then adds the words and protection of them from an appropriate subdivision use and development. Subsection C, the protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna. But then when we move to section 30, it's maintenance. And I'm not sure whether you heard the exchange that I had this morning with Ms. Settler, but having read that Canyon decision that she referred me to, or referred us to the other day, and having read that, I've made the challenge to her that in closing, the council need to be able to substantiate the assertion she made at paragraph 13 of the submissions that maintain means protect in accordance with that High Court decision. Because when I read it, I did not form that view, but we'll leave that to see what they say in closing. But in essence, as I read that decision, the reality was that maintain was very distinctly being looked at as being different from protect. And the outcome of that case, which involved Bendigo Station, and involved an application to subdivide for a large number of areas that have been planted in viticulture, resulting in about 10 or 12 houses being potentially built in an open rural landscape, with the opposers saying, well, that wasn't maintaining the open rural landscape, which had to be protected. But the outcome of the case makes it very plain that was not the conclusion the court reached, which was to grant approval to it. What I'm really making is that we've got this challenge that on the one hand, we've got the infrastructure people, Oceania and other submitters, saying to us what this proposed policy statement is doing is elevating all Indigenous biodiversity to a protection level, and that in doing so, it is in essence, as a practical consequence of that, elevating it to the Section 6C status. Now, I was hoping that you were going to address that specifically. You have partially, but not really, because your submission is all along the lines of, if you look at paragraph 11, each of these national statutory directives require protection of Indigenous biological diversity. Well, again, I'll make a challenge to you, do they really? Because it doesn't seem to me that Section 30 does, as a national directive, statutory directive, require protection as contrasted with maintenance. Now, maintenance, in the context of that Canopy High Court decision, was essentially saying you can maintain some values against adverse effects so long as you weigh those effects. Do you still adhere to your last sentence in paragraph 11?
Well, I don't reference section 30 on GA there, but it is something that I certainly need to give greater thought to and will be addressing in closing submissions.
Well, look, you're going to be here, aren't you? I would expect, or somebody from DOC will be here in the first week of May for the land and freshwater chapter.
Yes.
Well, how about, I've made the challenge to you. The opportunity is there for you to respond to that, if you would, at that occasion. All right.
Yes, thank you. That's very helpful. Thank you.
Thank you. At paragraph, bottom of page 6, top of page 7, you've emphasised the challenge to the use of the terminology net. And just looking at eco, sorry about this. Eco 01, which is where the challenge has been made, and you've referred to Mr. Brass's evidence in that regard, but it's also an Eco 02, but in the reverse. So Eco 01 is talking about a net decline, and you've given us all the reasons that was in summary that Mr. Brass advances against that. But has there been a submission by DOC in opposition to the word net increase in 02? And the challenge again that I've raised, I'm raising this question really more for Mr. Brass to answer or think about before he addresses it. If you didn't, why not? And how can you, in all logic, oppose it in 01 if you haven't in 02? Now, I'm assuming, and I don't know the answer to that, so I'm really asking you, do you know, Ms. Warnock, do you know whether there has been a submission by DOC against the word net in 02?
Yes. I do hear that,
right, okay. Well, Mr. Brass is going to have to address the other aspect of it. I'm not asking you to, Mr. Brass, in terms of how, in logic, can we deal with one and not deal with the other. Right?
I suspect so that links to the idea of protection as well.
Just jumping over to pages 9 and 10. Just as you were making those submissions, and funnily enough, it's one area where both sides of the spectrum seem to be in agreement about mitigate, minimise, so that may not become an issue subject to what the ORC say at the end of the day. But it is interesting that in that regard, and also in regard to, and again, there seems to be agreement too, or largely agreement about reversing the statutory hierarchy between remedy and mitigate or remedy and minimise. But it is interesting that what's happening in both those cases, largely bias, almost consenting was, is something that's not in the RMA. It's changing the words in the RMA, and it just makes me think that one probably shouldn't be too critical of the government, but the government is allowing a situation to arise where the NPSs are effectively in advance of the RMA in quite a lot of respects.
Yes, I'd agree, and it will be interesting to see what happens with in terms of the bill and in that context, the wording in the new bill.
Yeah.
Completely agree. So of course we're how many years on, 40 years on, and thinking about it, and we've had a plethora of jurisprudence in that time that's looked at these issues. So
simplifying legislation that was
I think it's called statutory interpretation. So yeah.
Not 40, I'm not that old.
How many? 30.
Yeah.
Not maths is not my strong point.
The only other challenge that I think I've got for you is, oh no, there are two more, but paragraph 33. The challenge that we're hearing from the infrastructure people and Oceania, obviously, and others, is in relation to the offsetting and your responses to 104, the 104.1 argument. Your responses have regard to means give genuine attention and thought to, and I don't disagree with that. But really, where their challenge is a step back from that, because they're saying that in appendix. Sorry, this is so much paper. In both appendix 3 and I think appendix 4 is the same. The opening wording is blunt. But biodiversity offsetting is not available for an activity. And so they say you can't have that because under section 104 1AB, sorry, the requirement of law is for a decision maker to have regard to, as you've said, and agreed with. You've said give genuine attention and thought to, but how their challenge is, how can you when you can't even get to the decision maker? Because the policy statement says you can't go. It doesn't even get to the decision maker. So that's what's underlying their argument. Now, again, not asking you to respond off the cuff. I'd like you to give that some consideration and give us some considered submissions on that. All right?
Yes, certainly. Thank you.
And the final one was a more practical one, and it relates to the paragraph 38. So you're saying it's important to remember SNAs are not locked away from all uses, rather they're protected from adverse effects. But again, the farming community, and we've yet, and I haven't read the evidence, Mr. Cubitt's well ahead of me on that in terms of the ODOG evidence. There's a wealth of farmers, but what I'm anticipating is going to be saying is, look, if you set the bar too low in terms of SNAs, we actually can't carry on a lot of our farming practices, and particularly in relation to tussock lands, of which we've got 1 million odd hectares in Otago. So what is that not a valid point? That if you set the bar too low, that's the outcome in a practical farming sense?
I think that is a valid point, and there is debate about where that bar should be set. it's not going, it's going to hinder certain activities that people want to do because of the adverse effects. I accept that.
Right.
It's not going to hinder all activities, but it's going to hinder some activities that people want to do. And so there is some debate, or there's a lot of debate about where that bar should set and how we should categorise SNAs, of course.
Yeah.
And you'll see that there is even a range of debate amongst the Department of Conservation experts on that. But what they will constantly say and consistently say, and I hope that this is the strong message from the Director General, is that if you get the policy framework right, then the details contained in APP2 are not quite as critical as they've been made in this hearing. And I think this is something that particularly Dr. Richardson will speak to when she gives evidence.
And that really brings me, your response really brings me to the last point I wanted to make, which was to take you back to page 4, top of page 4 in the first line. And I was following quite well on the previous page with you. It said that the exposure draft of the NPSIB has weight in the sense that it's been prepared under the RMA. I thought, yes, that's fair enough. B, it represents current best practice. And then we got to the phrase and considered consensus of technical experts. And I have to say to you, having sat here this week, I'm struggling to see a consensus.
Perhaps it will never be considered, but perhaps there will never be consensus of technical experts. Mr. McKinley wants to say something, but it is the best efforts that they have got after a considered process. Yeah. Is that a better way of? Would you allow Mr. McKinley to address this?
Oh, yes.
The debate you've heard this week is related to Appendix 2, not Appendix 1 in the NPSIB.
Right.
So, I think that we haven't heard any, I know, and the time I've been sitting in the hearing, I have not heard any debate about NPSIB Appendix 1.
Right.
So I'm not quite sure that.
Well, you're correct with, yeah, I take your point about that. Yeah. But certainly in terms of Appendix 2 or Appendix 3 or 4, you'd be struggling to suggest there was a consensus. Even amongst the opposers, there are differing views, as Mr. Kiewit took them through the other day. Anyway, there was an observation more than a question. And so that concludes the questions from the commissioners, and so we can move on to the
Thank you. I will call Mr. McKinley first.
Good afternoon. I think my evidence supplementary note has been circulated. All right, sorry. So I'll take the first page as read because it's just introductory and summary of my previous evidence. But on page 2 and onwards, it's some further matters which I'd like to discuss with you. So further to my substantive evidence, an issue that's been raised about the recognition of the impact and application of the New Zealand threat classification assessments in terms of those species whose indigenous range includes Otago and extend beyond the region's boundary. So many threatened species do move at a significant geographic scale, and this does have real implications for how our regional policy statement and subsequently regional and district plans promote the objective of Otago's indigenous biodiversity as healthy, thriving, and any net decline in any quality conditions. Quantity diversity is halted subject to changes as a result of the decisions as a result of this hearing. So I've just taken the notified wording of Eco 01 there. In response to this issue, I revised my thinking, and in order to give more specificity to the regional policy statement and consequent plans, I acknowledge that policy should reflect that some species have a range beyond Otago and others move seasonally in and out of the region. Equally, there is a group of species which are found only in Otago and consequently can be described as endemic to Otago. To be able to meet the stated objectives of the RPS needs to have objectives, policies, and methods which reflect this biological reality. In some respects, species which are sessile, those that don't move, are the easiest to develop an object for. Those endemic species found only in Otago should have clear outcome statements in the RPS as described in paragraph 149 of my substantive evidence. At the other extreme are those species which are highly mobile and range far beyond Otago. Definitions of this vary, and there is a version of a list for birds and bats contained in the NPSIB exposed draft appendix 2. Some entries in this list have direct application to Otago, and there is an expectation in the NPS that regional councils will address this issue in the RPS, and I quote, the relevant passage, paragraph 3.20 there. However, the NPS is not a perfect document, as for example, the list in Appendix 2 omits any reference to migratory fish. Paragraph 3.202 is also of limited utility as it includes the phrase, if it will help manage. Delegating this assessment outside the NPS is going to cause work, debate, potentially litigation. Between these two extremes is potentially the most difficult category of Indigenous biodiversity to develop policy for. Those which are not sessile and those which are not extremely mobile. Within this category are those species which are more widely distributed than just Otago, but for which Otago contributes a greater or lesser amount of the total. This is a dynamic space as biologists in the field continue to contribute field observations, data and analysis to describe the situation of the distribution of such species. This challenge is actually illustrated on pages 17 and 18 of the Wildlands 22A report, where the development of recommendations relating to lizards require the creation of significant and potentially significant categories. Some of these species move in regular patterns, others randomly to exploit resources during the year, but they depend on resources in Otago being available for them to exploit when required. And others are found naturally beyond Otago, and the development of objectives and policies and methods within Otago will measurably contribute to enhanced populations nationally. To be able to develop an objectives and policy framework within the RPS which recognises the correct scale at which to consider the appropriate measures for implementing ecological outcomes in the RPS requires further work. However, I do not agree that species which move in and out of Otago or for which actions outside Otago may drive declines independent of what occurs in Otago should be excluded from consideration by the RPS. The issue for me is not how to exclude the species which are not endemic to Otago, but how to get the balance of what's the appropriate contribution of the Otago RPS to ensuring the survivorship of these species. I have highlighted the need for the RPS to have outcome statements which are meaningful and measurable. I think that for species where Otago is a significant or important contributor to their threat status, this should be reflected in the RPS. And I think that this revised wording for the objectives captures what is intended or required. Failure by the RPS, I haven't read it out because it's recycled out of other evidence, out of other submissions. Failure by the RPS to have policy and guidance for all threatened species, even those which, while found out in Otago, are not endemic, will potentially lead to a worsening of the threat classification for such species. If all regional councils only created a policy for species which are endemic to their particular region, then it might be great for some plants, but it could be disastrous for threatened species which cross regional boundaries, e.g. rival, bitland, reeves, etc. So while addressing the recognition of endemic species through policy is relatively easy, there is a real gap for those species which are threatened but are more widely spread. Excuse me. I'd like to talk now about the assessment of significance. At the request of the hearing panel, an expert witness conference was held on the 31st of March. I attended the expert conference and signed off my views in the joint witness statement. The request of the hearing panel set out in minute 9 was to do caucusing to seek to achieve agreement between the experts on matters which are essentially of a technological nature. The agenda that the caucusing was given was as follows: review Appendix 1 and Table 1 record, and B, review Appendix 2 of against the draft NPS criteria in Table 2 below and record. Consequently, because of the fact that item A was asked for by the panel, but item B was added in, we focused on item A. And in the time available, we did not complete any substantive work on item B, which is a critical evaluation of Appendix 2 against the equivalent draft NPS IB criteria. As a result of the expert conference on 31 March, I think that the conference did what it was asked to do, but this was the wrong question. In my opinion, we should have been focusing on the detail of Appendix 2 as notified in the differences that the various submissions have made, but testing whether EMPS-IB Appendix 1 is a better approach. So a theme of my engagement and evidence in the RPS process has been to promote an integrated policy statement across the domains. And I refer there to NZCPS Policy 11, Indigenous Biological Diversity, and quote the relevant passages out of that. Consequently, a problem of implementing of the Appendix 1 of the NPS-IB is that the language of this NPS and that of the approved and predominating NZCPS are not consistent between terrestrial domains and coastal and estuarine domains. Appendix 1 NPS-IB is an ecologically based assessment of significance based on a wide range of ecological criteria. Compared to this, Policy 11 of the NZCPS is much more directed to avoiding adverse effects of activities with a focus on threat species and not assessing significance. Ideally, expert caucusing or conferencing should have been used to explore and test how the RPS could incorporate these two conflicting approaches in order to provide for an integrated approach to the assessment of significance across all ecological domains. In lieu of this careful consideration, I support the adoption of into the RPS of the Appendix 1 of the EMPS-IB, even though it has shortcomings as outlined above. I have adopted this approach because the EMPS-IB reflects current thinking has been developed at a national scale, which allows for a consistent national approach to be developed in regional policy statements. As a result of the evidence and discussion at this hearing on the 17th of April, I wish to emphasise to the panel the following points. The general matters of the Joint Witness Statement, paragraph 5, refer to the need for a guidance document as essential to interpret the criteria for assessment of significance. I'd like to be clear that this paragraph 5 needs to be considered as an essential part of the process of implementing the objectives of the RPS. Examples of what is required are available and could as an interim measure be cited in the RPS as to what's required. Examples that I think give a detailed flavour of what is required to implement these criteria include the two references there, one by Dr. Lloyd and one by Davis, Head, Myers and Moore about assessment of significance. There are probably others, but these illustrate the criteria do need interpretation and that such resources are available. Undertaking an ecological assessment is a matter of professional judgment. The criteria and the guidance explain the what of an assessment, but do not deal with the how. An assessment requires critical evaluation of the site, the ecological values present, and the criteria to be applied before drawing conclusions. It is an iterative process where judgments are required at each step and proper justification is recorded to ensure transparency and the basis of the evidence applied. I do not agree that it can be described as a tick box exercise or that certain criteria can be glossed over without proper evaluation. Therefore, in my experience, it is useful to have a full set of criteria to provide a robust basis for evaluation. Recognising the particular attribute of mineral resources, i.e. that they are fixed within the landscape and policy needs to reflect this, can be problematic. Providing for this potentially expensive other values that might be present could lead to perverse outcomes. I think that establishing a different consideration for mineral resources compared to ecological resources is erroneous and needs to be resisted. Inasmuch as a high priority mineral site is the result of abiotic factors that have interacted at a site and produced a mineral resource that is valued by society, so is the action of abiotic and biotic factors at a site led to the creation of important ecological patterns. Neither is movable to suit the other. In a policy framework, they need to be addressed equally and given the prominence they deserve. The RPS should, in my opinion, clearly set out policies so decision makers have the full context of the community to be able to make a reasoned decision. And I'm now available to answer questions on this and my substantive evidence from November last year.
Thank you, Mr. Pillow.
Yeah, thank you, Mr. McIntyre. I certainly found your evidence interesting, informative, and it's helpful through summary too that you've actually responded to what's been happening over the weeks. I do have some questions on your evidence. I think the first I was interested to read your evidence around the upper Taieri wetland complex in Scroll Plain. I flew over it a few weeks back on my way back from Invercargill and was sort of glued to the window looking down, taking pictures. It's amazing, it really is. I then went home and read a bit about it actually. And one of the questions I've got though for you around that, it was a couple of questions really, those and also the salt salt ecosystems that you talk about as well. What's the sort of ownership and protection around those at the moment, if any?
I've enjoyed that flight too, so it's pretty neat. So, so the Upper Taieri and the Sixth Basin scroll plains are large and expensive, and a multiplicity of ownerships. Some of it's in public land, and some of it is in private freehold. And there's actually some other bits and pieces in there which are local authority. So there's a range of tenures. The contrasting is the same way evidence, the saline areas, not necessarily salty, are generally small and spotty across the landscape, and have pretty much all in private freehold land, and some of them have protective mechanisms over them under the Conservation Act or Reserves Act, and the QE2 National Trust Act. Yep. And in some respect, the reason why I highlighted those in my evidence was to show them as examples of where they are unique ecosystems in Otago, and where the RPS can give guidance to regional and local authorities about promoting the significance and promoting mechanisms, formal and informal, to engage with those landowners to understand the values and how to protect them.
Yeah, I mean, I think it was quite obvious looking down on the scroll plane that we sort of see some encroachment of agricultural practices. I mean, you talk about increased recognition in the RPS. I mean, are you proposing there, and I didn't see this picked up in Mr. Brass's evidence, but given that these are unique and national systems, are you proposing specific recognition in the RPS, or just wanting to make sure that in whatever way the more generic provisions are in there, they would actually pick up and elevate these types of areas?
And it is, no, I don't think it needs to be specific recognition. That's the role of a plan, but it needs to have a policy framework where a plan is going to pick that up, whether it's a regional plan or a district plan. And when I think in my understanding of the hierarchy of implements in the RMA, it's at the plan level where these specificity of site, specificity of land use, and specificity of management of adverse effects really have to be examined through rules. So the RPS is at another level above that. So I think that, so it's the former.
Okay, no thanks. So that was a little bit I wasn't quite sure what you were intending through some of your comments there, so thanks, that's helpful. Sorry, I'll just find the next question. In the meantime, one of the, and recognition of the New Zealand threat classification system is something that's certainly come out through the evidence. One of the things that we heard from Dr. Keesing the other day, he was saying that rare species aren't as important as in ecosystems. And I think he was talking there about ecosystem functioning. And he was, I suppose, to some extent, brushing off the rarity criteria. And I'm just wondering how you'd respond to that.
I will. However, my colleagues just pointed out when it comes to recognition of areas that to be priorities for identification, we have talked about under Eco M2, those sites being part of that priority program. So, there's an analogy about being at the airport and wandering out to see the plane, and there's a guy taking out rivets of the wings to save weight. And the question is, how many rivets do you take out before it becomes unsustainable? So I think there is this issue about ecosystem functioning compared to the rare or the unusual or the unique. And I think it's, as I said in my supplementary evidence, when you're talking about ecological assessment, it needs to be a full and reasoned assessment across all the values. And so just picking one out at random or one out to suit is, I think, almost a flippant approach, because if you start to unpick things that are rare out of a system, when we look at the ecosystems we've got no idea what these rare species contributed if the system was whole and functioning. I mean, we have a tattered landscape with ecosystem functioning for a number of species, and we really couldn't draw robust conclusions about what is the contribution that a rare species might make if it was present in large numbers. And in my time, I've been involved in some species conservation programs, and we, as part of a partnership with Ngāi Tahu Whānui, we brought weka back from the Chathams to an island in Lake Wanaka. And what really stunned me, or one of the many things that stunned me about that project, was the fact that the impact that weka had on soil structure, and that because they scratch around, they actually plough the ground. So instead of a Central Otago sun-baked rocky island being hard, the substrate under the bushes where these weka were active was, quite furrowed, and the soil was soft. Although I didn't see it happen, I could guess that the fact that the soil was soft as opposed to hard would lead to increased germination by seeds and things like that. So when I look at a landscape, I'm very reluctant to sort of say we don't need that bit, we don't need this bit, because we don't actually understand these effects. And actually some of these effects take many, many years to work through before you understand them. And I guess, the introduction of wolves into Yellowstone National Park in terms of the impact on deer herds, there were some really unexpected ecological effects because the balance was changed again, whereas before it had been out of balance. So I just don't agree that you can just take all the rare stuff and undervalue it. But at the same time, I do hear that ecosystem functioning as we see it today is driven by the common and the widespread. So a bit of rant. Excuse me.
Oh no, that's helpful. I was interested just in your paragraph 13, where you're referring to the table that you put above and saying that 6 of the species are only found in one location, and e.g. the Clutha woollyhead. I'm just wondering if those 6 species, is that due to lack of surveys, or is it likely to be that restrictive? Some examples we've got where once people start scratching the surface, we do actually find a number of other populations. But how confident are you that they are actually seriously restricted?
I am, because the threat classification for plants has gone through about 2 to 3 iterations. So the botanical experts at a national scale have critically evaluated new information. The fact that in previous iterations are either nationally critical or nationally vulnerable would have driven awareness within the botanists to actually go and look for them and check out other sites. Yeah. But I think the point of the table is more to illustrate the fact that the Section 32 report didn't really drill into these species as species. And the fact was that it was trying to illustrate the fact that plants need to be recognised in the RPS as much as animals or animals. So that it's not just they're a component of the ecosystem, they're actually threatened species in their own right. So the use of Table 3 in driving a project within local or regional government or with Crown to actually confirm this and actually get up-to-date information is an outcome that I would seek. So.
I'll just check if I've got anything else in here. No, I think that's all. Thank you very much.
Thank you very much, Commissioner.
Thank you. Yeah, thank you. I think Ms. Warnock suggested in her oral presentation here that the criteria probably discussion is probably not so important if we get the policy framework right. I'm not so sure I agree with that at this stage, but you mentioned section 32 there, and it's been raised as an issue. And I'm not going to go through the joint witness statement and highlight where all witnesses disagree, like I did with Asiana, but you do note it for in terms of section 42A report, and you just mentioned it, that you didn't consider it relevant in terms of the implication of highlight implementing the criteria. So I guess my question is, why not in that context? Because you do address the gaps, I think, in your section 32 analysis in your evidence, and it's been raised and it sort of relates to some of the questions that I have of you around the lens environment when the threatened environment classifications. When I look at your figure 1, yep. So the coloured stuff in that is 10% or less. When you look at that area, Otago's actually got a lot of areas that are above 20% or above 30%, I think. A lot of the areas identified in the colour there are possibly most of them farmland that used to be totara that's now tussock lands. So that's always going to be an issue, because if we use pre-human start point, which I think you also raised as an issue with the exposure draft, I don't think that, I'm not sure if that's been changed, but the representative criteria in the exposure didn't have its pre-human start date to it. That's right there. So I'm interested in why you don't think that implementing the criteria, the implications of that, have been analysed as part of the section 32A reports. You suggest it's not relevant because we have been told it is, and it's the farming community who are probably looking at that and are concerned about where SNAs might drop out of in those environments. And related to that is the policy framework, where, as we've had this discussion, and Mr. Brass will probably pick up on it, Mr. Brass raised the concern around this. This is a question, sorry, Mr. Chair. But Mr. Brass raised the concern around, I agree with this concern. It was around, I can't remember, I think it might have been policy 3, is where just because it's not met doesn't mean say it's not an SNA, and you need to address that. And it's pretty standard planning practice. I didn't have the same concern with him as how the current setup works, because the issue that we've been raised was that everything is picked up by P6, and it's got a very strict and stringent test to get through, even if it's not significant. So it falls into that anyway. That is the concern that's been raised by pretty much all resource users. And it's when they look at the spatial extent of this stuff that could be picked up by that criteria, and not even picked up by the criteria as being significant, merely by being issues biodiversity. So I would have thought the section 32 analysis of that is pretty significant.
So you're talking about a specific statement in the joint witness statement. You're asking me about that detail. Yep.
Yeah, well, you've said it's not relevant.
Yep, in that context.
In what context?
So this is in the head notes to the
it's about implementing the criteria and the implications of that. If the criteria is going to pick up huge areas that may not necessarily be in the eyes of some. The concern is, well, that hasn't actually been analysed through section 32A. The implications of that, you have to do a cost benefit analysis and all that sort of jazz.
Well, I don't think it's the role of the ecologists to actually do a cost benefit analysis. And I think that some of what I think you're referring to is actually going to be resolved when this hearings panel makes a decision about what the criteria are and how the policies relate to it. I mean,
Problem with that is you're all telling us different things, even on the same team.
yeah, we were in the same room together and we were very civil, but there were clearly about 7 or 8 teams in the room and they changed all the time.
But even within teams, they were different.
But there was no,
Your
within
three-
topic, they changed.
Oh,
Cross topic. So when we we're in the joint witness statement, I was trying, in my mind's eye, what I wanted to do ideally was actually reflect on the relative merits of APP2 out of the notified RPS and Appendix 1. And the guidance from the mediator was we had to focus on the request from the panel first. Fine. But if we're going to just reflect on that Appendix 2, and we couldn't even reach agreement that we should actually reflect on the role of Appendix 2 in the context of the policies and objectives in the RPS, then I saw a little point in actually diverting even more time away from that particular time about what is our agreed position or areas of agreement on APP2. I mean, there was no mandate to actually broaden that conversation out beyond APP2. If the process needs an evaluation of how assessment of significance and the impact of that in the Otago region, that's quite a different question from figure out which bits you agree on.
okay. So you're saying it wasn't actually a part of the process you went through.
And it wasn't me that raised the Section 3242A report as a matter of topic. I was asked to respond to it there by one of my peers.
Yeah, okay, I got you now. So in the context of what you're doing there, you didn't think it was important. Well,
Yep,
it was
that's what I said.
relevant because you couldn't go.
Yep.
Yeah. Okay, I understand that now. Then you also say we really should be using Appendix 1 of the exposure chart.
Yeah, and I've highlighted where I think that's problematic, but I still think that, well, what I saw on Monday afternoon and at the conferencing was just a diversity of opinion. And at the end of the day, someone's just going to have to pick one up and run with it and live with the consequences.
Unfortunately, that's us. That's why I want you to give me the answer.
Well, my answer is go with Appendix 1 of NPSIB.
Do we have submissions that would allow us to do that?
Yes.
Yeah. I didn't read
Probably
this.
depends on the timing of the submission.
Yeah.
What was the form of Appendix 1? So in other words, really has Appendix 1 changed between the date of your submission and the current draft? There's been a number of iterations. Can you research that and let us know?
Yes, certainly. And then we may get into discussions about scope.
Sorry?
And we may get into discussions about scope of
Well,
submissions.
That's kind of weird.
Yeah, that's what Commissioner Kevin's questions raising.
And it's probably.
And the lead up to that, and the preamble to that last question, you canvassed quite a lot. And
yeah,
and there has been quite a lot of discussion about some of the tools that are available to assess representativeness, and there's been discussion about ecological districts and lens and stuff like that. And I just would like to be clear that the lens environment is counter the Land Environment New Zealand scheme lens is counterintuitive because it looks at the landscape that we look at with only abiotic factors like climate, rainfall, radiation. So when you look at a map of the lens zones across New Zealand, in many, many ways, it's not what you expect to see because we put the vegetation lens across it, or there's a river going through it or stuff. So it's actually quite a different way of thinking about landscape. So it's an important input into an ecological assessment because it brings a different lens. And if I was doing an ecological assessment, I would look to that lens to inform my judgment on that particular criteria. Equally, I would look to the ecological districts framework to inform my assessment. So these should be seen as inputs into this process, not a cast iron gold standard about what the result's going to look like. And
I think what you were saying there is exactly what Mr. Luna said yesterday on behalf of DCC. When I asked about those assessment scales, and she suggested you should be keeping them all in because it will depend on what you're looking at, which one you go to. You don't need to apply all of those. Depending on what you're looking at, be conscious.
that's right. And so at the end of the day, an ecological assessment for significance or environmental impact is, by definition, has to be site-based.
Yeah.
And so one of the problems that I perceive in this process is you're trying to think about across a region, but the actual implementation of it is going to take place at a different scale. So I think that sort of says to me, pull back and look at a high level and allow the detail to be thrashed out at site, not at a higher a policy level.
That's where the nervousness sits with the landowners, because
but equally,
I've seen that before.
Yeah, right. So I've got significant nervousness if we don't get this right, then significant ecological areas are going to miss out from being included in avoidance of or management of adverse effects. But it doesn't, I mean, we've got tools, and you've highlighted figure 1, which again is an illustration of a particular way of interpreting those tools. It needs to zero in at what is the site you're looking at.
Yeah. Just going back to the exposure draft, Mr. Winnick might help, but there is a timing section in there. It's not gazetted, but talks about the extent to, it's got some provisions around if you think that your RPS actually gives effect to, you don't have to change it, or if you do have to change terminology, it's just a Schedule 1 process. Is that 4.4 helpful in this context? In terms of if the committee was of the mind to adopt that Appendix 1.
So my comments only relate to Appendix 1.
Yeah, no, this is the process. This is actually more of a question. It's more of a legal thing. We're at a point where a lot of work's been done on this.
If the panel chose to listen to me and to adopt Appendix 1 in, they'd actually be ahead of the national policy statement. Or agree with me. Yeah, so I'm not sure, because the timing chapter appears to me on a first glance to be about things that are already approved and implemented.
Yeah, it is.
And you're slightly in a different context.
If we put an RPS out that actually had what's in there now, and that may change slightly through the implementation, but it'd be, I see that as saying, well, it's close enough, so you're okay. You don't have to go and amend your RPS. That's thinking ahead. I guess in terms, but with that exposure draft, you're quite keen for us to adopt Appendix 1, but not so keen to adopt the carve out for minerals. Because that's in there too, isn't it?
But yeah, I guess the comment there was, I get very frustrated that minerals or other mining type resources say we are stuck at site and we are unique in this. And I just disagree with that, because I think ecological values are at site and they're stuck at site. And I just wanted to raise with the panel the fact that it's not a unique situation, that ecological resources are equally stuck at site according to biotic and abiotic facts. I just wanted to illustrate that and to even the playing field, all the consideration.
Yeah, that's where the issue comes in around. I think someone put that question to Dr. Lloyd around whether compensation achieves objective 1. even though you guys don't like a duplicate one. Because it's not like compensation.
But it's actually not about compensation. It's about having a policy framework that doesn't say you're stuck at site and that's okay, and you're stuck at site but you're movable. I'm just trying to say that the policy, the RPS, should actually recognise that a number of resources in Otago are stuck at site, and that the policy framework has to recognise that and assess them on their merits for the use proposed at that time at that site.
Well, I think that is recognised, and that both of them are stuck at site, as well as a pathway that somehow be found if it's critical.
But in some respects, it strikes me that's a resource consenting process. You've got an application to do thing at a site. Does the decision maker have all the context, both for ecological resource and mineral resources, to actually make a good decision?
Yeah, it's all evidence. Thank you for that. I don't think we need to get into details, but it was a useful discussion. Thank you very much.
Thank you, Commissioner.
Just following on that exchange you've just had, the difference though that you're saying that it's at the resource consent stage that you make that decision is that because of the way that the appendices 3 and 4 are worded at the present time, the complaint from the infrastructure people and the mining people and the aggregate people is that they can't even get to the decision maker because their priority is immediately given to the one that's stuck at site, i.e. the Indigenous biodiversity that happens to be at that site. So what they are asking for is a consent pathway to do exactly what you said, which is look at site, having heard the evidence, should we be, in essence, allowing infrastructure at this location, or saying no, you can't do it, can't have your offset, or alternatively saying yes, on the evidence we're satisfied an offset can occur. So the question I'm really intrigued for your response is, do you accept that you seem to be accepting, and that the best thing to be done is to look at the particular site characteristics in any particular case?
Yes, but you have to always look at the site. Ecological assessment has to be site-based, but additionally, there are, as a decision maker, as an elected official or a commissioner, there are the expectations of, particularly for a council, what is the needs of society. And I mean, I guess my first preference is that we go, it's either avoid the adverse effects rather than head down, mitigate or compensate. But I mean, if a decision is required to make at site where mineral extraction is given precedence, then that will have to be argued, it should be argued on its merits at time in front of a decision maker who's got full context. But, the point was just to sort of say, the ecological resources can't move through the landscape.
I think everybody accepts that.
Yeah.
Well, certainly, I accept that.
Yeah, cool.
But I suppose the nuance to it really is in respect of some of the natural biota, if you like, or whatever we're doing, we want to use. Should there be an opportunity to assess whether or not it can in fact be offset or not, or compensated for?
So I think there's a threshold that's somewhere in there about threatened species, one basket, but for indigenous in a landscape where there is still indigenous components to it, then yeah, I think that on its merits.
What about at risk? If you look at, if you take Matagari, for example, or Tussex, Montane Tussex, as I understand it, well, let's deal with Matagari because I know that that's definitely described as being at risk, at which it seems odd that you should have a situation potentially arising where you cannot even assess an offset or a compensation package because there happens to be Matagari for it.
Well, I mean, don't know, I guess there was in the last couple of days, there's been quite a lot of discussion about Kānuku and Mānuka and Otago. But there's been no discussion about beach forest, which occupies more or less the same amount. We seem to be very much choosing what's fashionable or not fashionable as the examples about what we value or not value.
Well, I think, no, I don't think you're probably being fair to the submitters. They basically, I think, are coming along here and accepting the very high value of beach forests in the lake. What they're concentrating on really is east of that, where you've had a degraded, since humans arrived, a degraded situation where the original indigenous cover's been removed, or largely removed, but you've got remnant indigenous biodiversity. And so they're essentially arguing that in those situations, they should, when they've got linear infrastructure, whether it be, for resilience purposes, to meet carbon net zero, and you've got to double the national grid or whatever it might be, that there may be offsetting benefits in a broader sense that should be open to be taken into account as part of an assessment at the site in deciding what's going to happen here. Are we going to allow that infrastructure to go through and have an effect on that at-risk species? Or are we going to say, no, you can't even look at it?
Yeah. I think it would be better if you actually had this conversation with my colleague, Miss Mealy, because she has done this work on offsetting. Right. So,
okay, can I move on? Yeah. Move back to one that's more akin to yourself. Your evidence was excellent, so thank you very much for that. But I was interested that, and I may have missed it, and correct me if I have missed it, but I didn't see you addressing what I would call the big picture, which is the climate change risk and the question of whether or not Indigenous biodiversity is really facing a major threat from that source, and that our focus, as much as protecting from particular physical aspects of change at a particular location, we need to bear in mind that we've got to try and get to carbon net zero, to try and do our nation's bit to remove that bigger risk, which in the bigger picture is a greater risk to the Indigenous biodiversity than necessarily the particular direct impact. Do you have a view on that?
Yeah, I don't have any practice experience about how to interpret that. I mean, we know it's happening. I see the modelling in terms of change in the frequency of frost or how rainfall is going to happen on the east coast of the South Island, but I can't bring to bear examples of how that's happening now in terms of those vegetation communities in Otago. I mean, I think I'm looking down the barrel of something I just can't describe. So yeah, I've tried very much to even with some exceptions, talk about what I'm meant to be qualified about. So the climate change is actually a very evolving process right now. Our departmental response to it is only barely out of the starting blocks about how do we protect our built assets, let alone our biodiversity assets. We're just not there. So, I mean, I do hear your request for it, but we'd need to get a different person here to talk to the panel about that.
Yeah. The problem we face is we've got the government has already passed the legislation that by 2050 we've got to have in place sufficient electricity or some other source of energy to be able to achieve net carbon zero. The generators are coming along and saying to us to do that, we've got to build the equivalent in electricity generation to equate to a Roxburgh plus a Clyde every 3.5 years through to 2050. That's going to mean a hell of a lot of linear effects, a hell of a lot of structural effects, whether it be for solar, whether it be for wind, or whatever. And that's going to affect Indigenous biodiversity. Yep. So I hear what you say, and I can sympathise as a scientist who obviously wants hard data, that you just don't have that hard data to give an immediate response. But our problem is that we've been faced with people who are saying pressingly we've got to get cracking if we're going to do this. So from our viewpoint, do we say, well, avoid those effects because you're going to actually upset Indigenous biodiversity? Or do we say, have a consent pathway and deal with it through the district plans as the evidence becomes available at a site-specific basis?
Yep. I don't hold any particular expertise in that, but I do recall living when I was a younger person through the debates about the Upper Clutha and the amount of dams we needed up there. And there's one built, the original scheme was 5 or 6. Plans of engineers change. The thought of building a lot more infrastructure at the opposite end of the country where everybody's going to use it strikes me as a wee bit silly, but I don't, it's not my area of expertise.
Right. So
I think that that process needs to be on its merits. It's clearly not going to be a carte blanche for Indigenous biodiversity because it's an effects-based management scheme. Neither should it be a carte blanche for infrastructure because it should be an effects-based scheme.
Right. Thank you. Can we turn to a subject that you have addressed in detail, and that's the wilding issue.
Oh, yeah.
And I wasn't sure whether you're coming back to talk about that next time or you are. Right. Well, let's leave that.
Yeah, we can talk about it. We'll make arrangements. Yes.
You'll be back.
Yeah,
Next
sometime.
time. Good. Okay, that's right. We'll leave that till then. But can I just highlight a couple of things in relation to your evidence, which I found very helpful on that issue. You might have heard some exchanges that have been made through the hearings about the fact that I've been horrified by just recently driving through the Mackenzie country to see what's been happening with wildlife, etc. But I'm particularly concerned that you've been critical, and I agree with you, criticisms in terms of the force or otherwise of what's in the regional policy statement at the moment about those. And I'm just wondering, and I haven't had time to go back and try and find and wade through the doc submission to have a look and see whether you've made any submissions or any suggestive wording about that. And so I'm really just asking, when you do come along next time, can you indicate a bit more detail for the panel what your submission says or what your views are, even if you haven't got a submission on that point, because others may have, on Eco P9, and in particular, Eco P9 2. And also, final thing on that issue, just what, if you're able to assist us by giving us any idea of the extent in Otago of the non-plantation forests. In other words, what, for lack of a better term, carbon type forests, permanent forests, and what you know about that. Because those are the ones that we can address. We don't have to worry about them in the ships. But I think otherwise, I think Mr. McKinley, I probably. I think it's been high level questions. That's all I wanted to say. Thank you very much. And thank you for the thought and effort that you put into it for us. Thank you.
Thank you. Dr. Richardson to speak to her evidence.
Kia ora koutou. So I'll run through my opening statement. Okay, so I provide here a summary of my evidence dated November 23rd, 2022, followed by further statements relative to Appendix 2. I might skip a little bit over the summary of written evidence. I talk about fish.
In fact, just as Mr. McKinley did, if you wouldn't mind,
Yes.
if you did start at paragraph 12, thank you, because we have read your evidence.
I would like to insist though that
Yeah.
I believe my evidence holds despite the further reflections I have over Appendix 2.
Right.
In my evidence, so skipping to paragraph 13, In my evidence, I adopted the framework of criteria for identifying areas that qualify as significant natural areas provided in the ENPSIB, Appendix 1. Following the joint witness statement, I submit that the statements in my evidence hold. However, I provide, oh, that's exactly what I just said. Fundamentally, as I demonstrated hopefully through my evidence, I believe that policies of the pORPS need to solve the issue of integrating management across the terrestrial, freshwater, and coastal domains for vastly different organisms and varying degrees of complexity. These policies should be able to switch focus from individual taxa to areas and their living biota, and incorporate the reality that freshwater environments are dynamic and subject to change. The criteria in Appendix 2 as they stand at the end of the expert conferencing might be good enough, although they need to be tested against pORPS policies in different situations. In particular, ideally, I would have liked the opportunity to conduct full thought experiments on all the criteria. It's particularly important to test Appendix 2 where criteria apply differently to various spectra, for example, terrestrial versus coastal versus freshwater, taxa, etc. It is yet unclear to me, for instance, whether the representativeness criterion can seamlessly apply to freshwater assemblages or to freshwater ecosystems. I thought that meeting at least one of the criteria may be a low threshold for significance, which in itself might not be a big problem. However, this needs to be confirmed by using different models and examples. When incorporating considerations of geographic scale, domain, or taxonomic group, uniform decision criteria or units seem ill-advised. One size does not fit all. Depending on the case, some groupings might be more relevant than others to determine significance. Such groupings may range from highly specific to generic and might encompass different scales, which might lead to difficulty to generate systematic or actionable policies. One approach taken in the Appendix 2 is to use the most useful spatial scale depending on the case considered, which might encompass terms such as ecological district, biogeographic region, or biogeographic unit. But this can be problematic because different delimitations of analytical units can result in different outcomes. For instance, I found myself struggling to find a term properly encompassing a notion of ecologically relevant area for the rarity criterion D2 that would apply across the board. Using fundamental definitions and concepts might be useful here, although this may also vary depending on assumptions or approach, methodology, and grouping used, which might explain the discrepancies between experts. So explicit and clearly defined criteria, and within criteria, analytical units might be useful to answer to policy objectives. This hints at the notion that case-by-case analysis and expert opinion should be systematically required, which was highlighted, for instance, in the JWS General Matters, Section 6, to interpret some of the Appendix 2 criteria. However, a strategy of opting for the best unit for each case might be lacking for clear policy development in the absence of clear direction on how to define that best unit for each type of question or each type of issue that arises. Therefore, this calls even more for policies and methods to be framed adequately. Choosing the best unit and scheme could be based on measurable objectives. I therefore support the DG's proposal for new objectives, which I believe addresses these concerns and still provides a clear pathway for outcome-driven policies. I also support the proposal and wording in the legal submissions and the summaries of evidence given today in the hearing by Mr. McKinley, Mrs. Mealy, and Mr. Brass. And then finally, a little bit off topic, but I would like to address one question that was previously posed to me by Commissioner Sullivan in the Coastal Environment chapter regarding threats to biodiversity. I answered the question at the time based on my personal impression and stated that, in my opinion, habitat degradation and regression was the most dire and direct threat to freshwater species. I maintain this opinion, noting that pollution, direct exploitation, introduced species, and the cumulative effects of all these pressures might contribute directly or indirectly to habitat degradation and adversely affect species persistence. The ANZBS Biodiversity Report 2020 provides a useful summary of data to support this opinion that you might want to refer to.
Thank you.
Yeah, Dr. Richardson, I thought your evidence was very clear, and that's been well supported by your statement here. So I don't have any questions. Are you back for the land and freshwater chapter as well?
Yeah, that sounds like my type of gig. Yes.
Excellent. I do have some questions which I'll pose to you. So thank you.
Yes, thank you. Just a couple of quick questions, and it's my ignorance more than anything. What is a biogeographic region?
I actually took the definitions.
Is there a definition in your evidence?
No. I took it as an addition in order to answer potential questions arising. So a biogeographic region is an aggregation of biogeographic units. And biogeographic units are fundamental units related to operational units, which are geographical, population, place, range of distribution, and biological, population and taxon, and are the basis for pattern description.
Not sure that helped me, but thank you.
So, this is where that issue of which groupings or which analytical units are selected to define a biogeographic region for the criteria.
So, I think the way that's written, the biogeographic region sort of relates to coastal marine.
So
it's all coastal marine biogeographic region.
Yes, so I'm not sure about terrestrial biogeographic regions. In my field of work, we do have, for example, a concept of biogeographic region for migratory species, which are basically the discrete areas where a group of migratory species might be recruiting within.
Yeah. I'm pretending I understand, but I'm not sure I do. Thank you. Then the only other thing was, in your paragraph 148, you were unclear what was meant by the terms decline in condition, quantities, and diversity. Mr. Bass has recommended, well, has changed that in his evidence. I'm assuming that's do they mean different things to you? I guess in the context of ecological diversity or biological diversity.
Yes, where I struggled was in understanding what a condition of biodiversity is what does it look like when biodiversity is in good condition? Like that is fairly, well, it's either too broad or too vague to make any ecological sense to me, because I do not know how to measure that.
See, I would have thought you'd be telling me whether that's in a healthy condition being an ecologist.
So, but again, healthy condition for biodiversity depends on, it's kind of lies in the eyes of the beholder. I do have a reflection about it, not about biodiversity, but about ecosystems, what healthy ecosystems are defined as, and there are differences in opinions among experts as to what that is. So I think the bottom line to me is to have a set definition and work with that definition to enact the policies. And then the differences in opinion don't matter as much if the definition is properly set.
Yeah. It's an interesting way to put that, because Marie sitting back there might be able to help me, because we had Fish and Game suggest, and this was going kind of related, the definition of restore in relation to ecosystems, which means return to a state of good health, well-being, and resilience. You're looking, but does that cause you the same sort of problems? And I think that was in the context of probably more terrestrial, maybe where we're, no, it wouldn't be, it was the river form and function as well, with that pre-human start point. So fish and games evidence was essentially not really realistic, getting back to that for some environments. So that, in the context of policies, use that word, that was the definition they came up with, but I'm not sure that that would help you either. Good health.
Yeah, I think that's the key point of advocating for outcome-driven policies, because in my mind, outcomes are quantifiable. They are associated with indices and measures that might not be perfect, but that would indicate a sense of progress or failure.
Yeah.
And I don't have any a priori about what these outcomes should go for. In Appendix 2, for example, a significance criteria threshold for areas is 20%. This is a space for bargaining, but first defining what type of outcomes are expected and then bargaining on those quantities or those thresholds would be the purpose of policies.
I guess what you're saying there, like, we take air or water quality, we can measure those, how good air quality is or quality of the water.
Yeah.
An ecosystem is a complex, dynamic thing.
Yeah. Very
hard to measure. Same with the landscapes. We'll probably get in trouble with the landscape theory because it's a very subjective thing. So how do we measure that based on someone's opinion that it's outstanding? And ecosystems are that complex like that as well. Yeah. Okay, thank you. I'm not sure I'm any further ahead, but thank you.
I have anything.
Just referring only to your eco paragraphs, I've got an apology to make to you really that I was probably a bit unkind in my note on your paragraph 148, because you said that you were unclear what is meant by the terms decline in condition, quantity and diversity, and whether condition, quantity and diversity refer to biodiversity or to something else. And I put really question marks because if we just insert the word it's or then doesn't that answer the situation? And any net decline in its condition, quantity and diversity is halting. That relates it to the indigenous biodiversity.
So how would you define diversity of biodiversity?
No, I'm not getting on to that.
Okay.
But just your challenge, I thought was easily overcome by putting in a possessive, because you're right that at the moment it's hanging there and it doesn't relate to the biodiversity, but it can be overcome really easily by putting a possessive. But the next thing that I did want to ask you about, though, is a bit more complex about that, and Mr. Brass might have some views. The wording has been suggested to us that it needs to be changed to one to be Otago's ecosystems and indigenous biodiversities are healthy and thriving. Is that an improvement, or does it not make any difference?
So is it for eco? Hold on. You want me to? So instead of Otago's indigenous biodiversity, Otago's indigenous diversity.
Ecosystems and indigenous biodiversities are healthy, etc. Or does that not make any difference or not in your?
There's a notion, an additional notion in ecosystems of structure, so structural components that takes into account biotic and abiotic elements. So it does improve eco-1 a little bit.
Yeah, no, thank you. I just wanted your view on that. And other than that, your evidence, once you explained to me the other week, some of the words that I wasn't following, is excellent. So I've no further. Thank you. Just for 10 minutes, or even 5 or 10 minutes, all right, and then we'll come back. So who have we got to go? We've got
Dr. Hendrik Schultz, who I'm just tendering, just have a written statement. Cassandra Mealy on office setting and compensation, who will be online, and Mr. Brass.
Okay, right. Thank you. Schultz. Where are you at? Did you want to make some points at the start, or are you just available for questions?
Just about questions today.
Okay, thank you. Right. Yeah.
Yeah, no, thank you. Your evidence was clear enough. We had questions at the coastal chapter. I don't have any additional ones for this stage, so thank you.
I'm the same, actually. Thank you.
I'm the same. I'm sorry.
It's okay. I don't take it personally.
No, I asked all that I need to ask, all the ones I had folded over with question marks. You've answered all of them. Yeah. Thank you. Thank you. There's Neely.
Miss Mealy next, and she's online.
Okay. And has she got a summary?
Yes, she does.
Good. That's no disrespect to you, Dr. Schultz. It's just that the New Zealand Coastal Policy Statement just happens to assist your area in a way that you've got all sorts of problems. We've just got a draft for the Indigenous biodiversity. Thank you. No slide.
She is. Yeah, just got the video.
Ms. Mealy, we're told you're there. You up to
Hello.
speak?
I can hear you. Can you hear me?
We can hear you, but we can't see you.
My screen is telling me that the video is failing to start, and I'm having trouble finding how to troubleshoot that. I have a spare computer which I can set up. I might do that quickly, if you don't mind. My apologies.
Well, alternative. No.
Could you see the video?
No, they had their settings wrong.
Ms. Mealy, are you there now?
Currently.
Yes, I am here.
Well, look, once again, we can hear you but not see you at the moment.
Yeah, I'm still trying to troubleshoot this. This is
Look, the best thing, we're under a bit of pressure of time. So the best thing will be for you to commence, and we're listening to you. We can hear you, and you can hear us, obviously.
okay, great.
We've got before us your summary, so headed corrections to evidence. So if you commence with that. Thank you.
Sure, thank you. So I've got a few corrections to my evidence noted there, but I won't read them out. There's nothing substantial there, but just a few minor errors. So starting from paragraph 4, overall, I support the inclusion of detailed provisions for the application, design, and implementation of biodiversity offsets and compensation, and the intent of these provisions to improve the quality of biodiversity offset and compensation proposals that will ultimately assist in the protection of the region's biodiversity. I strongly support the inclusion of an effects management hierarchy in Eco P6 that lists a specific cascading order of management steps to protect biodiversity from the impacts of development. Such a hierarchy is an international accepted approach that prioritises methods with the greatest ability to protect biodiversity. Without a sequential hierarchy, the overall effect on the protection of Indigenous biodiversity would be minimal. Sequential top-down hierarchies such as these, and for example, the reduce, reuse, and recycle waste hierarchy, aim to facilitate development or manufacturing, in the case of the reduce, reuse, and recycle, while maximising the protection of the environment. In light of this, I recommend that the order of the effects management hierarchy, as listed in the Section 42A report, is altered so that mitigate or minimise precedes remedy, as reducing the impact, such as reducing the area of affected, better protects the environment than remediation. which attempts to repair the damage. My recommendations for alterations to the biodiversity offsetting and compensation criteria in APP3 and APP4 follow current national and international best practice. The recommendations are based on well-established principles derived from a long-standing, since 2012, international agreement reached through the collaboration of more than 80 organisations, including business companies, government and non-government organisations, and financial institutions. The principles derived through this process remain well recognised in the field and are replicated in current proposed regulations and guidance documents. In addition to my aligning my recommendations with best practice, I followed the lead of the Otago Regional Council and tailored the provisions to the regional context. I have also recommended minor wording amendments to throughout APP3 and APP4 in my appendices A and B to aid clarity based on my experience interpreting similar provisions from other councils. I recommend that key terms are defined, including biodiversity offsetting, no net loss, no net gain, and biodiversity compensation to improve clarity and understanding. I recommend that several subclauses under clause 1 in APP3 and APP4 are removed as they are too restrictive. And this is referring to the clauses that reference individual threatened taxa, measurable loss of at-risk taxon, and the removal or loss of viability of threatened flora or fauna habitat. And this honestly does feel perverse to say this, but in my opinion, the policy is too conservative. And in my experience, these subclauses could lead to the skipping of biodiversity offsetting in favour of the more uncertain method of compensation, which could result in poorer biodiversity outcomes. Further, there could be some ecological contexts where the loss of individuals of threatened taxa or at-risk taxon or the removal of habitat for threatened flora or fauna would be appropriate, where there are acceptable and known ways to create a net gain with confidence, in my opinion. Clause 2 in APP3 and APP4 specifies where biodiversity offsetting and compensation may be available and provides guidance on the design and implementation of these methods. I support this approach and propose minor amendments and additional subclauses to ensure biodiversity offsets and compensation are applied in accordance with best practice. A crucial subclause alteration I recommend in relation to APP3 to B is the addition of the word quantitative prior to loss gain calculation. This addition ensures robust offset proposals are developed using measurable and objective data, which can be verified on the ground by an independent party. Given the predictive nature of an offset, inputting measurable, quantifiable data ensures that the offset outcome is reasonably likely to be achieved. The amendments and additional subclauses I recommend under clause 3 of APP3 and APP4, additional guidance, are intended to support the Otago Regional Council's direction to ensure the correct methodology and social and scientific processes are employed for biodiversity offsets and compensation. These additions go beyond the MPSIB exposure draft and are based on my experience with the design of biodiversity offsets and compensation. And that's it.
Thank you, Ms. There will be questions from the commissioners. We'll commence with Commissioner Sullivan. Thank you.
Yeah, thank you. And thank you for your clear evidence too, very helpful. At paragraph 36 of your evidence in chief, you say that you support the use of criteria in the title of appendices 3 and 4. We've had a range of views on this with quite a number of people requesting that they be principles such as is used in the exposure draft of the MPSIB. I mean, I suppose I'm just interested in what you think the key differences are between whether they're criteria and principles, and why you prefer criteria over principles.
Yeah, that's I've seen that come up in the evidence a few times. They are referred to as principles generally, and in the BBOP guidelines as well. Criteria to me is more robust, and overall, these principles are well established as being the core factors that make up an offset, So for me, if an offset was proposed that didn't meet those principles, it wouldn't be an offset. So for me, it's a criteria anyway that I would use to judge an offset. I think this could be very helpful in terms of if someone's trying to determine whether or not an offset is appropriate and they don't have the experience, having them as criteria could make it perhaps a bit more streamlined. Further, if it doesn't meet those criteria, that's okay. The proposal can just try and meet this criteria as best as they can and drop down to compensation. And that would make it a really robust compensation, but it wouldn't quite be an offset because it doesn't meet all of the criteria. Does that make sense?
Yeah, it does make sense. And I do wonder if the importance is in what the appendix is saying rather than what it's called, because if it's framed in a certain way where it does have the certainty that you're wanting, does it really matter if it's criteria or principles?
As long as they're adhered to or complied with, in my opinion.
And I take the other points, I suppose, of the Director General's evidence that it's actually the presuming this applies to Appendix 3 and 4 as well as Appendix 2, that it's the overriding provisions that are very important here as well. Just moving along here. Which paragraph are we talking about? I think we're talking about paragraph 40. Sorry, my question is cut over the paragraph number. You're talking about whether in criteria 1 under appendices 3 and 4, whether the criteria are applying to the offsets and compensation or the activity itself. And I take your point there where you're saying that if it's relating to the activity, perhaps it would be better in a policy. But I did note that some of what you're proposing in your revised Appendix 3 is actually relating to the activity as well. I think the new A that you're suggesting there, where you're talking about the activity will result in the worsening of the conservation status. So are you talking about the activity itself, or are you talking there about the offset?
I believe I'm talking there about the activity itself. So have you got the paragraph there that you're referring to?
Pardon?
Were you referring to a particular paragraph?
It's number paragraph 40. No, it's 39 at the end of the italicised section where you've quoted policy 7.2.
Yeah, okay, just finding it now. So there I was trying to indicate that these are policies that seem to place a limit on the activity itself. So if it was going to remove 5 individuals of threatened kiwi species, the activity is not allowed, regardless of the fact that you could make more of these kiwi species or kiwi individuals through an offsetting pathway, for example. So the way I read it was that it didn't take into account what you would have after you've applied the effects mitigation hierarchy, which could include reducing the effects, minimising, remediating, offsetting, or compensation. So it's very much an absolute term. So to me, it fitted better in a bottom lines policy. I guess it's separate to offsetting because it wasn't directly applicable to the outcome of offsets. It was applicable to what happens before the offset is employed.
Okay. Yeah, thank you. I'm not sure if you've read or heard the discussion with Mr. Mark Christensen a couple of days ago. He favoured the MPSFM offsetting and compensation appendices. Have you looked at those? I mean, they seem reasonably very similar. I mean, some wording differences from the exposure draft of the MPSIB, but have you put any comment on that?
Yeah, I did see that, and I listened to it. I have again compared them. They're essentially the same, the MPS FM and the MPSIB. There is one difference. I noted it was very minor.
Yeah, there was a minor wording difference there, but that was.
Yeah, essentially the principles are all the same in the MPS-FM and the MPSIB, and they also correspond to the BWOP guidelines that have been around for a long time.
Yeah, okay, no, thank you for that.
Thank you, Ms. Mealy. Bianca sort of covered the issues of relevance to me, and I'd just note that some of the recommendations you've made in relation to APP 3 and 4 are consistent with Mr. Christensen and others. So the only thing I was going to talk to you about or ask you about was the leakage criteria. How that works and what happens in practice there, because I have an example for you now. Might be wrong here, but Mr. McKinley may be able to help. I was told about a conservation area up in Central Otago when it was set aside. One of the reasons it was set aside for a particular plant, sort of a ground cover plant, was quite rare. So it was set aside as a conservation area, and that meant grazing was taken out. There was no sheep or anything allowed to graze in there. That ended up having the unintended consequence of that particular plant being disappearing because all the other vegetation around it grew up and sort of smothered it. Is that kind of what you're talking about here in terms of, I think it's in your paragraph 43E?
Yeah, I'm just thinking of paragraph now, but from what you said, yes, it accords with how I interpret leakage to be. So when you intend to protect one thing and you do management on that one thing, but that affects something else that's also valuable.
Sometimes it's very hard to anticipate, isn't it? So,
yeah, I imagine so.
I guess that's my concern around that as well. How do you actually crystal ball gaze there and what may actually happen? It's quite a hard criteria to meet.
I agree. Like with everything with conservation and ecology, nothing is straightforward and all that predictable. If it was, we probably have all the answers by now. So I think, in my opinion, we should just be striving to look out for those things. So let's think about what impact this management might have on something else that we value. Just making sure that we're thinking things through thoroughly.
Yeah, and I agree with you about should have all the answers now. It would be nice.
Yes.
Okay, thank you for that. Your evidence was very clear and helpful. Thank you.
Thank you.
Kia ora, Ms. Mealy. I don't have a question. I just want to confirm the comment that Commissioner to my right said about the evidence. You gave good evidence and was really nice and clear evidence for a non-tech person like myself. And enabled me for one thing to disabuse myself of the fact that Bob had nothing to do with the Bay of Plenty.
She's Australian. She won't know what you're talking about.
Yeah, but look, thank you very much.
Thank you.
Ron Crosby, final questions. Just paragraph 43, page 17, paragraph A, but it's earlier than that because it's actually a suggestion, I think, that you're making that there be a phrase that there are no technically feasible or socially acceptable options. What do you mean by socially acceptable?
Yes, that's a fair question. So, for example, if someone wanted to, if cats were an issue in an area, we thought to protect this value, an avian species, we might trap cats. But then we think, oh, we're doing this in an urban area. Is that socially acceptable to trap cats in an urban area? Another example might be we want to do some predator control in an area. We want to use some toxin, but is that socially acceptable with the locals in that area to use toxin? So just considering that factor, it doesn't have to be a hard and fast rule or measurable, but just consideration of the social setting in which you're doing the offset.
Right. Thank you. Broader question, really. Do you happen to know what lay behind the sudden emergence between October last year and February this year of the inclusion of the requirement for compliance with principles 1 to 6 in the NPS FM that slipped in after the exposure draft was out for submission?
Yes.
Do you happen to know what was the reasoning behind that compliance being inserted?
I do not know the reasoning behind that. In my opinion, as I said before, an offset would tick all those boxes from those principles, and I would be looking to see that they comply to be classified as an offset. But I'm not sure of the reasoning that they used to put that in, but that is my reasoning for agreeing with it being in there.
Right. In answer to Commissioner Sullivan, you talked about, in response to the issue of the terminology of principles or criteria, you responded and noted part of your response was that, to me, that would not be an offset if it wasn't meeting the principles, i.e. you took the view that it was a series of criteria. And the question I'm really posing to you is, who do you believe should be making that decision? At what level? Should it be at the officer level as to whether or not an offset can actually qualify? Or should it be for the decision maker in the round, taking into account all of the considerations, both Indigenous biodiversity, but everything else under Section 104?
In my opinion, an offset is quite technical. It encompasses all those principles as well as some balancing, so some mathematics and equations. So in my opinion, it would be better decided at the offset stage than by a decision maker who's already got enough, in my opinion, enough on their plate to weigh up, which might include external factors, economic, social, etc.
The problem with that, though, is if you looked at Section 104 1AB of the Resource Management Act.
Yes, I've seen that. I'm familiar.
And you'll see that it requires that a decision maker must have regard to any proposal for an offset that's advanced by an applicant.
Yes, I agree.
If it's decided at a technical level, at officer level first, it doesn't even get to the decision maker, does it?
I'm sorry, that last bit cut out. Who is to decide?
If it's decided at the technical level first by the officers that it is not complying with the criteria, then how does one achieve the requirement of Section 104 1A that a decision maker is assessing and making having regard to any proposal put forward for an offset or a compensation?
So I guess I would draw from the mitigation hierarchy here. That's been a long-standing hierarchy that has offset as second last and compensation as the last resort for management of effects. And I think I don't want to speculate anymore on the legal side of things. That's not my profession. I'm not skilled enough to interpret the law there. But yeah, I would refer to the mitigation hierarchy in terms of what comes first. And offsets and compensation is lower down on the hierarchy. And that's a well-established method. I think I'm going to ramble here, so I'm going to pass it back to you. Does that at all answer the question?
I think that was what you would call in rugby terms a classic hospital pass to Smaller, or possibly to Mr. Brass. So, no, look, thank you. As with others, your evidence was helpful, and I thank you very much for that. Thank you.
Thank you.
And I do have some speaking notes which are being handed out. I'm not looking to summarise my evidence. These notes respond to some letters which have come up in the hearing at the time when I write the notes. And with your leave, I will also provide some oral comments on other matters that have come up in the course of today. So starting at point 2, and this was the reference to the additional objectives referring to the NZTCS classification system. In my evidence in chief, I recommend that 2 new objectives be added, and Ms. Warnock has referred to that they refer to the correct classification system. The 42A report opposed these on the basis that the correct classification is a nationwide assessment. Therefore, the correct classification of the species found in Otago might not always be dependent on what occurs within the Otago region. I remain of the view that reference to the NZTCS is appropriate. However, having considered the concern raised in the Section 42A report, I consider that it would be possible to refine the drafting to avoid it being dependent on activities outside Otago, but to still recognise the species where Otago is an important contributor to their threat status. And that would include those which are only found in Otago, those which are mostly found in Otago, but also species which rely on Otago for a critical life stage. So my proposed wording is set out there, and the key change is putting the focus on activities within Otago rather than being driven purely by the threat status. At 4, the role of offsetting and compensation. Dr. Keesing has expressed a view that offsetting and compensation for development projects is the main way in which environmental improvements occur. While I agree that offsetting and compensation have an important role, my experience is that there are many other ways in which biodiversity improvements occur on the ground. These include such things as improvements in farming practices, voluntary landowner actions, the work of a wide range of community groups and non-governmental organisations, and habitat enhancement, species work, predator control, wildlife control, etc. And of course, DOC itself supports a lot of that work and does provide funding. And I would also note that those sorts of measures have been referred to by federated farmers earlier on, and also there's been reference to the work of QE2. Did that change to KE2?
Yeah, I was wondering that as well.
National Trust. So while I agree with Dr. Keesing that the pORPS should provide for the appropriate use of offsetting and compensation, it is also important that the pORPS supports and enables a wide range of voluntary measures that occur within Otago, and I refer to various provisions. Those provisions within the RPS would be expected to lead to regional and district plan provisions that, for example, limit conservation activities, enable pest control, enable restoration planting. I therefore support retention of those and any similar provisions in addition to provision for offsetting and compensation. And I'll refer to that point in my oral response on other points that have come up. And in terms of the approach to offsetting and compensation, and I'll start paragraph 7 and note that this is a planning response as opposed to Ms. Mealy's technical response. I totally bow to her technical expertise. And my view is that offsetting and compensation should act as a hierarchy. On a first principles basis, this is what the effects management hierarchy requires, and that approach gives the best overall outcomes for biodiversity. I also consider that the framework for offsetting and compensation is better expressed as criteria as principles. And some of my views on those matters particularly relate to how offsetting and compensation are considered under Section 104. In my experience, when offsetting criteria can be fully met for a particular effect, then that effect would normally be considered to have been fully addressed. So it would not weigh against granting of consent, but would instead be addressed through conditions that require implementation, monitoring, reporting, and so on. In contrast, where compensation applies, by definition, there are still elements of effects that have not been fully addressed, and it is then a decision on the merits as to whether consent should be granted and what conditions should be imposed. Given that, I consider that it is appropriate that offsetting and compensation operate as a cascade. So they're doing two separate things in a decision-making sense. And particularly for offsetting, if that's going to put an applicant in a position where essentially that effect has been negated in terms of 104 decisions, then that does need to have quite clear and certain criteria around it. But I do note that where not all of the criteria for offsetting can be met, it is still open to an applicant to seek to meet as many of the other criteria as they can. In my experience, this strengthens the value of the compensation and adds weight in favour of granting the consent. And so it's not, if you like, sort of an automatic that those effects have been negated, but it does place a very strong case for the applicant. And I would also note that for proposals with a range of effects, there may well be a mix of offsetting and compensation across the various effects, and such an approach is entirely appropriate. So while it's not a free-for-all mix and match, there is a hierarchy that you're operating to for different effects or different locations. If it's a large project, for example, you may wind up with a range of those measures that are applied as appropriate. And turning to the vexed topic of section 104AB, my view is that that provides, if you like, a general provision. So the RPS can provide more specific provisions, and the MPS FM itself provides more specific provisions. MPS IB, when the time comes, will also do that. But it provides a further step. So where a measure would not meet any of those applicable more specific provisions, there is that general provision for offsetting and compensation. So an applicant can still offer up measures that ensure positive effects, and these would then fall to be considered on their merits. So as an applicant, they're probably not going to weigh as heavily or as strongly in your favour as particularly if it was full offsetting, but they are entirely open to be put forward and considered. Just for the record, new method Eco M7A regarding Kaitahu Kaitiaki Taka, Akaha as requested, and Woodai report writer has supported, and just note that I also support the inclusion of that new method. And Appendix 2 significance criteria. The panel has been provided with a joint witness statement in this regard, which proposes some changes to the Act 2 significance criteria. Some were agreed and some not by all. While I defer to the ecological experts within the area of expertise, I do have some concern from a planning perspective. It is my experience that any combination of ecologists will seek changes to such provisions. I think that would have been referred to earlier, reflecting their personal backgrounds and views. And just to be fair to ecologists, I think planners are probably no different. My reading of the JWS is that most of the proposed changes are of that nature, rather than responding to particular characteristics of Otago's biodiversity. While such changes may have their merits, there is also merit in having consistent criteria across domains and across council boundaries. In particular, there will be many species of fauna which move across council boundaries, and also some habitats and vegetation which straddle such boundaries. I therefore consider that the panel should place weight on the national consistency, which can be provided by using the exposure draft MPSIB criteria, and that changes to that should only be made where there is some characteristic specific to Otago which warrants a departure from a national approach. And now just in terms of some oral catch-ups, if you like, Just while we're on that last point of paragraph 17, there was a question about whether anybody had sought the NPSIB criteria. The exposure draft post-dated the original submissions. The Director General's submission sought a specific set of criteria, but the wording of the submission also said, all provisions or words to like effect. From my knowledge of those criteria, what was spelled out in the DGE submission is fairly close to where the NPSIB exposure draft landed. So I would be fairly comfortable that all to like effect within the DG submission would give scope to bring in the NPSIB wording. Turning now, if I may, to some other things that have come up. And first of those is the distinction between maintenance and protection. And I would almost view them as a subset, and that protection is a subset of maintenance. Protection is sort of a specific defensive approach, whereas maintenance is broader, and in my view can include sort of active or proactive activities. And when I talked earlier about the RPS, which contains a lot of provisions that support voluntary measures, the works of community groups, landowners, and so on, I would see that those provisions and what they flow through to in terms of regional and district plans would fit within that wider maintenance of Indigenous biodiversity. But within maintaining Indigenous biodiversity, particularly where you've got significant vegetation and habitats, then a protective requirement applies. So I do see the two as related, but there is that distinction between them. And I guess that just from my own experience, I'm aware, for example, that the current regional water plan creates issues for agencies that are wanting to, for example, spray to control weeds in regionally significant wetlands. Similar issues around the use of toxins for pest control. And so I think there is a clear role for the RPS in setting out a framework that will lead to regional and district plan provisions that enable those activities, enable landowners, community groups, etc., to do what they need to do to maintain biodiversity without unnecessary hurdles in their way. Whereas protection is a narrower and probably if you like, a stricter arrangement. Now there was a question asked in terms of objectives 01 and 02 and the use of the word net in those. So no, the Director General submission did not seek a change to net in objective 02. The reason being that if the net is removed in 01, then that creates that protective element, and the use of the term net in 02 would essentially be trumped by 01 in terms of the ability to, if you like, sort of mine existing biodiversity to, and balance that off against enhancements. So it wasn't so much outright support for the use of the word net there, but more the thinking that if objective 01, the change made there was sought, then it became a moot point as to whether 02 included the term net or not. And noting that 02, because its enhancement will include activities in locations that
don't currently have much or any value, so there'll be restoration, replanting, those sorts of things. So they're not part of the current equation, if you like, and in that net sense are added to it as part of enhancement. Just briefly, there was some discussion about tussock and the concept that if all tussock was significant, that essentially stop farming activities across large parts of Otago. I guess just reflect personal experience in dealing with that, which is that tussock does have significance, but your common species have, if you like, sort of a lower level of significance than, say, a threatened plant species, and that protective role can then translate through to vegetation clearance rules, which provide a larger, in cases I've been involved with, a much larger allowance for clearance of common tussock species than they would for threatened plant species. So you're still providing that protection, but you're matching the protection to the species, and so it's not a simple case of if there's a tussock there, these activities are unable to proceed. It's more about matching the level of protection to the significance. Another, just a minor comment, the Apatoiri scroll plane, there's a question about how that related to, or how that should be reflected in the RPS. And I agree with Mr. McKinley that the RPS is not the place to sort of specifically extract out individual locations. But it does, particularly the scroll plane is a very complex and changing mix of land and water. And I think it illustrates that need for the RPS to operate successfully across those domains. If you try to manage the wet on any given day bits of the scroll plane separately to the dry on any given day bits of the scroll plane, it's simply not going to work. So providing for the scroll plane, one of the ways that the RPS can do that is by how it integrates across the domains. Turning to Eco P6, and there have been questions raised or discussed about whether, as currently drafted, that is too restrictive. And I have a number of points to make in response. The first of those is that the hierarchy that applies there does allow for compensation, and compensation is quite broad. If the hierarchy there started offsetting, that's quite a high hurdle. Compensation, there's a lot more ways to achieve that. Where Eco P6 is being applied to biodiversity, which is not caught by the significance criteria, then by definition, that development site or whatever it is going to have a lower level of biodiversity value. So it still has values, but they're not triggering the significance criteria. That is going to make offsetting or compensating for effects on those values more achievable than if it had a higher level of values. But I would also note, and I don't know if it was today, I think it might have been earlier, was reference to case law around that, not capturing sort of minor transitory, don't quote me on the wording, sorry, I don't have it at my fingertips, effects. And I would agree that cascade, particularly when you get into the offsetting and compensation, if effects are sufficiently short-lived, minor, that it's not necessary to fully offset or compensate for them. So I don't think it in practice is going to be as strict for non-significant triggering biodiversity as some parties have raised concerns about. Relatively simple one, just for the record. Eco 01, there was a question about adding the term ecosystem to that. So I target is ecosystems and Indigenous biodiversity. Just for the record, I support that. I think that would add some useful benefit to the drafting. And also, sorry, just towards the end of Ms. Mealy's session, there was discussion about, particularly for 104.1ab and the use of offsetting and compensation, who the decision maker should be. And from my experience in those sorts of arrangements, it really needs a technical person to assess a proposal against the offsetting and compensation criteria. And particularly where you have got through either national direction or the RPS specific criteria for it to be assessed against. But then the overall application does come back to the decision maker. So the decision maker then says, well, these effects have been fully offset in compliance with the relevant criteria. I can largely just ignore that effect. These effects have been compensated. There are remaining effects. I need to weigh them up in the round. Are we still allowed to use that term? They need to be weighed up as part of the decision. And similarly, if there were measures that were outside specified criteria, but were still being provided under the broader provisions of 104.1ab, that's very much something that sits with the decision maker to say, look, we're losing some tussock, but they're giving some money to the local community hall. How much weight do I want to give to that? And the technical matters essentially need to be dealt with by the technical people, but then the decision of what that means through 104 sits with the decision maker. That's the matters where I had oral responses to. Thank you for your patience. And with that, I'm happy to answer any further questions.
Thank you, Mr. Bryce. Very succinct and helpful. Thank you.
Yeah, thank you. And your bits at the end have actually covered off some of the questions that I had too. So that was helpful. One of the things I know Ms. Mealy has suggested some elements of appendices 3 and 4 be placed within a policy. And you've said that you consider that EcoP6 would be an appropriate place for that at paragraph 169. Do you have any drafting suggestions for that? Or is that something you've turned your mind to?
I've turned my mind in general, but I haven't at this stage taken it through to drafting. If that would be useful for the panel, I'd be happy to do that.
I mean, I think it would probably be useful to just sort of see what you're thinking with that. I found your comments in paragraphs 3 and 4 of your speaking notes to be quite interesting. I think a lot of the focus has been on avoid being at the bottom of the, I suppose, the cascade in appendices 3 and 4, whereas you are making the point there that particularly with compensation, there is the possibility that at the end of that it may still not stack up against the provisions of the plan. I thought that was quite an interesting point that we haven't had before, and there may be some listening to that. In relation to your paragraph 168, and subsection 1 of Eco P6, we've had some people, well, several requests that rather than avoid adverse effects as a first priority, it's changed to avoid adverse effects where practical. And I think that does reflect the effects management hierarchy that we've seen in MPSs as well. Do you have any comment on that?
I think in operation, they're probably going to work similarly. Where practicable is a reasonably high test. So if it's available, it is going to be applied. I think that probably has a similar effect to saying you did it as first priority. My personal preference is the as a first priority wording. I just think that's a little bit clearer about how it operates as a hierarchy.
No, I think that's all I've got in here. Thank you.
Thank you, Mr. Brass. I'm not sure your further discussion on Eco P6 and maintenance versus SNAs clarified too much for me, because and I guess it all gets back to what maintenance means in the context of Indigenous biodiversity, because biodiversity, it's defined in a certain way, like variability and diversity amongst species, which doesn't mean you have to keep all of those. You just have to make sure you have a range of those things. So it doesn't, but the way P6 operates, if you do have a small farm, like for example, if someone is cultivating a paddock and putting irrigation on it, that's quite a stringent and erroneous not erroneous, onerous cascade to go through. You see, compensation, etc., will be available in those cases. But if you're just removing the odd Indigenous biodiversity, it might be Matagari or Kanuka or something in a gully, it's still, this kicks in. I'm still not convinced. I just wanted to do you have any comment around that? How it applies, given the definition of biological diversity? Because it really, the way this plan is, policy statement is working, is where you touch any Indigenous vegetation, you're into that process. And it's quite significant.
It just triggered a question in my mind, sorry, which is about the interaction of Eco P5 and Eco P6. And I think Eco P5, which recognises existing activities, goes some way to answering your question.
I've had questions around it too, so I'm
yeah.
not sure if it does either, but anyway.
Sorry, it's just, and all I'm going to do is pose the question because I don't have an answer, is Eco P5 is clear within significant natural areas. Is there an Eco P5 equivalent outside significant natural areas?
I would have thought section 10 was the one.
I'm thinking about whether eco, so the situation that Commissioner Cubitt has referred to, that may well be something that is an existing activity. And he's concerned about Eco P6 capturing it. And I'm just wondering about something that's captured by Eco P6. If it's an existing activity outside a significant natural area, yeah, you may be correct in that.
The classic example was Queenstown with irrigating existing pasture, which is combination of exotic and indigenous. And I think the Queenstown plan set up such a way where something that triggers a consent because you're modifying indigenous vegetation.
If the irrigation is changing as opposed to maintaining.
Yeah. Yeah, so it's not an existing activity as such. In relation to in paragraph 12 in your supplementary there, you talk about, I think, the mix. That's sort of in contradiction to the legal submissions of Ms. Warner about pick and mix not being appropriate, I think.
No, I think there's an important distinction there, and that pick and mix implies that you can pick, which you apply. The situation I'm referring to is where that cascade still applies, but that cascade will operate differently across different types of effects, different parts of a large site, so that, and this is the example with experience that we've had with Oceana Gold, for example, where across the range of the things that were happening, there were some things that they were able to offset, some things that they weren't able to offset, but they could get quite close, so they would miss one criteria but do everything they could in terms of the other criteria. Some other elements where they completely couldn't offset, and they took a compensation approach. So across the total development, you saw a range of things, but they were arrived at as a result of that cascade, as opposed to being, if you like, a freely available, choose what you want.
Yeah, well, that's how I understood the evidence, but I thought the suggestion in 26 was that it wasn't how they were putting it. That's my confusion. Sorry. The only other thing was in your paragraph 4, you talk about the role of offsetting of Dr. Keesing's view. And he used an example of avoiding an area, and therefore there was going to be no benefit to ecological benefit because there was going to be no enhancement of that particular area. And there have been submissions saying the RP should make some recognition or promote additional development rights, if you like, in exchange for that sort of work, which actually happens all the time now in consenting processes, I think. And I think you touched on that. Do you think that should be explicitly recognised in the RPS?
As you say, it's something that people are doing already, and that can be right down to the scale of a 2-lot rural residential discretionary subdivision, where some indigenous vegetation restoration is part of the overall mix. So I support that being used. I'm not sure whether it needs to be reflected in the RPS in the sense that it's available anyway. And I think and I guess a little bit similar to my views on the RPS, setting up a framework that will lead to district and regional plans providing for restoration, conservation activities, fencing, etc. I think it falls into the same category as that. It's not so much that it needs to be highlighted in itself, but you do want to make sure that the overall package of provisions that you've got in the RPS will support or lead to the lower order plans reflecting that.
Because quite often the biodiversity is not affected by this activity, but they use it as here's a positive with their proposal, which is in line with Objective 2 of this. No, apart from that, your evidence as usual was very clear and well thought out, so thank you for that.
Yeah, Mr. Brass, I just want to refer to your support for this new method, 7A. It's been, and I wondered whether the department or you personally had any examples of ways in which this sort of stuff is actually done. I mean, M7 just talks about using Mātauranga Māori methodology and aligning that with science monitoring methodology to do that. Are you aware of any actual existing programs that use that approach?
Nothing that I'm aware of, if you like, wearing my official hat, just from my personal capacity and keeping in touch with the news. There are cases where Mātauranga Māori is being used in pest control within lakes. I think that was using mats woven from, I'm not sure what they were woven from. Also similarly, trapping methods being used in freshwater management, monitoring of fish species, those sorts of things. So yes, there certainly is stuff that's happening on the ground. Not my area of expertise, but I've seen enough of it to know that it's happening.
And it's working.
And it's working.
Yeah.
And I guess probably my key point is that I don't see that as just about reflecting the parts of the Act that relate to Māori values. I also see that as a way of more effectively meeting particularly 6C in terms of the biodiversity values.
No, I agree with you there. I mean, there was some talk about this when I was at Lanka Research years ago, how you might better align some of this kind of monitoring, and I must say I've lost sight of how some of these things are being undertaken. I mean, it's neat that it's being supported in the context of this RPS, but I'm always curious about how you then put that into practice.
Commissioner, Dr. Richardson has some good examples, I think.
Yes, so for example, in freshwater monitoring, some iwi hapu have developed cultural health monitoring indices.
Yeah, I'm aware of those.
Yeah, so, and those are routinely used. They are more holistic than the frame of indigenous biodiversity only because they also encompass usage and reflect values and aspirations and how current states are answering to those aspirations and values. But yeah, so there are examples of this happening. And what's really interesting is that they're site-based and site-specific. So yeah.
I mean, it's challenging, but it's a good challenge, I think. It's a really, it's kind of at the heart of where this RPS is going as well. I mean, this kind of, partnership, participation, whatever the word is a key overall consideration, I think. And this is just, for me at least, it's one example of how this sort of partnership thing can be put into practice. And I'm really looking forward to seeing how it then pans out once it gets, the big tick or whatever it is. Yeah. Thanks. That's what I had. Thank you.
You answered in advance most of my questions, so I've only got two left, really. The first is hopefully a smaller one, because, well, I hope it's smaller, if I read you correctly, or noted you correctly. But just in terms of the effects cascade, when you got down to the offsetting and compensation, if I noted you correctly, you had an attitude that was likely to be addressing matters, the residual adverse effects other than minor, and that's been dealt with in the MPSFM by using the words which a lot of the submitters have asked us to incorporate of a phrase more than minor residual adverse effects. So do I take it from your response that you would be comfortable with that change?
Yes.
Yeah. Right. Okay. So that was number one. Number two is a bit more tricky, really. It's sort of the crunch question in terms of this offsetting issue. On the one hand, we've really got the Mr. McKinley's. I'm not saying you're at the end of the spectrum, Mr. McKinley, but we've got the, if I put it this way, we've got a body of evidence from ecologists who agree with the proposition really that Mr. McKinley's put today, that you've got certain Indigenous biodiversity that really, if you possibly can, you shouldn't touch, all right? If I put it that way, avoid terms. And, you know, that's persuasive, very persuasive evidence. And at the other end of the spectrum, we've got people saying, look, we need to be able to have a definite consent pathway. And the description you've given to us is essentially, as I was listening to you and noting it, it's essentially saying that there needs to be a technical person. Presumably that's almost certainly going to be handed off to a technical consultant to do a Section 42A report and come back. But the public, the infrastructure public, the telecoms, the whatever, and the miners don't have confidence in that, because what they're, I imagine, thinking is that they're going to put in their offset proposal, and before it even gets to a Section 42A officer, some officer in the council is going to be saying, no, it doesn't comply with this, and so we're not even going because you don't comply, and it's not available in terms of the plan, which has to comply with the RPS. It'll be said to be not available. If we would use the wording that was along the words that a decision maker considering any offset or mitigation proposal shall have particular regard to the importance of avoiding effects on, and then all of the clause 1 parts of Appendix 3 and Appendix 4, does that not ensure that the infrastructure submitters have the confidence of knowing that there's within the RPS and within the district plans, there will be a consent pathway that can't be blocked at officer level, and yet at the same time recognises the concerns that Mr. McKinley's and the other ecologists have got, that there are certain aspects of ecology to which there has to be particular regard if you're going to be putting up an offset proposal, and that in regarding those, you've got to have regard to the importance of trying to avoid effects on. Is that an approach, do you think, that you could live with?
My preference would be for those gateway elements to operate as criteria, as reasonably hard gateways, as opposed to allowing a discretion subsequently to the decision maker. But against that, because I think it is important to get those gateways right. And that's where, in particular, the Director General's submission, and from my experience, I fully support, would see the removal of particularly the loss of individuals, divisions from those gateways. And certainly from my knowledge of things that have been a real concern for those developer interests, is it's what level those gateways are set at. So I would rather have clear gateways, because there are, particularly if you're talking about threatened species, for example, they're at a stage where death by 1,000 cuts really will lead to loss of those species. In Otago, we've certainly got fish, if I can refer to fish in this area, but also lizards and plants that are within that they're at that level of threat. So my preference would be that you do have a firm gateway, but as I say, that we set that gateway at the right level.
I want to thank all of the those who've given evidence and for Doc, you've got a hard road to hoe always, because you're cast as the devil and you're not, and you all know you're not, and our sympathies are very much that way too. But we have to listen to reasonable concerns about how, in a practical way, this act can be made to work, particularly when you've got a background of a net carbon zero looming, where in reality infrastructure has to be put in place, and hopefully for the better good. So it's not easy for us, as Mr. Hewitt's been repetitively saying, and we just thank you very much for the effort and thought that's gone by everybody. Thank you. Thank you.